Hello, my fellow Alaskans. Thank you all for tuning in here this bright and beautiful Thursday morning. You guys are all probably just like me and snowed in, unable to get out of your driveway once again. Yes, that is the case. We are snowed back in again. We've got a little over a foot out here in the Mat-Su Valley, at least in where I am located at. The Palmer Courthouse has closed for the day, and the court case is going to be held virtually. So far, we have heard from the prosecution's witnesses their expert testimony paid for to give their spin narrative of what is going to happen, kind of like the January 6th committee was. And this is where we're currently standing at right now. We had John Lewis was the first one that gave testimony, and then we had Matt Kreiner yesterday. Lots of hearsay, lots of opinions, lots of this is what we believe, assumptions, you name it. That's pretty much what the case has been all built on currently at this point in time. They are all popping in on the Zoom screen right now. The judge has just taken the bench there. They are just about ready to begin. Get your popcorn popped. Get your shot glasses filled up. Going to be one hell of a show. Yes, David Eastman is on the stand this morning. He is the first right off the bat that will be participating in this. And so get ready. He is the key witness being interrogated today. Questioned today. And then they will move right on from there on determining on whether or not this case is going to move forward, or they're going to continue to bring witnesses in. And they, from what I understand, have about 40 of them for the defense versus their two expert witnesses that they brought in that are all part of think tank type university left-wing opinionated. We give you our theories on what we think is true to be right and factual. Again, thank you guys all for being here today. You can find this video right now on Twitter, YouTube, Facebook at Politadick and Politadick Unfiltered, and within the next 6 hours or so it should migrate over to Rumble. And here within a day or so our website will be back up and running where you would normally be able to find this video streaming live right now, which is at Politadick.com. As soon as the website is back up and running, please go there. Also, click the support button to help us grow. As soon as the site is back up and running, the support page will be back up there too. Thank you guys all for being here today. They have begun.
That way. But if I put it you want to I can try to patch Mr. Miller in. Thank you. Mr. Miller, is it that you can't hear us?
Yeah, I've got a hearing deficiency, and so in order for me to hear with proper volume, I have to have my Bluetooth headset in, and the phone allows me to do that.
Unfortunately, you're welcome to call into Zoom, but if I split the lines and I try to put you on our conference line, it's going to create a problem with the audio. And there
okay,
are
let me try to call in on the Zoom here. I think I've got the number. It looks like there are two different numbers. Okay, let me try that. Give me just a second.
Okay.
Enter your meeting ID followed by pound. Enter your participant ID followed by pound. Otherwise, just press pound. Please enter the meeting password followed by pound. You are in the meeting now. There are 10 participants in the meeting. You have been added to the waiting room.
Miller, can you hear us? Please hear me.
Yeah, yes, I can hear you. Thank you.
All right, Mr. Miller, it sounded like there was a little bit of echo. Let's just see if we're getting you through clearly.
I can hear you, Judge. I've muted out my laptop and also the speaker, so hopefully that will eliminate the feedback.
It sounds pretty good. Your video is just a little shaky, but the audio sounds fine.
Good.
I appreciate everyone's flexibility again with the court closure today and the need to move online. It might require us to just be a little bit more deliberate with some of the delays, and there is still a little bit of an echo, so we'll just try and move slowly, deliberately, but we still hopefully can continue on with the evidence in the case and moving forward. When we broke yesterday, Representative Eastman was on the stand. Mr. Dedukian had reached a point where it was potential to move on to cross-examination, but he had reserved for a bit in order to determine whether or not the questions that I asked yesterday had raised any new questions that he wanted to bring up. So before we move on with that, I just want to check with the parties if there's any other issues that we need to take up prior to Representative Eastman continuing with his testimony. Mr. Dedukian, anything from you?
Not at this time, Your Honor.
Mr. Miller?
I gave Mr. Dedukian a proposed list of witnesses today, assuming that we go forward with Mr. Eastman's case. One name that I did not include that I just found out 30 minutes ago may be on the list is Stuart Rhodes. He would be connected because he's incarcerated by phone, and it would be at 1 o'clock our time. It's going to be probably the only opportunity to hear from him if we can even get him on then. So what I would propose, Judge, is maybe at 12:55 or so. I think I don't want to presume the court's lunch break, but during the lunch break, I could try to make the connection so that we're ready to go at 1. We'll have maybe 30 minutes, so it's not going to be a lengthy period of time, but it's going to be the only opportunity. And if Your Honor thinks it's important to hear from him, I think it's probably going to happen.
That's helpful to know. Given the conversations that we've had about what's left from the plaintiff's case, it seems like we'll have moved into, if we're going forward with the defense case at that point, that'll be your time. We'll certainly if that's the time that your witness is available, I understand the challenges with getting people, if they're in Federal Bureau of Prison custody, on the line and into court. So we'll make every opportunity we can to make sure that we're available at the time that he might be.
Thank you.
Ms. Harrison, any other issues from the division to raise before we move forward?
None. Thank you, Your Honor.
All right, Mr. Dedukian, if you're ready and if Representative Eastman is on the line here, we can continue. Mr. Miller, is your client where he can be on a video?
He's connecting now.
All right, thank you. All right, Representative Eastman, can you hear us fine?
There's been a little bit of garbledness. I can hear you fine right now.
All right, let us know if at some point we drop out and we can just repeat, but it might just take some patience on everyone's part to get through. All right, Mr. Eastman, you're still under oath from yesterday. Mr. Dedukian, you may continue.
Thank you, Your Honor. Mr. Eastman, when you traveled to DC around January 6th of 2021, you wanted Congress to delay certifying the election, right?
I was asking my representatives to object to going forward and to hear the information that was being presented by the other members of Congress.
And so what you were asking your representatives to do was to delay certifying the election, right?
I wouldn't construe it as delaying. I think it's part of the normal process.
And the process that you wanted was for there to be audits and investigations of so-called fraud allegations before certification happened, right?
The process, as I understand it under federal law at the time, and I don't know that it's changed much since then, is that if a member of the House of Representatives and a member of the Senate both pledge an objection or a challenge, if you will, then members of Congress will go into deliberations and will review the objection and then we'll vote on it accordingly.
And at the time you had written in that Trump lost and Jeffrey Epstein killed himself article that the election process was abused to such a degree that it could no longer be called an election, right?
Correct.
And you wrote Congress should not certify the winner.
I'd have to go back and review what I wrote.
Okay. I can just read you a couple of sentences from it and you can tell me if it rings a bell. You wrote, tomorrow, Congress is scheduled to count the votes and certify the winner of the presidential election. They should not do so. You remember writing that?
I have to go back and review specifically.
Okay. And also at the time you went to DC, you knew because of the email we talked about, the call to action we talked about yesterday, that Oath Keepers had been called into Washington, DC for certification of the election, correct?
I knew that there was going to be Oath Keepers in Washington, D.C. For the different events that were taking place there.
Right. And you knew that Rhodes had said all patriots who can get to DC need to be in DC, right?
I believe so.
And you knew from that email that there was going to be a well-armed and equipped QRF teams on standby.
No, I don't remember reading about that, no.
Well, can you turn to exhibit, give me 1 second. Exhibit 14. And it said,
exhibit.
You have their exhibits. Yeah, they're my judge. I'm trying to make sure that we can get them the exhibit.
Understood. Let us know when
you
you
have my computer.
We might be able to pull.
Yeah, so
But it sounds like and I think I did remember seeing the binders sitting on defense counsel table when we cleared out last night. So
I can try to share it. Last time it didn't work. I'm going to try right now and see if I can get it to work. It's wanting me to quit Zoom and I don't want to risk doing that. So I'm just going to read from it if that's okay with the court.
it is.
So Mr. Eastman, I'm going to represent to you that a DC 305, which is your Bates number on Exhibit 14 in the call to action from Rhodes. It said, quote, as we have done on all recent DC ops, we will also have well-armed and equipped QRF teams on standby outside DC in the event of a worst-case scenario.
Mr. Miller, are you able to hear us?
Sorry about that, Judge. Can you hear me now?
I can hear you now, yes. Your client, we don't have any.
If you could mute Representative Eastman. Okay, so the objection is this, Judge. What was just read from the exhibit, I have it digitally and I can print it out for my client, is just a portion of the sentence. So it's out of context. I think if he's going to read this, particularly with the exhibit not in front of my client, he needs to read the entire sentence.
That's sustained. Mr. Dukin, we can have you read the entire sentence there for completeness.
I'm happy to do so, Judge.
And I just want to also, before you go on, Mr. Miller, is your we can't see your client and he's muted, it looks like. So I just want to make sure he's hearing it and that he's part of the.
Right. So, Judge, in order, because of all the feedback problems, he's shutting down his end when I object. Otherwise, we get all these feedback loops and it creates all sorts of problems for the court and for us.
Wanted to make sure that everyone where you're at, both you and your client, can hear while Mr. Dudukian's reading. If we need to take an extra second so that you guys can pass over, because it sounds like it's a limited bandwidth issue as well as both an issue with a feedback from where you guys are at, that if we need to pass back and forth, that's fine. Just let us know when you're doing it.
Right. And part of the problem, Your Honor, and I apologize for this, is that we had an alternative location, but there was so much snow here today that my client barely even got to my location at the time that this started. So, and drives have not been cleared and roads have not been cleared. And so we have to deal with what we have and we're doing the best we can.
I appreciate that. Mr. Dudukian. You had a point.
Yes, Your Honor. I understand about the feedback loop, but I would like Representative
And at the time that happens, it may give us, we may have to go down to 5 minutes or so. Would Your Honor give us that time? And that probably will eliminate this problem that we're having here, at least with the video. And I don't think the audio is necessarily going to be cured because I think that may be independent of the bandwidth. But I think if you're okay with that, Judge, if you could suffer a 5-minute break when they actually go to increase that bandwidth, that probably would be the best approach for the efficiency of the court.
Is that something they could take care of before 9:30?
Let me check. Judge, I don't know. I can't get an answer to that. So I think we just ought to proceed. And if I get an indicator that they're able to do it, I'll just ask permission before they do.
Right. thank you for that. And I take Mr. Dedukian's point that if at all possible, can we keep your client at least on the video while he's testifying?
But yeah, I think that is the intent.
Right. All right, we got about
Per your request. So you were aware at the time that there were going to be well-armed QRF teams nearby, correct?
I was aware of that email. I did read it.
Okay, and you were also aware that Rhodes had told the recipients of the email to prepare your mind, body, and spirit for battle.
I don't remember that specifically, no.
Well, I will represent to you, since you don't have a copy of it in front of you, that it's on DCE 305, below the click where you would pay money to the Oath Keepers. There's a sentence that starts, quote, prepare your mind, body, and spirit for battle, and above all else, prepare to stand. Okay, so that was in the email too. And you were one of the patriots who responded to the call to action, right?
No.
Well, you ended up in Washington, D.C. on January 6th, and you were within a quarter mile of the Capitol building, right?
Hold on, I can't hear you.
You, on January 6th, you went...
Hold on, Mr. Dedukian, it sounds like Mr. Miller's trying to raise an objection.
And Judge, I also just printed out the exhibit for my client, so he's looking at it right now. But I would object. I mean, this is misconstruing the evidence that's before the court. The testimony that has been given is that Representative Eastman was already in travel. In fact, was in D.C. when this email was received. So what's trying to be presented by this presentation is that he received the email and then went to Washington, D.C. Mr. Dedukian knows by the discovery that has been produced and by the testimony that's been given in this case that that is not the sequence of events. This email was received after purchase of tickets and after travel to Washington, D.C.
Mr. Miller, I'm not hearing an evidentiary objection or an objection to the question. That those are subjects that you can bring out on cross-examination with your client. It's a disagreement with the amount, but he's not characterizing his testimony. He's asking him a question about why he went. If there's additional information that he needs to present, you can bring that out on cross-examination. That's fair for you to respond to the direct. But as far as the question goes, it's a fine question, and Representative Eastman's answer is what it is.
And Your Honor, I'm going to object again to the talking objections continuing. And I mean, again, a 5-minute essentially testifying to the court about the facts, and I will continue to object to that.
Yeah, let's continue with the questions.
Judge, if I may, I mean,
Mr. Miller, let's keep moving. I understand the point. You're raising an objection. I've overruled it. We're going to move on.
All right. So, Mr. Eastman, on January 6th, you were at the Grant Memorial, right?
I was, yes.
And that's within a quarter mile of the Capitol building. Right?
I don't know what the distance is. No, I'd have to look at a map.
Okay, well, we're going to ask the court to take judicial notice of that a little bit later. I will represent to you that on Google Maps, it shows it as a 0.2 mile distance from the Grant Memorial to the Capitol building. And that was right on the edge of the restricted Capitol grounds, right? Right?
I don't know what the restricted grounds you're talking about are.
And you stayed there near the Capitol until the curfew was issued in Washington, D.C. Right?
I'm sorry, you're cutting out. I can't quite understand what you're saying.
You stayed near the Capitol building on January 6th until the curfew was issued by the District of Columbia, correct?
I don't recall exactly when the curfew came out. I remember there was a text message, I think, that came out about that.
Right, sir, but you got to listen to my question. I said you were there until the curfew was issued. I didn't ask you what time it was issued, but you were there until the curfew was issued, right?
Yeah, I don't remember where the curfew came into events.
Okay, you went there, you were at the rally at the Ellipse before you went to the Capitol, right?
Before I went to the Grant Memorial, yes.
Okay, so you were at the rally at the Ellipse and then you made your way.
Saying anything? I can't hear anything.
I'm sorry, did somebody say they couldn't hear me?
It sounded like Representative
Yeah, so-
Eastman said he couldn't hear you. What I'm going to suggest we do,
So
there's a fair amount of interruptions just because of the bandwidth issue. Mr. Miller, is what I'm going to do is we'll take a break until where you're at, they can give us, tell us whether they can increase the bandwidth where you're staying. Do you have a time frame for when that might be?
I just tried to find out when I took a brief break a few minutes ago and wasn't able to, but if maybe we could go back on in about 5 minutes, I should be able to make a call and find out. There may also be an option that is based upon whether or not roads have been cleared where we can get to the other location that we had arranged. But I will check both of those options out, Judge. The problem is that, and I can hear this coming through Representative Eastman's feed, he's hearing Mr. Dedukian probably a good 2 seconds after I hear it on the phone line. And so there's a huge lag. And I can also hear out of my uncovered ear that a lot of the audio that Representative Eastman is getting from Mr. Dedukian is broken. So I think we do need to try to establish a better connection. We know that we have the potential option of expanding bandwidth. So let me check that. And let me also check on the road status to the other location that we had arranged. And maybe we can reconvene here in about 5 minutes.
Let's take 10. Let's give you a little bit more time. Just everything takes a little bit longer than we usually expect. That always applies to me. So let's say 9:40. We'll come back on.
All right. Thank you, Judge.
All right, stand in recess.
Hi, my fellow Alaskans. Good to see you guys all here once again. They currently are taking a break away. They are having bandwidth problems, unable to hear each other properly. The attorney for the prosecution is currently trying to question David Eastman, and David Eastman is, from what I'm understanding, not able to hear him. The last question there that was being asked of Eastman was, did he leave when the curfew was issued? David Eastman's confused because he's not sure, because he doesn't know what time the time it was supposed to be for that curfew to have been happening at. And the attorney is missing that, and I heard Eastman bring that up several times. Put in a time frame. Give me some time. Tell me when are these events that you're trying to make me say yes or no to actually occur. And until the prosecutor gets off the ball and actually does their job and actually starts asking a real question, maybe they'll be able to move on with this case. So, sum up the last couple of days, the first person that they brought up onto the stand his name was John Lewis. and he's from out of state, belongs to a university think tank, so to speak. It's the best way to describe both of the witnesses that we have here. I'll just label them all as being part of think tanks. I believe both of them, I know Kreiner did, Matt Kreiner, who was the second person, John Lewis was the first. Matt Kreiner and have testified in front of the Alaska Ledge down there in Juneau last year, or this year, depends on how you look at last session, not the upcoming session. And they gave their expert opinions, assumptions, theories, whatever you would like to classify it. They are supposed to be the experts on everything extremism, and everything they focus on is 100% what you would classify as the far right. And the John Lewis and Matt Kreiner are supposed to be experts on the Oath Keepers and the extremism of the group. Now, they're trying to label the Oath Keepers as an extremist organizations for the actions of basically 33 or approximately people that are under charges right now for January 6th at the Capitol, or the 60 plus that I believe that was involved in that at the time, out of 38,000 members that are a part of this organization. They're trying to label it that those 33 people that are under charges right now, their actions are the responsibility of all 38,000 members, and the rest of those people are all guilty by association for all belonging to the same group. And that's the type of this is the narrative that they're spinning out there of where David Eastman stands at with this case currently at the moment. They will be coming back on live at 9:40. So don't hesitate. If you got something to do right now, go get it done. They're going to come back at 9:40. Hopefully they have all their bandwidth problems cured and they can move on with this case. Sitting in the courtroom yesterday was definitely a real experience being involved in this case. As you all know, I was snowed in, kind of like the same reason why they closed the courthouse again today. It's snowed in. They can't do it any other way but virtually. And when they tried to do this on Monday, they had the same problem, bandwidth problems, and they weren't able to do anything other than just say, we're going to meet tomorrow, which was on Tuesday. And they still was pretty much virtual for several of the people. Some of them were sitting in the courthouse, but not. And then the following day, of course, I was there, and then here we are again, another snow day. The Palmer Courthouse announced that they were being closed down. Back to the case. So the expert witnesses, Lewis and Kreiner, they gave their opinions about what happened on January 6th and upcoming to, and what has occurred after the fact for as indictment and charges and things like that, impending charges, impending convictions. And they're trying to paint this picture that you are guilty by association, that if you belong to any organization that has members within it that are within the leadership roles, whether you're active or not, you are guilty by association by being no more than just having your name on the membership roll. And because of that, anything they do, you are now guilty of. And that's what the scenario that they're trying to tell us the last 2 days has been all about. Guilt by association. Whether you are involved directly or not does not matter to them. And in this case, David Eastman was not involved one bit. In fact, he openly admitted on the stand yesterday that it's been several years since he's had any contact with them. And that should really tell you what's going on. All the emails and stuff that they've had that came to David Eastman, there's only a couple of them, and they were provided by David Eastman to them, not responded to or anything else like that. There were a mass mail out that was sent to everybody that was on the membership roll, and if their email was still active, they received this email in their inbox. How much junk mail do you guys receive in your email boxes every single day? I know I receive a hell of a lot. I delete about 100 messages a day, emails that come through, just because they're nothing more than spam junk mail that just never ending, continues to grow. The longer you have your email, the more junk mail you'll end up receiving. So their case 100% has been based upon people's opinions. theories. If you watch the January 6th committee hearings that they had for what happened and we're going to indict Trump, here's the smoking gun, it was all cut and snip scenarios that they picked and chose what they wanted us to see. They purposely cut out the remaining parts of speeches just so you didn't hear it, because it went against the narrative that they were trying to spin. And that's the same thing I see going on here right now. They're trying to paint a narrative that you are to believe just because he was in D.C. on January 6th that he is responsible for those idiots, those morons, the stupid, who knows, I could keep on going on down the list of every adjective out there that you could think of to label those people that broke into the Capitol that day. Anybody that condones that actions, I feel sorry for you. But when you, and I'm going to label this right now, but if you're on another side of the fence like the Democrats and you destroy buildings, you break into the Capitol, you take over the Capitol floor while it's in the middle of a hearing of a bill, which has happened multiple times on the left, they never called that an insurrection or trying to take over our country. When they were banging on the Capitol doors on the outside of the walls, none of that was a problem. When they burned down the church across the across the street, that was not a problem. As they burned down police stations, Molotov cocktails, businesses, none of that was a problem. But this is all they ever want to focus on. This is all that was ever done. It was only January 6th. None of that other stuff exists, because that's the narrative they're trying to paint here. Ignore what others have done. It's only what these 38 people did, and they're making guilt by association to everybody else. We have been seeing it since day one, since the election results came in, and after January 6th. If you are a conservative or you have an R by your name and are a Republican, you are vilified and you are guilty by association for being no more than being a part of a group. Same thing that they're doing to David Eastman here. As a conservative, if you got an R by your name, you are a Republican. You are literally the scourge of the nation. You are the ones that got to be vilified on every turn. How dare you have an R by your name? How dare you be a Republican? You, every single one of you, every single one of us that calls ourselves conservatives are guilty by association. All the crimes ever committed by those that sit with an R by their name, you are vilified and are guilty by association. And that is exactly what they're doing to David Eastman right now when it comes to this case currently. Let me just do a little quick, bring my screen capture back up here on the screen, make sure I can see what's going on there in the courthouse, because they're just about ready to come back up on again. But that's where we're standing at. I mean, you're guilty by association. You belong to a group. You got a label by your name. And anything someone, the minority, the fringe few, we're talking less than 1%. It's like a 0.001% of the actual oath keepers that are there that committed this atrocity. And they're blaming everybody for that. And that's what they're doing here with David Eastman. This is made up of our military, our first responders, our veterans. These are who are the oath keepers. And they are just carrying on the tradition of carrying on the oath that they take when they have taken the positions that they have held or may still currently be holding. Think about that. Every legislator we have, every council member, every assembly member has to take an oath. So are we now to say that because somebody there made a action or did something, that one person, a part of that assembly, now all the rest of the assembly members are guilty by association because they all took the oath to withhold and preserve against what that one person did? Well, that's exactly what's happening here. And our choices of what happens in our elections, our voices and our votes matter. And they're taking it away with this lawsuit right here. Our voices and votes don't matter. David Eastman won resoundingly in this current election. He is the House representative for that district. And this person, who's not even in David Eastman's district, brought this lawsuit forward saying you cannot be the next House representative until the courts decide if you were elected or not. Not the constituents who voted for David Eastman. No, their voices and votes don't matter. It's all in the hands of a judge trying to dictate the actions of one person, or in this case, the 33 that they have indictments going against right now down there in D.C. for the January 6th. This is currently where it all stands at and kind of what it looks like, and it's just not changing. We Alaskans need to be standing up and vocally speaking out about this. I've seen the articles, the Beacon, the ADN, the Alaska News Source, the NPR, and everybody else has been putting out about yesterday's trial. I was in the room. They really focused on less than a couple of minutes of testimony given by David Eastman himself. They completely ignored all of the cross-examination and examination of the expert witnesses that they had brought in. They barely touched upon how they were decimated on the stand, more than once brought out to admit the involvement of others that showed a conspiracy that was more on a government level, in my opinion, than what it was on a personal level. Looks like they're getting started. I'm going to shut up so that I'm not talking over them.
Can you hear us fine?
I can, Judge, although I'm going to need to put my earphones in before we get too far. It's my understanding that MTA is tripling the bandwidth within 30 minutes. And
unfortunately, Mr. Miller, we did lose you again right after MTA is tripling the bandwidth. Mr. Miller, are you able to hear us? All right, looks like we've lost Mr. Miller from the Zoom. We're just going to break in place until we get him back on. It seems like it's worth waiting, given the state of the record that we've got, until at least about, probably for the other parties, wait until about 10:30 to give a chance for the bandwidth to hopefully increase where Mr. Miller's at, but we'll address that once he's back on. All right, we've tried to reach out to Mr. Miller by email just to let him know to call into the Zoom. It doesn't seem worthwhile to keep the other parties here waiting around on the Zoom and on record until he gets through. It sounds like there's just connection issues. What I heard him say is that it would be about 30 minutes until they could get a bandwidth increase. The state of the record with the connection issues with him, it just didn't seem like it was worth continuing the testimony as it is. So at this point, we're going to stand in recess until 10:30 until he can join back in. Hopefully, at least we can get him back on the Zoom at that point or address scheduling issues with keeping things moving. But the testimony it was a tough record to go through. So at this point, we're going to stand in recess until 10:30. Please be available at that point. Thank you very much, everyone. You can go off record.
Your Honor, while we're all still here, IT has looked and checked with MTA, who is our Valley service provider. They're having issues throughout the Valley. There is one other option, which is a landline option. We could all call into the L3 conference line. That may or may not be advisable or an option, but I figured I'd throw it out there while everybody was on the phone.
That's something, thank you, I appreciate that, Madam Clerk. That's something we should certainly discuss at 10:30. If it turns out there are continued connection issues, I do want to make it available. It sounds like the witness that the defense wants to have this afternoon is only available potentially at one time and would be by phone anyway. And so we might need to address, but we're getting into more substantive matters than I really want to take up without the other parties here. So it's just good everyone has that information to think about and then we can address it at 10:30. So thank you very much for bringing that up. Let's go off record at this point.
Get my microphone turned back on here. All right, so you guys all heard that, what's going on. They are having, as it's been since the beginning, connection issues trying to get this stream up and going so that they can resume the trial. Miller and Eastman are working on getting their bandwidth increased so that they'll quit having so many connection issues and hearing problems. Hopefully they're able to get that accomplished right away. And the court also just reported that MTA is reporting problems with their network right now. And several communities throughout the area are also having issues. Fortunately, it looks like I'm not one of those. So it's up to you. Give me a thumbs up in the screen for those that are watching right now if you want me to just keep this one up and going, or if you would like me to just restart again at 10:30. And it's your call at this point. We've only got a few people that are really watching right at this point in time. So just give me a thumbs up if you want me to just leave this stream up and running and leave it at that, or we restart again at 10:30 when they begin again. It's all up to you. I'm snowed in my driveway once again. I've got over a foot of snow. It is up over my bottom of my truck's door frame once again. Plow truck has been called. They said that they're one house away from being able to come to us next. So as soon as they get them plowed out, I'm plowed out. The big street grader just came down our road, down at the end of the road. I'm sure he put another berm at the end down there. So if you're like me, you're snowed in, you're trying to dig your vehicles out, or you've been at it for a long time. I already dug mine out this morning, at least around it. But that was as far as I got when I saw how deep it was, and then I checked the court's website and realized that they were not going to even be opening up the Palmer Courthouse. So that's when I started setting up for this live stream here today. Again, thank you guys all for tuning in. Make sure that you like, share, and subscribe. Click that notification bell so that you get notified. YouTube is doing the best right now for making sure people get notified when people go live. Facebook is picking and choosing the winners and losers of notifications for who goes live. So I'm not sure if any of you are receiving those notifications, but I'm seeing it in my daily feeds. I'm not being notified when my pages that I follow are going live. And I go to those pages, I'm going, well, This was live. Why didn't I give the notification? Oh, here's another one at a different place. It was live. They didn't give a notification. So that is what the trend is right now on Facebook. But YouTube, the ones that I am subscribed to there, I am having no problem getting a notification they have gone live. And so if you want to make sure that you know when we're live, that's the best place to do it at, is to subscribe to us on YouTube. Also, go to rumble.com. Rumble, I have noticed too, I'm subscribed to several people on there, and when they go live on Rumble, I get a notification almost instantly after they've gone live and able to watch their broadcast. And I'm on Rumble. You can find us at Politadick there on Rumble and subscribe to us there. Once we reach 100 followers, people that are subscribed to us on there at Rumble, we will be able to live stream to them directly. That is one of our goals we're trying to achieve right now, and you guys can make that happen. Go to rumble.com/Politadick, or just go to rumble.com, type in our name, Politadick, and subscribe to us there. Be greatly appreciated. The faster we reach that 100, the faster we will be live streaming directly to them and not having to wait 6 hours to 12 hours later for it to mitigate over to their platform. We're also working to try to get ourselves a solid connection onto NorthTube. I am all signed up. Our videos are supposed to be streaming there right now. Unfortunately, NorthTube, the last 3 or 4 that I've tried to do now, that will just not connect to NorthTube to do the live streams. Hopefully the programming there is mitigating over my live streams from YouTube onto NorthTube so that you're catching up on the current stuff, but it's not the same as streaming directly to it live so you can watch it there. That's another channel that we're working on, making sure that you can find all of our videos uncensored and uncut. Another place just like Rumble that you'll be able to go and watch the videos and not have to worry about YouTube or Facebook or Twitter putting a censorship or a banning on the video and completely removing it because it goes against some so-called claimed violation that they put into place, saying you gave some sort of misinformation like they recently did to 3 of my videos, and only one of them I was not able to get put back up onto YouTube again. And they claimed that there was election misinformation in there, and it was Scott Clayton and Rachel, I hate that, drawing a blank there, but they were 2 candidates that were running in the Mat-Su Valley for the elections here. Both of their elections involved ranked choice voting, and they were talking about their current elections and where they stood at and how ranked choice was going to play out, and that they were still in the running even though they weren't in the lead. Both of them had a chance in their 2 different districts to have won their race depending on how people ranked. And then that was also when the group for Honest Elections had given their very first presentation to the Mat-Su Valley for the ballot initiative to remove ranked choice voting. And for some reason, YouTube, they wouldn't point where in the video it hurt their community guidelines, but they banned it. And I demanded, and I asked them, please show me where in this video it hurts you. Where point to it, please. Point to the video where in the video it hurts you. That went against their community guidelines, and they refused to do it. They just outright said the whole thing was just misinformation, which this is being filmed or streamed directly from the Alaska School of Government. So the current case, get back on track here. We got Kowalke against David Eastman, and it has been a very interesting, fun-filled adventure that has been going on there in regards to this case so far. The prosecution has brought in their 2 expert witnesses. I believe they're the only witnesses that the prosecution has brought and is bringing forward in their case, trying to spin a narrative how the Oath Keepers are a violent extremist group that sole intention has been since day one to overtake our country and have their own perverse view on the Constitution and the oath that all of the first responders, our veterans, our military, everybody that has served in office, whether it be in government down to assembly to community council members that take an oath. If you take an oath to a group and a few bad apples do something wrong, the rest of you are all guilty by association. That is the narrative that is being spun right now, that if you belong to an organization, whether you are a participant in that organization or not just a card-carrying member. I mean, I'm a card-carrying member of AARP. Does that mean I support all of the actions of those that are in charge there? No, I'm just a card-carrying member. If they go out and decide to go and pull off their own insurrection at the Capitol, so to speak, is every AARP card-carrying member now going to be guilty by association just because they belong to that group? That's what they're trying to tell us. That's what they're trying to convince us, that David Eastman, just because he's a card-carrying member of this group, he's guilty by association, and because he's a part of this group, he's going to, he wants to overthrow our country and our Alaska Constitution, the Red Scare laws that were put into our Constitution. That's how far back, and if you don't know what the Red Scare is, look it up, Google it, and maybe you might find out a little bit of knowledge that you've always wanted to know, but or maybe didn't want to know. But that is when those laws were put into place, and they're trying to apply something that has never been tried ever before in the state of Alaska and use that obscure law that against David Eastman. And if they succeed here, where does it stop? Seriously. I mean, look at it already. Since the 2020 election has ended, we have over and over and over again heard the Democrat Party come out and say anybody with an R by their name, anybody that voted for President Trump that has conservative values, anybody that did that, you guys are all of us are a co-conspirator to the overthrowing of our government, and we need to be censored and ostracized out of society. That is the mentality of what I hear being drummed into our heads by mainstream media on a daily basis. But when the Democrats get put on the line for their own rhetoric and everything else, we're told oh no, you got it all wrong. You're taking it out of context. The context is not right. Yet all they did was just read back what the words that person had said to them, and now just reading that is out of context. You don't understand. I did not mean for them to go and attack and go after those that are in the Supreme Court or those that are in the legislative body that supported this particular initiative. We didn't tell them to show up in mobs. We didn't tell them to go and make sure that their lives are a living hell, show up on their doorsteps. Excuse me, I should have brought my drink over here. It is one of those things that literally just needs to wake up and realize that if they're doing this to David Eastman, this has nothing to do whether you're a Republican or a Democrat. This has everything to do with our freedoms here in America. It doesn't matter what you label yourself. You should not be targeted because of your own personal liberties and beliefs or who you may or may not be a part of as an organization or group or idea. I don't say that they should be sponsored or promoted. It's not like I'm saying let's go out and make the KKK great again. I mean, the Democrats already did that. They just rebranded themselves as Antifa and Black Lives Matter. It just all depends on how you look at the labeling that and how it's been rebranded to match the different faces that they want you to see. Just like Antifa. I mean, please take a moment. Google right now. Take a second because we've got 25 more minutes before they get back here. In 25 more minutes, they're going to be coming back. And in that time, take a second, Google Antifa.com and click on the link that comes up. Guess what? Takes you to the White House. Isn't that amazing? You go to the White House. It takes you to the White House page. During the 2020 election, it took you to the Joe Biden donation page. Ironic, isn't it? How is it that that particular web address takes you directly to the White House. Antifa. Type it in. It's yet they are, that's not them. This is an organization that's just a name. They really don't exist. It's all in your imagination. It's all a conspiracy theory. FTX, cryptocurrency, all the money that was funneled into all the elections out there, and they say, oh, well, there was some Republicans that got some of that money too. Wait a minute here. Hundreds of millions went to the Democrat Party, and a couple million went to the Republicans. Unless, of course, you're talking like Senator Lisa Murkowski, who I understand profited greatly from the FTX redistribution of other people's monies in his Ponzi pyramid scheme that he had going on. Twitter files. When's the last time you looked at the Twitter files? I mean, come on now. They're coming out. The mainstream media is spinning those Twitter files as being nothing but a conspired narrative conspiracy theory. We already knew all of this stuff. We knew that the Democrats and FBI had direct, and those in Hollywood, direct access and backdoor to Twitter and the censorship that was going on. We knew this was all going on. There's nothing to see here. This was all okay. Censoring of everybody is all okay as long as it's the right people. Long as you censored the right people. If you censored the wrong people, well, then on the other hand, that completely changes the scenario out there. So I'm going to just leave the blank screen, so to speak, of them for the case that is currently in front of us, Kowalke versus Eastman, up on the screen. They are going to be back at 10:30. I was thinking about stopping this stream and restarting it, but I'm looking at the time and I'm hearing the plow truck may have just arrived out in my yard, and I need to go and point to them where they need to be and what they need to push. And so I don't want to miss the restart of this, so I'm just going to leave this running. Take a moment right now, please like and share this video. It is greatly appreciated. More Alaskans that get to see this, the easier it's going to be for us to make sure that Alaskans know what is being the next steps that they're taking, those that are working against we, the American people, what they're trying to attempt to do by bringing this particular case forward. They're making it so that you will be guilty by association, whether you are a participant or not. And if this case passes, that is what's on the line. You think David Eastman's just the first attack? Wake up. This is non-stop. We got McCabe, we got Hughes, we got Shower. They're all facing lawsuits out there of different sorts along the same kind of problem that is going on here. They're going after their own personal liberties one step at a time, trying to make sure that they can remove them from being able to participate in anything that has to do with our government and the future of our nation. And that's done on purpose because these people are not there to get along, to play along. They're there to get the job of the people that they represent done. And they don't want that. They want people there that will represent those that paid for their campaigns, funded for them to be there, and pass on all those hundreds of millions and billions of dollars back over to their special interest projects and organizations. That's the sole goal behind what this entire case is about right now. They want another mechanism to be able to remove those that are against the agenda they have in play. All right, I'm going to be quiet for now. Again, like, share, subscribe to us on Rumble and YouTube. Make sure you always get notified when we go live. We'll be back here at just before 10:30. I should be back in, and we'll see what happens from now to then.
on the line? Can you hear me?
Yes, I can hear you.
I can hear you.
All right, we're back on record. I can see Mr. Dedukian and Ms. Harrison here, both present. Mr. Miller, can you hear us?
I can, Judge. I'm just trying to connect my phone too, just for my hearing device.
You entered 3134. This meeting ID does not exist. Please re-enter your meeting.
Okay, Judge, the phone's connected. If I could have the clerk admit me.
Admit me.
Mr. Miller, do we have you on by phone?
I can hear you, Judge. Thank you.
And were you able to get the bandwidth increased where you're at, or what's the status on the connection?
We've been told, Judge, that it has been increased. It's impossible to test, but we've been told it's been tripled. So we've also been told that apparently there are some problems valley-wide with MTA, which is, of course, the primary internet service provider. But it does appear to be working on our side.
The video of you, at least, it's a lot smoother. It does seem like, I understand the phone connection issue, why we need to talk to you that way, but it seems like the video feed to you is good. Is your client able to get back on the video and by audio?
Yeah.
And Judge,
I think we'll still have an audio challenge because of the feedback, but the video should be okay.
And Judge, may I be heard on that?
Yes, Mr. Dedukian.
Your Honor, I would request that the cross-examination of Representative Eastman resume when we are back in court in person. First of all, he's the only in-person witness in this case, and it would be kind of odd to question him by Zoom when we could do him in person, unlike all of the other witnesses. And second, I think it's one of the key parts of our case, if not the most important part of our case. And I think based on the experience this morning and the fact that I can only see his face, we would strongly request allowance to question him or cross-examine him in person tomorrow or as soon as we possibly can. And we can take other witnesses today, but given the importance of this questioning to our case, we would like to do it in person.
All right, understood. Mr. Miller?
Well, I think you specified cross-examination. And so I'm getting a tremendous amount of feedback.
It's a little better now.
Okay. Can you mute? Okay. First of all, my client is a table away from me. I think that's probably the primary concern that opposing counsel has. I would estimate 8 feet or so. So although I can see him, he can see me, I can't pass notes to him. That's not going to happen. As an officer of the court, I'll represent that. The problem here is that, basically what opposing counsel is suggesting is something that should have been raised yesterday, not today. I made it very clear that at the close of his case, we would be moving this court, or we'd be making at least an oral motion to close the case. and I'm prepared for that. We may not even cross Representative Eastman. I suppose that would be a way to resolve this, is by not crossing him. If the court finds that additional testimony is necessary, obviously our case goes forward. Then I call him in our case in chief. But this whole process, I mean, they claim that Representative Eastman is their core witness. I'm glad to hear that. I mean, if they don't see their experts as being that important, then probably after we hear from David or Representative Eastman on direct, it might actually strengthen our hand a bit with the oral motion that I'm going to make. But yeah, we've heard from their witnesses by video, both in deposition and in testimony, effectively, although what opposing counsel is saying about the importance of Representative Eastman, effectively their case is built on their two non-fact witnesses, their opinion witnesses. And, I think that fair play has turned about. I mean, we haven't had access directly to them. He doesn't have access directly to Representative Eastman. If he thought it was necessary, should have been raised yesterday, shouldn't be raised right now. And then finally, of course, we want them to close their case. I object to taking our witnesses out of order, particularly given the importance of this case, and of course also the issues that may or may not be brought up on review at the conclusion. But I think we had the right to ask Your Honor at the close of their case, based upon argument, referring back to the evidence that has come into this court, to make a determination that in fact plaintiff hasn't proved their case, and that as a result, we should basically move directly to closing arguments. But anyway, Judge, that's really the argument here. I think that the court is very able to evaluate and view the witness. I've given a representation about his location to me. As an officer of the court, I've made it clear that I'm not going to be passing messages to him. He can see Representative Eastman. We just went through, or not I, but the good person who has put me up in their residence has tripled their bandwidth, and we're ready to go forward.
So, Mr. Dukian, I understand your point about the witness being by Zoom, but that's the situation we're in. And so we are going to go forward today, but I want to make clear the record that I have in front of me. The reason that I'm suggesting that we need to go forward today is twofold. First, there is the timing issue of we just need to keep the case moving. We've already lost an entire day. Taking the witnesses out of order doesn't seem appropriate at this point, given where we're at in the case. Additionally, I do find that as long as the connection is good at this point, that the Zoom is sufficient for me to see the witness, for the parties to see the witness. That is essentially how we've taken the other witnesses so far in the case. And based on the experience that I have with doing other Zoom trials during the pandemic, post-pandemic, this is sufficient for there to be a record and for the parties to see the witness and for me to judge credibility and everything else that I need to do as a finder of fact. On the other hand, simply put, the way that the connection was working earlier wasn't sufficient. It was a bad record. We were getting people talking over each other. That's no one's fault. That's just the reality of what we're facing at the moment. And so if it turns out that the audio is fine to go forward and it's otherwise the same connection level that we have with Mr. Dedukian or with Ms. Harrison, I find that that's enough for us to go forward with the case, and that's sufficient for at least the direct examination here to go forward. Mr. Miller can make a choice about whether he wants to cross his client or not. So we're going to go forward at least at this point. But Mr. Dedukian, if it turns out that there's significant connection issues, then we'll return to your request to finish that in person, because there was not a sufficient record, I think, earlier to make that really helpful testimony in any way.
Okay, Your Honor. I mean, again, I would just note that we have the right to effective cross-examination, and there are a lot of different reasons why we were impeded in doing that before. Some of it was connectivity, some of it was not. We were impeded in impeaching the witness because he didn't have access to the exhibit binders. And I don't believe that, if we have to do it by Zoom, that it's going to allow us to do an effective cross-examination. And we couldn't have brought it up yesterday because we didn't know yesterday when we left court that we were going to be on Zoom today.
I understand if there's exhibits that we need to get to Representative Eastman, we can work on that. But as far as the Zoom portion of the questioning, we're going to go forward right now.
And Your Honor, also to address that concern that opposing counsel has, I would actually prefer the exhibit to be in front of my client. I do have a printer that's available. I have all of these exhibits digitally stored, just like the last exhibit that now Representative Eastman has in front of him. If there's another exhibit that Mr. Dedukian would like him to see, it will take just a minute or two to print it. I'm happy to do so.
All right, thank you, Mr. Miller. Can I also get? All right, given that, are the parties ready to proceed, or is there another issue?
Judge, just although the video feed is working great, given the increase in bandwidth, we would like Representative Eastman to also connect by phone because of this severe lag. The phone is apparently connecting at a different rate than what the video is. And so if we could allow him to go ahead and call in and maybe the clerk join him by audio, by his phone audio, that would be wonderful.
All right, we can make that work.
Okay, he's going to go ahead and dial in now. Oh. Trying to get the password and the meeting ID figured out, Judge. Sorry about that. Okay, he is in the waiting room now, Your Honor.
Representative Eastman, can you hear us by the phone?
I can hear you. Can you hear me?
Yes, we can.
Okay, thanks.
It might be helpful, since you and your attorney are in the same room, to, if we do start to get feedback between the two of you, for Mr. Miller to at least mute the phone connection until if there's an objection or something that needs to chime in on, but just to make sure that there's minimal feedback, that might be an issue. But otherwise, I think we're good to go.
You know, Judge, I should have just conferenced them into my line. I didn't even think about that.
Well, can you do that now?
That actually may be a better solution so we don't get this feedback in. It may still happen. I'm not a technical expert, but I am getting a tremendous amount of feedback this way.
Mr. Miller, let's try.
Let me try.
Mr. Miller, before you do that,
Go
let's. Right now, I'm just concerned if you're conferencing and you're sharing a speakerphone that we might not have a good audio of your client. Right now, we can hear him pretty well when he's speaking, and so if you could just mute your phone line, let's try that for a while and see if that works. But I want to get a good audio recording.
Go ahead and see.
Yes. How's this?
We can hear you fine, Representative.
Okay.
Party's on the line, one moment. Your Honor, I've just sent instructions so that we can merge those phone lines with Mr. Miller and Mr. Eastman's video to cut back on a lot of that feedback.
Okay.
In the chat.
Do those instructions go to you?
To all of you.
You know how to do that?
And Judge, I'm still waiting on the email. Don't have it yet.
It's in the meeting chat. So if you go into the Zoom, there's at the bottom next to participants, it says chat, and that'll bring up a screen to the right, and that'll have the instructions.
Sorry, Judge, I'm not a Zoom expert. There we go. I see it down there. Okay, our PC audio, at least on mine, is disconnected. Representative Eastman, if you can make sure that your audio on your PC is muted. I do not have a disconnect audio button. Oh, maybe it's leave computer audio. Maybe that's what it is. Let me just try that. Okay, I think I may be merged, Judge, with the video at this point on mine. Can you hear me okay?
We can hear you fine.
Okay, and it looks like, are you getting a lag? Are you hearing my voice at the same time that you see my lips move?
There's a little video lag, but the audio is fine.
Okay. Have you been able to do the same? So go to the mute, use your up button, and then leave audio.
I'm not sure how to know if it worked or not.
Good. Sounds like we got pretty good audio. I'm just going to mute my end and make sure we don't get any feedback through me while the questions progress.
Understood. Representative Eastman, can you hear us okay?
I can hear you.
All right, let's try going forward. We'll see how it goes. And Mr. Dedukian, you're muted.
Judge, did you say that we did not get a good record from the earlier questioning this morning?
To the extent there were answers, it came through. You know, it was just taking a long time and it was tough to hear. If you would like to go back, you know, where were we at was, we were just discussing him being on the Capitol grounds until the curfew, that subject, and then near the Grant Memorial and the rally on the ellipse. So I think we got the substance of the answers, but it was tough to hear and follow. And so this is going to be a lot better.
Okay, so I guess my question is, do I need to start over or should I try to continue where we were?
You should continue where we were. I think we got the substance of it, but it was going to be tough going.
Okay. So yesterday, your lawyer was suggesting that the calls to action emails from the Oath Keepers, they weren't a regular occurrence for you, correct?
I did not frequently receive emails from Oath Keepers.
And when you received the email on January 5th, it was important enough for you that you forwarded it to Pat Martin, right?
Yeah, he was going to be in DC at that time.
In fact, you two had traveled there together, correct?
Correct.
Now, turning to the events of January 6th, you spent part of the day at the Stop the Steal rally at the Ellipse, right?
I think it was the Save America March, I think they called it, but just generally referred to as the President's rally.
Okay, and that was about 2 miles away from the Capitol building?
I think that sounds about right. I couldn't tell you exactly.
And at the end of that speech, the president asked the people at the rally to march to the Capitol, right?
Yes.
And to fight, right?
I don't remember anything about fighting, no.
You don't remember the president using the word fight like hell?
I don't remember the words the president used, no.
Okay. And at the time the rally concluded at the Ellipse, you made your way by foot to the Grant Memorial.
I think actually we first started in the opposite direction.
Okay, and eventually you found yourself at the Grant Memorial.
Yes.
And as I was asking you before, right when we got disconnected, that was right on the edge of the restricted grounds at the Capitol, right?
I couldn't tell you anything about that, but I can point to it on a map for you if you like.
Okay, and then I think this is exactly where we got interrupted. I was saying you continued to remain at the Grant Memorial until a curfew was issued by the District of Columbia.
Yeah, I couldn't tell you when the curfew entered into the mix. I just remember that there was a text message that went out on cell phones announcing that a curfew had happened. I don't know if that happened at the same time as the curfew or even when that was issued.
Okay, so let me rephrase it. You stayed at the Grant Memorial until you got the notification that a curfew had been issued by the District of Columbia.
Yeah, I don't know when that curfew came into the mix.
Right, and I keep telling you that I'm not asking you when it came to the mix. I'm asking in relation to when you left the Grant Memorial. It would have been after you got notification of the curfew, right?
I didn't leave because of a curfew. I have no idea what came first or when what happened. Okay, so you have no recollection if you left before or after you got notification of the curfew? That's your testimony today? Yeah, I don't know where in the mix the curfew falls into the timeline. Okay, understood. While you were at the Grant Memorial, violence erupted on the Capitol grounds, right? I was told that. I didn't know that at the time.
And you were there when actually the Capitol building was breached by the violent mob.
I believe that may have happened before we were anywhere close to the Capitol. I think the timeline that I was told about was that the breaching of the Capitol grounds started while we were still listening to the president's speech, and we did not participate in the march to the Capitol. We didn't get there until quite some time after the fact.
Okay, and so again, so you have a pretty good recollection of the timeline just now. What time exactly was it that you got to the Capitol grounds or near the Capitol grounds?
I know we were going to get there for a group photo, which is why the Grant Memorial was on our to-go-to list. But I think the photo, if I remember right, wasn't until like 4:30 or something like that. So as far as when we got to the Grant Memorial, I don't remember any particular thing that happened that would help me remember what time that was.
Okay, but at least as of 4:30, when the photo was taken, you were at the Grant Memorial.
If that was the time, yeah, whenever the photo was taken.
I thought you said that was the time. I didn't come up with that time. I thought you testified that.
My I don't have the invitation in front of me to verify that.
All right. So you became aware at some point that a number of individuals had breached the Capitol building, right?
At some point, I became aware of that.
And you became aware at some point that the certification of the election had been delayed because of the mob that entered the Capitol building, right?
I don't know exactly what you're asking. Did I read about it in the news? Yes, I did read about it in the news.
Okay. And I take it that you were glad that the certification was delayed, right?
Not particularly, no.
I'd asked you earlier in my questioning if you had been wanting Congress not to certify the election, and I thought you had written that you wanted Congress not to certify the election. Is that not correct?
What I was hoping would happen was that those in Congress who had lodged objection would have the opportunity to have their objections heard in according to the law. Unfortunately, that did not happen, I think is my understanding.
Okay, but the fact that the election wasn't certified, isn't that exactly what you wanted? At least it was temporarily delayed. That's exactly what you wanted, right?
No, it's not exactly what I wanted at all.
Sir, did you have a specific intent for the Oath Keepers who were at the Capitol on January 6th to use violence to stop certification of the election?
No.
Would you grant me that it's hard to get into somebody's mind to determine what their intent may or may not be?
I think. Hold on. I got to find my mute button here.
We can hear you, Mr. Miller.
All right, objection calls for speculation.
Overruled. It's a fair question to ask him about whether or not he can see other people's intent. So continue.
I think the judge asked it more artfully than I did. So are humans able to see other humans' intent?
Sometimes, I think sometimes not.
Right. Well, you can't see it with your eyes, right? So you have to make inferences based on what people do, right?
Yes.
And then you also have to make inferences based on what people don't do, right?
Yes.
So at some point after the events of January 6th, you became aware that there were Oath Keepers included amongst a mob that entered the Capitol building, right?
Yes.
And you became aware that Oath Keepers had committed violence inside the Capitol building, right?
I know there's some accusations. I don't have any direct knowledge about those.
Okay. And yesterday you testified that you had direct knowledge of actions that the Oath Keepers took while inside the Capitol building, like protecting Capitol Police. Do you remember testifying to that?
I remember that.
So you have direct knowledge of what the Oath Keepers did inside the Capitol building, but you don't have direct knowledge of whether they used force.
So if you're talking about something that I've talked with someone else about and have had a conversation, yes, I've had that. I think I generally give more weight to that kind of knowledge than I do to reading a headline in a newspaper.
So I'm sorry, a part of that cut out for me. Can you repeat that?
Yes, I would say generally, if I have an opportunity to talk to someone about something that's happened, I give that more weight than I do just simply reading a newspaper headline, which may or may not be accurate.
So is it your testimony that you talked to Oath Keepers about what happened inside the Capitol on January 6th?
No, I haven't talked to Oath Keepers who are in the Capitol.
Well, it sounds like you talked to somebody about what happened in the Capitol on January 6th. Is that right?
Oh, yes, I've talked to several people at this point.
And when you talked to those people about what happened inside the Capitol on January 6th, you were told that some Oath Keepers were helping the police?
Yes, I did see some video about that.
And did you ask them, those people that you talked to, if any of the Oath Keepers had actually committed violence inside the Capitol building on that day?
I think my first introduction, if I remember right, was watching a documentary about that event and watching the footage from that and hearing the testimony of the people who were there.
And when you watched all that footage, did you see people wearing Oath Keepers gears marching in military stack formations through the Capitol building?
I think there was a excerpt in that film that showed people with their hand on a shoulder walking up into the Capitol to rescue some of the Capitol police officers that were in need of help.
And those people that you're describing were wearing Oath Keepers logos, so you could tell that they were Oath Keepers, right?
Yes.
And so when you viewed that footage of Oath Keepers and they were also wearing combat gear, right?
Could you be more specific?
Well, you were in the military, right, sir?
I was.
And at any point in time, did you wear or call anything combat gear?
I don't know if that was the term that we use very regularly now.
Okay, so you have no understanding of what the term combat gear might mean? How would you?
Well, I don't use that term with any degree of regularity. So if you're using that term, I'd like to know how you mean it so that I can answer accurately.
All right, fair enough. Did you see any of those individuals who you identified as Oath Keepers wearing helmets?
Yes.
Did you see any of those individuals wearing tactical vests?
Yes.
And did you see them assembled, as you said, with each individual with a hand on the shoulder of the person in front of them? Did you see that?
Yes.
And in the military, that would be called a stack formation?
That's probably not what I would describe as a stack formation. That was just people walking through a crowd, holding on to each other.
And your understanding of what they were doing in the Capitol on that day was that they were proceeding in that fashion to help the police? That's your understanding?
Yes.
And you are aware, though, sir, that at least 3 of those individuals have now pled guilty to seditious conspiracy charges, right?
I've heard that.
And you're aware that in the plea agreements, in their statements of offense, they admitted to not only marching in those formations, but to using force while inside the Capitol building, right?
Those aren't documents that I've reviewed, no.
Okay, so you have no knowledge of any of that?
I have not reviewed those documents.
And Your Honor, I believe at least on my end, the video is starting to freeze up.
It's a little bit slow. There's a bit of a lag, excuse me, on the video. The audio seems to be coming through fine. Representative Eastman, it'd be helpful if you just moved a little bit so we could tell if you're still actually there. All right, thank you. It seems like it's intermittent. Sometimes it's in, sometimes it's off.
Okay. So Sitting here in court in December of 2022, you still haven't made a conclusion in your own mind about whether the Oath Keepers used force inside the Capitol building?
I know there were individuals that were engaged in force and violence. I would not attribute that to every Oath Keeper that went into the Capitol building, no.
But you would admit that some individuals who were Oath Keepers used force while inside the Capitol building?
Yes.
And you understand, sir, and when did you reach that conclusion in your mind as to the fact that some Oath Keepers had used force inside the Capitol building?
I think the first thing I had heard was that there was a gentleman who was an Oath Keeper who, had some kind of altercation with a Capitol police officer.
And sir, you froze again, so I can't. It looks to be permanently frozen this time.
And Judge, I'll just note for the record, I'm seeing everybody moving except for Mr. Dedukian.
I've seen Representative Eastman is frozen up on my screen too, as far as the Zoom goes. He's starting to move again, but it was frozen for the entirety of that answer. And we're, unfortunately, Mr. Miller, now you're also breaking up just a little bit for us there.
Can you hear our audio fine, Judge?
I can hear you right now, yes.
Okay, we aren't having any issue though with audio feed, right?
No, the audio is coming through. I haven't heard any glitches, but Mr. Dukian's correct that your client and you, at least as far as the video feed goes, are frozen up at the moment.
And Your Honor, for the reasons I've said before, audio is fine, but we want video too. It's not a telephonic hearing.
I understand. Let's give a second here to see if it's just a problem at the moment. But I've seen Mr. Miller move again.
And the strange thing about this, Judge, is I got you just fine. Mr. Kowalke's frozen a little bit too, but.
Mr. Kowalke's moving fine for us. I think that the problem is, unfortunately, it's coming from the connection between Mr. Miller, where you all are at, and the rest of the participants. All right, I'm seeing Mr. Eastman. At least there's a little bit more movement there. Saw a few blinks, but it seems like we might be back. So let's continue on a little bit more, Mr. Dukin.
Okay. I was asking that, or I think you said that as of now, you at least have knowledge that some Oath Keepers were inside the Capitol building on January 6th, right?
Correct.
And at least some Oath Keepers used force inside the Capitol building on January 6th, right?
Yes.
Do you have, is it your contention that what happened at the Capitol building on January 6th was a peaceful demonstration?
No.
Okay. Do you understand that as a leader in the Alaska legislature, that people in the community and your constituents look up to you?
Yeah.
And you try to communicate your views and opinions to your constituents, right?
Some of them, yes.
And so you do that, for example, by using your Twitter feed?
Sometimes.
And you have a Facebook page, right?
I do.
You have a David Eastman website, right?
I do.
And you post articles and op-ed type pieces to your website?
I do.
And sometimes you write op-eds for the newspaper?
Sometimes.
And I think we have that video problem again.
Yeah, Mr. Eastman, you are frozen. It's kind of coming in and out. Sometimes we're seeing you there, sometimes it's not. We're still getting the audio.
Yeah, I think the audio seems to be working fine, Judge.
All right, it looks like it just reset we lost you for a second there on the video in the background. Can you just lean back and lean forward just so we can see if you're moving? I understand it's unnatural to move. It looks like the video is getting a little better again. So again, let's try and continue.
Okay.
And Judge, maybe if there's a chance it's our connection, not just the general MTA connection, maybe what I should do is shut down my video.
Yeah, it might help to reduce what's going out. All right, let's continue and keep moving.
So I was asking about the different ways in which you communicate with your constituents, and I think I asked you about your website. So you post articles to your website, right?
I do, yes.
And you post, or you have written op-ed pieces for the newspaper?
I do at times.
And do you have like a constituent newsletter or something like that?
Not really.
Okay. The people in Alaska were generally aware, to your knowledge, that strike that, let me back up. You had told the people in Alaska and your constituents that you were going to be in Washington, D.C. on January 6th, right?
Yeah.
And you had posted pictures of your trip on your Facebook page, right?
I believe so.
And
I don't recollection of which pictures were posted or not posted. I know there were some probably.
You have no memory of whether any pictures were posted to your Facebook page about or portraying your trip to DC?
I think there was a picture. There's probably two pictures. There was a picture that was taken of the group at the Grant Memorial, and then there was also one in front of a bus on January 5th. And I think those were both posted either to my Facebook page or somewhere else.
Right. So the one that I want to ask you about is the Grant Memorial picture. That was taken on January 6th?
It was.
And you were in that picture, right?
Correct.
And you could see in the picture that it was at the Grant Memorial, right?
Probably. If you don't know what the Grant Memorial looks like, you may not know.
Okay. And for those people who are familiar with the Grant Memorial, they would know that it's relatively close to the Capitol building, right?
Relatively.
Okay. So after the events of January 6th came to be known by the American public, you never once communicated anything, whether by social media or your website or in any other way in which you condemned the Oath Keepers, did you?
No, I generally don't condemn groups.
Okay. And in fact, you didn't condemn any individual Oath Keepers either, did you?
I generally don't condemn individuals either.
Well, you did suggest that the violence that happened on January 6th was by Antifa, didn't you?
I know there were a lot of people who engaged in violence. I'm not sure who all they were. I know there were some folks on the Antifa side of it, or who appeared to be, that were engaged in violence, and others as well.
Right, but you say you don't call out individual groups, but of all the entities or individuals that engaged in violence on January 6th, the only one that you called out specifically was Antifa, wasn't it?
It's possible. I think, I'd have to go back and look at what the public statement was that I made.
Well, I'm going to help you with that. If you can turn to your exhibits, Defendant Eastman's Exhibit AG. Let me know when you're with me. Your Honor, Representative Eastman is muted again, and I'm just going to object to that. And Mr. Miller is not even on the screen.
Muted. We're on the phone line, I believe.
Okay.
Yeah, nobody's muted anything.
All right.
I mean, other than he had to do to connect by himself.
In other words, it's not going to change. And the noise in the background, Your Honor, is the turning lead. Right away is turning in these lights.
I am looking at Exhibit AG.
On page 1 of 7.
I have it in front of me.
So that was it looks like, is that a Facebook post that you made on January 7 of 2021?
Yes, I believe so.
And your testimony a minute ago was that you don't call out individual groups, but if you look about halfway down that post, you write, if you think that the members of Antifa or any other groups who were assaulting police officers at the Capitol today were doing so because of something said by the president, then you know neither Antifa nor the president. Did I read that correctly?
Let me find that. Yes, I believe that's correct.
And you wrote that, right? That wasn't ghost written by like a social media person that you have?
No, I wrote that.
And the only group that you called out in that post about the events of January 6th was Antifa, right?
Yes, I made it as a statement that would be encompassing any groups that were involved in the violence that day.
I understand that, but there was only one group that was named, Antifa, and the Oath Keepers was not named in that post, right?
That's correct. And to correct your statement a moment ago, I said that I generally don't call out groups, but on occasion I do. It's just not often for me to do so.
Okay. And even after you later learned that there were Oath Keepers included in the people who entered the Capitol building on January 6th, you still didn't post anything condemning the Oath Keepers as a group, right?
Correct.
And you didn't condemn any of the individual Oath Keepers who entered the Capitol building either.
If you mean calling out people by name, my condemnation was of the violence itself, not particular individuals or anything like that.
Okay. And in fact, on January 15th, you conflated the violence that occurred on January 6th with election fraud, didn't you?
I don't recall what you're talking about. Sorry.
If you can look at Exhibit AB. Let me know when you're with me.
I think we'll have to print it out. I have Exhibit AB in front of me.
Okay. So do you see your post? It looks like it was on Twitter. David Eastman Jr. or at David Eastman Jr. That's your Twitter handle, right?
I think this is a Facebook post.
Oh, is that on Facebook? Okay.
I don't remember, but no, it says Twitter on it. So you're right, it's Twitter.
Do you see that on January 15th, you posted, quote, "Those who broke the law in violating the integrity of our Capitol building should be prosecuted to the full extent of the law. Those who broke the law in violating the integrity of our election should be prosecuted to the full extent of the law." You see that, right?
Yes.
Even though by January 15 of 2021, every single court to have looked at allegations of election fraud had rejected it, correct?
No, actually, I think there were many courts that did not look at election fraud.
That's your understanding of the state of affairs as of January 15th, that there were still legitimate concerns about election fraud?
Judge, I'm going to object on the basis of relevancy.
Overruled is.
You can answer.
Could you restate the question, please?
Your understanding as of January, the state of affairs as of January 15th, 2021, is that there were credible allegations of election fraud that would have, well, let me stop there. Credible allegations of election fraud.
I think to clarify from a moment ago, there were courts who were asked to look at election fraud and chose not to do so based on standing or some other technicality.
Oh, I see. And so in this post on January 15th, you equated election fraud with the violence that occurred on January 6th at the Capitol, right?
Objection mischaracterizes the evidence.
He can answer the question to explain.
Yeah, no, I did not equate. I compared the two things together, both as violations of laws. My question in that comment was, are we not a nation of laws? And if we are, then we should be following laws in both cases. In fact, in all cases, but particularly those two, since those were topics of interest at the time.
When you said that those who, hold on, I don't want to misquote you. Those who broke the law in violating the integrity of our Capitol building should be prosecuted to the full extent of the law. Did you include in that statement the Oath Keepers members who had entered the Capitol building?
I don't believe I had information about that. And I think generally with talking about violating the integrity of the building, you're talking about forcefully breaching a building, and I'm not aware of Oath Keepers who were involved in that.
Let me ask you point blank, sir. Do you think that any Oath Keepers should have been prosecuted to the full extent of the law?
I think anyone who violated the law should be prosecuted to the full extent of the law.
Right. Let me ask the question a little bit differently. Do you think that any Oath Keepers should have been prosecuted to the full extent of the law in connection with their activities on January 6th?
If they violated the law on January 6th, then yes.
Does that include Stuart Rhodes?
If he violated the law on January 6th, yes.
Well, in fact, the jury found that he violated the law on January 6th, right?
That is correct.
But when he was indicted back in January of this year, didn't you publicly state that that was a politically motivated indictment and wasn't a legitimate indictment?
If you want to talk about something I said, I'd be glad to talk about it. I don't have that in front of me.
Do you recall making that statement to a journalist that the indictment of Stuart Rhodes was politically motivated?
That was not my recollection of that statement.
Do you think that the indictment of Stuart Rhodes was politically motivated?
I think almost everything dealing with January 6th has political motivations behind it from one side or the other.
All right. I have just one last question for you, Representative Eastman. Why haven't you called out the Oath Keepers for their actions on January 6th?
I called out everyone who engaged in violence that day for their actions on January 6th. And if the Oath Keepers were part of that, then they fall into that category.
And you don't see the need to call the Oath Keepers out by name?
No, I do not.
Nothing further.
Mr. Miller, any cross, Representative Eastman?
I'm going to have my client mute his phone so we don't get the feedback in. No, there will be no cross at this time, although if the court directs that we present our defense, then we will call him back in our case.
Representative Eastman, at this point, you're excused from testimony subject to recall.
Thank you.
All right, Mr. Dedukian, any other witnesses for the plaintiff?
Not at this time.
Does the plaintiff rest their case?
Yes.
All right, so timing-wise, Mr. Miller, I understand there's a motion that you want to make following the conclusion now of the plaintiff's case. Just looking at timeframe-wise, talking it through now, your next, if we go forward with the presentation of evidence, your next witness would be at 1 o'clock. So I think we have enough time to essentially address the motion. I can make a ruling, and then one way or the other, we'll know whether or not that needs to happen with Mr. Rhodes at 1 o'clock.
Very well, Judge. If we could take a 5-minute recess so I could hit the restroom, and I should be able to. So what I'm proposing, Judge, is it's going to be my opening combined with the motion. So those are inseparable concepts. So I don't anticipate before the witness at 1 o'clock doing any type of opening if the court directs that we proceed with our case.
Okay. I'll give all the parties essentially a break. It seems like a good chance to reset. So we'll come back at 11:35. That should give folks time to get back, come back, and then we can address the opening, the motion. If I need to take a brief time to make my ruling, that should still leave time for lunch and then moving forward if needed. So we'll come back at 11:35.
Talk about perfect timing. They couldn't have planned that one any better if I had tried for them to take that break. The plow truck literally just finished cleaning up my yard. It looks amazing compared to what it did look like. You're talking like 30-point turn just to be able to turn around in my driveway prior to this from the past plow that came in. But you get what you pay for. Last one was free. This one I paid for. Big difference, but it was well worth it. So far we've heard the cross-examination by the prosecutor there, grilling Eastman on his association with the Oath Keepers, what was his role on January 6th and where he stood at when he was there. And obviously the plaintiff did not get the answers that he was trying to coerce out of him several times throughout the entire witness there giving his testimony. Eastman the prosecutor kept trying to make a point of saying you are guilty by association. You are a card-carrying member. Did you see others doing this? Oh, you're guilty because you saw others doing this. You have not openly outright condemned the violence that occurred January 6th. Why haven't you done that? Specifically calling out the Oath Keepers. And each one of them individually by name, kind of go back, flashback, look back at all the times that they accused President Donald Trump of not condemning racism, violence, all the other stuff that was going on out there. They kept trying to put words into his mouth saying that he's never condemned any of these things, yet he condemned it over and over and over again. And same thing here with Eastman. He's condemned the actions of those on the Capitol, in the Capitol that day, I should rephrase that, in the Capitol that day. Condemned them 100%, just like any American would do. I don't know anybody out there that would call themselves an American, a U.S. citizen, that did not condemn what happened there on January 6th. The violence and actions of the few should not be placed against the many. And that's exactly what the left stream out there, the extreme left who's taking over our country, trying to, wants us to believe that, again, all you are is you're guilty by association. All you have to do is be a card-carrying member, and that makes you guilty of the crimes of the individuals of other people's actions. You're guilty just because you are a part of that group. Pretend for a moment AARP. You're a card-carrying member of AARP. The leadership in AARP decided to pull their own, who knows what you call it, an insurrection, and they went after, they decided to go into the Capitol to complain about not getting enough benefits for everybody out there, for the senior class that's a part of the AARP organization. And they go and they stage a coup where they invade the Capitol and everything else, and it's just a few individuals. We're talking the head leaders, 30 people out of the 30-some thousand, or AARP, I think they're in the millions that are involved with that organization. All millions of them are now guilty by association because they are a card-carrying member. And that's what they're trying to tell us, that David Eastman is guilty by association for the actions of 33 people, less than 1% of the entire enrolled group that is there as call themselves oath keepers and belong to them. So the actions of those small minority, less than 1%, we're talking like the same predictions that they had for COVID and how many people out there got sick from it, and you base that on how many people died, and then you actually take the overall population and it came out to like a 0.000 something percent. That's what we're looking at here. That's how many people were affected by this, and that did what they did, and they want to blame the millions upon millions of other people out there that it's all their fault, that we're all in danger because those people died, yet it affected less than 1% of the entire population, as in for worst case scenario. And they're talking the same thing here. Less than 1% did the worst case scenario. They invaded the Capitol that day and caused a lot of mayhem and destruction. But there was no insurrection. In fact, there was no weapons found inside of the Capitol other than the ones the Capitol Police had on them. And the only person to get shot was a person that was there, a patriot, Ashley Babbitt. She got shot by a Capitol Police officer, no justifiable defense behind the shooting to begin with, and that Capitol Police officer still, to this day, has never been charged. He was let free. In fact, if I remember right, they gave him a medal. It's just totally shocking what they can get away with just by how they spin the narrative. This is a remnants of, you watched the January 6th committee hearings that had occurred, and the trial that they had, I want to call it a trial, but those hearings the January 6th committee did, and the 6 of them, and now they tried to spin their narrative. Cut and paste scenario. Only say what they want you to see. Only show you what they want you to see. Take speeches of President Trump and purposely clip out the part about peacefully go down and raise your voices. Those kind of things never made it into their hearings because that completely dispels the narrative they were trying to spin to all of us. Same thing that they're doing here. The 2 expert witnesses that the prosecutor brought forward for their case, Matt Kreiner and John Lewis, both of them far left-leaning, work for institutions that sole job is to do nothing more than to push divisive rhetoric and opinions and theories about what they think about the alt-right extremists. If you were to ask them what happened with Antifa, the Black Lives Matter riots, the protests that are going on, the Supreme Court justices' homes being invaded, so on and so forth, that type of extremism, I don't know nothing about, was their answer. Matt Kreiner was asked about the FBI that was involved directly in the middle of all the things that happened there on January 6th, like, who is Ray Epps? That question, I have no inkling of anything about to do with Ray Epps, was the answer. What about the others that were embedded into the Oath Keepers, the FBI that was there? What about them? Oh, I know nothing about that yet. Both of the expert witnesses they brought forward were supposed to be experts on everything Oath Keepers. At least that's how they portrayed John Lewis. He was the expert on everything Oath Keepers. And Kreiner, he was pretty much the same way. Matt Kreiner, he was portrayed as the expert on everything to do with extremist organizations that are considered terrorist groups or along those lines. But whereas Hamas on his, no, none of that. It's all domestic terrorism. You know, the pushing people off of into the train tracks there in New York City. That's not considered extremism, or the attack on the Jewish populations that's being perpetuated by the minority Black Lives Matter representation out there. Yet that doesn't make the news because it's the wrong demographics and the wrong color of skin. That's not extremism. That's nothing to look at. Don't look over here. None of that is a problem. The attack on the pro-abortion clinics or the abortion clinics, you know, those that are not for it, you know, the pro-life clinics get attacked. Crickets. The other two that I named off first, man, they're on mainstream media for weeks. They have someone indicted and under criminal charges within days or hours after it had happened. Yet, if you are pro-life, crickets. Investigation stops. They're not looking for the people that perpetuated the actions. Oh, they finally might find somebody, but they're instantly released. Yet if it happens in the other directions, they're thrown away. The key is thrown away, and their lives are gone, and nothing in the future is ever going to happen for them because they're going to throw the book at them. All the other folks are already out on cash release bail that they didn't have to pay any cash because of the laws that they have. Let me pop up on the screen here again. I want to make sure that I'm not missing them coming back online. And it is just a black screen is all I am seeing there right now. Oh, they're starting to show up. I see pictures of them showing up on the screen, so they're going to be coming back on here in just a second. So again, please, if you haven't done it yet, take the time, like and share this video. The more Alaskans that we're able to get to sit and watch this and listening to the games that they are playing with our judicial branch, determining our voices and votes at the ballot booth are going to be determined by the judicial branch on who and who cannot represent us, and the actions that are taken against your freedom of liberty or who you want to associate with, whether you are a card-carrying member or an active participating member on a day-to-day with their everyday activities. It doesn't matter. That's kind of where it all stands at. I'm going to go ahead and switch screens here for the other one and get them back on again.
Miller, can you hear us?
And we'll go from there. Please like, share. Find us on Twitter,
Mr. Miller,
YouTube,
back
Facebook.
Back on the connection?
Rumble. Like, subscribe. Quiet time for me. They're back.
Representative Eastman, are you able to hear us from where you guys are at? Mr. Miller, we can see you now. Are you able to hear us? Mr. Miller, can you hear us now? We can't hear you. So Mr. Miller just held up a sign saying, I'm waiting. Unfortunately, we can't hear him. All right, Mr. Dedukian, I just want to make sure everyone else on the Zoom, I haven't heard you guys speak. Are you able to hear us?
I can, Your Honor.
All right, Ms. Harrison?
I can hear you too.
Okay.
I wonder if he's waiting to be let into the Zoom, if someone needs to let the phone call be accepted into the Zoom.
Mr. Miller, can you hear us now? It looks like a phone may have just joined.
Judge, I went in and joined by the computer. I wasn't being let in on the waiting room, or maybe you guys aren't seeing me. I don't know on the phone, but I muted my phone and I now just tried to join my audio. I want to make sure everybody can hear me though if I do this through the computer.
We can hear you fine.
Good. I'm going to disconnect the phone and hope this works. And Judge, I've got some stuff up on my screen, so hopefully I can see if there's any type of problem with you hearing my argument. I guess my client can indicate because he'll have me on video. So,
And Your Honor, I was wanting to bring up some housekeeping about exhibits before we do the argument and opening.
Sure. All right, Mr. Dedukian.
So I wanted to make sure all of the exhibits that we had, or I want to go through the exhibits and see if the ones we want admitted have been admitted. So there's exhibit, we offered 3, 4, 5, 6, and 7.
I have those as admitted.
And then I believe 9, 10, 11, 12, and 13 are from the stipulation.
Yes, that's correct.
Then is exhibit 14 admitted?
14 was admitted.
18, 19, were they admitted?
They were.
Exhibit 20 was the superseding indictment of Stuart Rhodes, and I don't know if we formally offered them into evidence. We wouldn't offer it for the truth, but only to inform the verdict that you took judicial notice of.
Mr. Miller, any objection for it being admitted for that purpose? It wasn't admitted previously.
Judge, I think we would stipulate to the admission of AA, which I think is the entirety of the indictments. And that might, let's hold on that. I'll hold on that. I think the indictments that they wanted before the court have been offered and admitted. 20 was not part of that, so we would object to its admittance at this point.
All right. I'm going to admit it if there's no reason to not find it's authentic. It's helpful for an understanding of the guilty plea that I took judicial notice of. So I'm going to admit it for that purpose.
I understand, Your Honor, that 21 was admitted for 703 purposes.
It was, but not for the truth of the matters asserted in it.
Right. And then 22 through 39, I think, were the court admitted under 703 and reserved judgment on other grounds. And I wanted to provide the court with some citations as to the basis for our request that they be admitted for the truth.
All right, go ahead.
So the guilty pleas, the court can take judicial notice of them, and a couple of citations for the court. One is United States versus Ferguson, 681 F3rd 826 from the Sixth Circuit. And then there's Colonial Penn Insurance Company versus Coyle, 887 F2nd 1236 from the Fourth Circuit, 1989. There's also a reference by the Alaska Court of Appeals in Harris versus State, 195 P3rd 161 at 182. That's Court of Appeals 2008, where the court noted that a guilty plea had been judicially noticed. And then As far as the other exhibits, the statements of offense, again, we would ask for the inculpatory statements contained within the statements of offense to be admitted for their truth. And that's because each of the individuals who pled guilty and signed the statements are outside of the court's subpoena power. If you look at Civil Rule 45E, the court can subpoena witnesses within the state, and all of those individuals are outside the state. And to the extent they've made inculpatory statements in those documents, then they should be admitted as statements against interest. And a couple of cites on that: U.S. versus Jackson, 335 F3rd 170 from the Second Circuit, 2003, and U.S. versus Centracchio, 265 F3rd 518, Seventh Circuit, 2001. And one last thing, Your Honor. Sorry. Let me first continue going through the exhibits unless the court has questions.
No, good. So we're up to Exhibit 39, I think, in what we're talking about.
42 was admitted, or that was judicially noticed. Was 43 admitted?
It was the January 14 Rhodes letter.
Okay. And then I would ask the court to take judicial notice of the location of the Grant Memorial in relation to the Capitol building. I sent the court an exhibit. It's a Google.
Chris has been telling me a while about it from Shoemaker.
It's just any other participants here, just make sure you're muted.
I sent the court a document, Exhibit 49. We'll mark it and bring a paper copy to court tomorrow. But it's, I think the court can just judicially notice the location of the Grant Memorial in relation to the U.S. Capitol building.
Mr. Miller, any objection to taking notice of the distance and the location of the Grant Memorial in relation to the Capitol building?
Yes, Judge. I think they need to bring in a witness to testify to that. They've not done so. And I think submitting a Google printout, which I think is apparently, I don't have 49 in front of me because it's my understanding that it just came in today. Let me just double check this. I mean, I haven't even looked at the exhibit, Judge. So I guess this is a brand new exhibit.
It is. My understanding is it was just emailed today.
Okay, well, I don't have it as part of our exhibits right now. And so I haven't even had a chance to look at it. If he wanted something like that come in, he should have had it, associated with one of his witnesses.
And for what's worth, Mr. Dedukian, I'm not going to, but I don't think it's particularly, given the testimony that I got from Representative Eastman, he explained the relative closeness of the Grant Memorial to Capitol. I don't think it would be particularly helpful to know the exact, is it 0.2 or 0.1 or a quarter mile. He didn't know where the line was for restricted Capitol grounds versus the Capitol, but everyone agreed, and it seems clear that the Grant Memorial is certainly close to the Capitol. So I'm not going to take notice of it.
Understood.
And Judge, did you want to hear my objection on the efforts to admit for the truth of the matter asserted the exhibits? And I didn't hear it all, Judge. Again, I'm not connected by phone, so my hearing's limited, but I heard a number of citations and a number of exhibits that apparently.
Mr. Miller, unfortunately, we're losing your audio.
Yeah, I think we need to connect by phone, Judge. Apologize.
I agree.
So I'm going to try that again. I'm going to try that one more time. Last time I was just in the waiting room. So if maybe the clerk could watch from my computer, stand by.
Judge, I think I'm on.
Oh, we can hear you.
Good. Fantastic. And I'm getting the feedback through the computer. Let me just see if I can mute that. All right. Can you hear me okay?
Yes, we can hear you fine.
And I've got you, Judge. Thank you. So, Your Honor, do you want me to repeat what I was saying when I broke up there at the end?
Sure. So where we were at was, you had heard the plaintiff's argument for why exhibits essentially 22 through 39 should be admitted, at least the inculpatory portions of the statements of offense, as a statement against penal interest. And there were a number of citations given. So at this point, it makes most sense, I think, to hear from you why that, if you oppose the admission under those grounds, then why?
We absolutely, Judge. And this is kind of I hate to use the parlance sandbag, but this is something that probably should have been briefed far in advance of trial. If they weren't going to bring in witnesses to testify to the underlying facts and they wanted to try to get it in this way, I mean, it's obvious opposing counsel has taken a lot of time to research this particular issue. I mean, we would disagree. Statements against interests or against parties, and obviously these are not statements against Representative Eastman's interests, so that doesn't fly. I have no idea what these other cases stand for and their propositions, but just to speak to one of the issues that was raised in questioning by opposing counsel relating to the whole statement against interest. I mean, individuals, even assuming that these are documents that the court could take judicial notice of, not for purposes of the contents. I mean, people all the time enter into plea agreements for all sorts of different reasons. Maybe it's the cost. They can't afford counsel, or they don't have counsel, or they have risk, because of certain charges. I mean, there are a whole variety of different reasons why people may enter into a plea agreement with the government. And, unless the only way that the contours of that could be fleshed out would be to have those people come in and testify. This case has been an extreme burden on Representative Eastman. And I'm just trying, and the reason why I'm raising this isn't to make, some sort of perfunctory statement about, oh, this is too bad that Representative Eastman is here arguing this case, but it's the issue is that much of this is by the cause of plaintiff and the timing of this. But the reality is that this was their case. They had months to prepare their case. If they wanted these to come in without witnesses, it should have been briefed in advance. They didn't do that. And certainly, if Your Honor is going to consider their admission for the truth of the matter asserted, we should have the same opportunity that obviously opposing counsel has had to do the exhaustive research necessary to provide legal support for our position. I can just tell you, based upon my knowledge of the rules of evidence, it's certainly not a statement against interest for Mr. Eastman, for Representative Eastman. It can't come in that way. Otherwise, hearsay. The court's already made a decision about the documents, not the content. I'm happy, Judge, if you feel uncomfortable making a decision at this point without us having the same opportunity that plaintiff has had to research this issue, to make an argument assuming that they've been admitted. I don't think it eliminates the capacity of us to go forward with the request that the court make a decision now on the evidence that has been presented. But again, our position is we don't believe they should come in for the truth of the matter asserted, so we would object to the court using them in that fashion. Judge, am I still on?
No, you are. I'm taking a moment to think through how to proceed. Essentially, what I'm hearing is that you would like the opportunity to read the citations, and I'm not trying to put words in your mouth, but I just want to make sure that I give you the opportunity to present the information that you want to present, that you would like the opportunity to review the citations provided by Mr. Dedukian and to provide any counter case law that you are able to find, between now and when we need to essentially move forward with this issue. Where that leaves us, though, is that, we're at the close of the plaintiff's case. I anticipate that you're going to be making a Rule 50 motion for a directed verdict, essentially. And that, at that moment, I'm going to need to make a decision about what evidence is in front of the court. And so if you're going to ask to reserve or me to hold off on ruling as far as whether or not these come in under 804b3 until you've had a chance to give me any counter citations, then that's obviously going to push back consideration and a ruling on your motion at the end of the plaintiff's case. And so part of this then is, I'm fine if we can hold off on you making argument on that until you've, by the end of the day or by, tomorrow morning, given me citations and we move forward with that. But at the same time, you have a witness that's only available at 1 o'clock today. And so that means taking at least one of your witnesses out of order before you make that motion. And so I'm asking you, which would you rather go? Would you rather I just make a decision now, or would you rather
right.
And then you make your motion, or would you rather have the witness and then make your motion tomorrow morning?
Judge, I think I'm getting a little bit of feedback here. Sorry. So I still happening. I'll just try to do it.
I think you unmuted your computer, and that might be causing the problem.
Somehow that did happen. Thank you. So, Judge, I think the record's preserved. We've made it clear our objection to the admittance of these exhibits for the truth of the matter asserted, and I think you can go ahead and rule.
Okay. What I'm going to do then is I was given citations. I'm going to take a quick look at them. They're part of the record. I think they need to at least be. I need to give them at least a quick look. We'll come back on at 12:10. We can address them then. So we'll stand in recess until 12:10, and then I'll make a ruling.
Thank you, Judge.
All right, I'm back. They're gone. They'll be back at 12:10. We just got to hear the Miller giving his closing or opening remarks to why this case should be dismissed and should be done and over with at this point. The judge is reviewing all of the last-minute entries that the prosecution has entered into this case, stuff that should have already been put into the record during the discovery portion of it. That was already supposed to happen. It is a normal action of prosecutors to try to muddy the waters at the very last second, because their entire case was based upon two expert witnesses that provided nothing but their own opinions, theories, and assumptions, and putting words into other people's mouths that were never said, trying to associate them because of being a card-carrying member as being responsible for the actions of every single one of those members. That's kind of like someone had put into the comments here just a second ago, and I read that and kind of chuckled when I saw it there, that what's to say, because you are in the judicial branch, and the judges out there are all part of the Bar Association, and they all take their oath, and one of theirs goes out and does something like this. Is the entire Bar Association now guilty for the actions of someone else and the crime that they committed? If we were to believe the base value on the face value of this case happening right now, the answer to that would be yes. He is guilty by association because he's a card-carrying member of the Bar Association, and the Bar Association, some of the head leaders in it, decided to go commit a crime, and everybody else that's a part of that association is guilty for that association because they're a part of that association even though they weren't involved, not one iota, in anything that had happened. School teachers, another good example. You got a bad apple school teacher. We see it a lot here in Alaska, especially when it comes to our children and the actions that they take towards our children and the very deviant, perverted, very sick, disgusting acts that occur. And should that act of that one teacher be the catalyst for all the other teachers? They are all now guilty by association for the actions of that one. They all took an oath. They all promised to take care of our children when they were in school, do the best by them, yet here this one bad apple, and I shouldn't say one when it comes to that, multiple bad apples seem to crop up, a few every single year that get caught. And they just want to say guilt by association. No matter how you look at it, you're guilty. And that's what this entire case is based on. Be a card-carrying member to anything out there, and if they don't like it, you are now labeled a terrorist to the nation. You are guilty by association for everything that 38 people did inside of the Capitol that day, or 33 people, or 60-some people, and I keep throwing out different numbers there because the convicted people, the people that are facing charges right now, only about 33 of them are from the Oath Keepers, yet there was over 60 of them involved there that day, from my understanding. And but they keep flip-flop the numbers every time they say it, but they're holding pretty steady to the 30 plus, so we'll just stick with that. Now, there are 38,000 people that are card-carrying members of Oath Keepers that have either lifetime memberships or just pay their regular annual dues, but they're all card-carrying members of the Oath Keepers. These are made up of our first responders, our military, our police force, our veterans. These are people that have at one time or another taken the oath to protect our Constitution and our nation from both foreign and domestic problems that we may have. They are the front line of our defense, and they should be treated as heroes and put up on pedestals, not vilified and made to look like the evil devils that they're being portrayed as because of the actions of few. That would be like saying everybody in Germany is Hitler. You know, you kind of get the idea that everybody out there is all, if you are German, you're a part of that club, you are Hitler, you are a Nazi, that's you for the rest of your life. You are now labeled that. That is the label you're going to carry across your forehead. And that's what they want to do with David Eastman right now. They want to put that label on him that says you're an Oath Keeper, you're a terrorist, you are an invasion of our domestic terrorist for invading the Capitol, yet he wasn't in the Capitol. He was at the Capitol, participating in the events going on outside the Capitol, but he was not involved in any, not one scintilla of anything that occurred inside the Capitol that day, or anything that led up to that actually happening, or any of the planning, or anything else. And the prosecutors are trying to pretend that the actions of these other people, these convictions of these other people, are all David Eastman's fault. Our election should be determined by the ballot, not the bench. And you guys have all seen me say that, and I put it in every single title caption that I have had for this trial that is going on. And that's exactly the bottom line to it. We voted at the ballot box. We voted in David Eastman, and I say we as in the Alaskans that are in his district, overwhelmingly voted David Eastman in for another term. If he's what they are claiming in this court case, why would any sane, rational person in Alaska ever cast their vote for somebody that is a domestic terrorist? Because it's not true. We here in Alaska know that's not true. Kowalke is just somebody that is a bent, hurt, had his feelings stomped on, and is all upset and has big funded outside money paying for this lawsuit. The entire intent is for the swamp in Kowalke. If you go and look at everything that he's ever been involved with out there, he's had his fingers in every bad policy over the last decade happening here in Alaska. Ever wonder where ranked choice voting come from? I bet you'll find his name attached to it. How about the vote no for the con? I bet you'll find his name attached to it somewhere there. How about the recall Dunleavy? Bet you'll find his name attached to that too. I mean, you can just keep going on down the list. And I'm assuming here he's on all of those things. And if from what I've read, I know I'm pretty accurate on most of them, as I've just stated. We really, really, really do got to start taking back our country, and it takes each and every one of us here in Alaska to do just that. We need to stand up. We need to be the voice for the voiceless. Why do you think I do it? Do you think I'm making big bucks doing this right now? No. In fact, I'm losing money sitting here right now doing this. I am not making any money. What I make a living at has nothing to do with politics, not even close. It is not even near what you may think. If you know who I am and you've met me in person, I'm more than happy to talk about who I am outside of politics. But on air, I'm Politadick. I am the political dick that likes to expose what mainstream media and everybody else out there wants to cover up. Have you read what has come out in NPR, Alaska News Source, The Beacon, the ADN, everything they had to say about Eastman's testimony yesterday? They all tried to paint it into a picture that he was proven guilty. This is the assumption they wanted you to come up with as you read the way they flowery written up what was there. They focused solely on everything that had to do with the Oath Keepers in the Capitol, their convictions, and tried to associate their actions there that day as being all David Eastman's fault because he belongs to the same group. This group was organized, I believe, back in 2009. They had 13 long years of uninterrupted loyal service to our nation, being there when in crisis. If there was a hurricane and they needed people out there on the streets, they were out there on the streets helping clean up after the hurricane. Wherever there was flooding, they were there helping them out. You could go down the list of the positive actions that they did protecting our country as the Oath Keepers, trying to protect our Constitution and the loyalties that go behind that. It wasn't until October or November of 2020 that those few at the very top level in the Oath Keepers, and only those few, did what happened. They took it upon themselves. They were privately messaging themselves in Signal, and this is where you get to the 60-some that I mentioned just a little while earlier. And mind you, I am watching the screen to make sure they have not gone live on the other section there yet. It's still just sitting with a screen showing them waiting patiently for it to happen. And but yeah, no, this is kind of where things are at right now. Right now we're at that pivotal moment for the judge. The judge is now reviewing all of those last-minute entries that the prosecution had brought forward, the stuff that neither the judge nor the defense there for Eastman has had a chance to even look at or review, all stuff meant to muddy the water. The prosecutors only had 2 witnesses, other than if you want to classify Eastman as their witness, that they pulled up onto the stand. Their 2 expert witnesses were paid to give their hearsay, assumed theories, and everything else that they had ever learned about the alt-right domestic terrorist problem we have in America. Yet anything that has to do with the alt-left domestic terrorists that we have in America, they couldn't answer a single question on cross-examination by the defense. This is the type of people that they brought forward. My understanding is both Kreiner and Lewis were also in Juneau this last session, giving their expert testimony in front of all of our legislators down there about the extremism in the Oath Keepers, and gave their theories and opinions and testimony then. Ooh, I see a face popping up there on the Zoom for the court trial, so they will be beginning here in just a second. I'm going to keep on talking just for a couple of seconds longer here before I swap back over to them. And it's just amazing. It takes action, though. We Alaskans need to unite. We conservative Alaskans need to unite and take action about what is going on within our nation and within our own state. This is going to be one of the worst sessions next 2 years in Juneau Alaska has seen in over a decade. Literally in over a decade. Some of the worst policy actions are going to try to be pushed through over the next 2 years. That's just going to make you cry and shake your head, because if you stand back and do nothing and you don't stand up and do something about what is happening right now, they're going to pass all of this through, and in a year or two from now, you're going to go, what happened? Why did this happen? Oh, this is just not fair. Well, I didn't know none of this. Well, if you're not paying attention, you're not being involved, you're not looking for feeds like mine. I mean, literally, if I'm streaming something, it's because I believe, and usually you guys all believe, this is of great importance to all of Alaskans to know. Something that mainstream media doesn't want you to see in its entirety. I streamed what happened yesterday, the narrative that the attorneys tried to spin, the prosecutor and the defense, and their different ways of looking at things, and the narrative that the defense had spun left and right throughout the entire event, or through the entire trial yesterday and this morning. And what news media reported was the narrative. They did not state the facts. If you didn't watch it uncut and unfiltered like I streamed it, then you don't know the truth. You only know their narrative they want you to believe. Looks like they're all getting started again. I'm going to go ahead and transition the screen back over to them and get quiet on my end so that we can hear what they're saying.
Mr. Miller, are you there?
I am, Judge, and I've got two sites for you that I found during the 10-minute break if you're interested in hearing them.
If you'd like me to consider them, yes, then please give them, and I'll take a look at them.
So, U.S. versus Thomas, 571 F. 2nd, 285, page 288, Fifth Circuit case 78. The documents proffered by.
Can you just give me the citation one more time, please?
U.S. versus Thomas, 571 F. 2nd, 285, page 288. It's a Fifth Circuit case from 78. The documents being proffered by plaintiff can't be used against a party who didn't make the statement except as exculpatory. And then Colonial 10, which is 887 F. 2nd, 1236, which is the Fourth Circuit case from 89. The court there just merely took notice of the fact of a guilty plea in that case. So again, short notice, obviously 10 minutes, but those are the two authorities we found, the first being more important than the second.
All right, can you just repeat the second citation for me? My handwriting is, when I'm writing fast, is not the best always. So can you give it to me one more time, please?
Sure. Colonial 10, 887 F. 2nd, 1236. And that's a Fourth Circuit case from 89.
Okay. All right, I'm just going to come back on then at 12:25.
Okay, Judge, and I'll just call back in again.
Thank you.
Wow, that was like literally fast and sweet right there. If anybody that is watching right now caught how long they said they were going to be, please put it in the comments right now. Oops, forgot to turn off down the volume back on the phone there again, the one that I'm monitoring this broadcast with. As we were at before this all got, it looks like the judge is now having to take a further review upon the documents that the prosecution decided to just throw right on in there at the very last second. And Miller has brought up some remarks in regards to the content of a couple of those right there, or so what was in it. And now the judge is reviewing those few cases that he's already thrown up. It sounds like objections to. take a moment, like I've been saying since day one, like, share, subscribe, click that bell, make sure you get notified every time we go live. YouTube is doing a great job of making sure you receive that notification. Facebook is hit or miss. I mean, they literally, like, I'm subscribed to the Michael Dukes Show. I've been watching them for years upon years upon years. I've been watching him. And every morning I would wake up, I would open up my phone, and there would be the first thing I would see on the outside of my phone before it's even open, a notification that he was live. I have not seen a notification come through for the Michael Dukes Show in almost a month now. My YouTube notification, though, is sitting there on my screen telling me he's live. So that just gives you a concept. This comes in at 6 o'clock in the morning. That's usually when I like to start my day. I'm actually usually even earlier than that because of the work I do. It just depends upon the day. But here we are. We're waiting for them to come back again. And again, if anybody saw what time they said they were going to come back at, please let me know. I'm looking at the comments right now. 12:25. Okay, so that means we've got 8 minutes to kill here. What do you guys want me to talk about? Where are we standing at right now? Throw something into the comments there. I'm more than happy to cover any subjects. The Michael Dukes Show, the second hour there, well worth your time to watch. If you want an explanation of what is happening financially within our Alaska school districts, specifically targeting more along the lines of in Anchorage, and where the money is going, how much is being spent per student, how one class of student can get nearly $100,000 applied to them per student. I think he said it was like $72,000, $78,000. I bookmarked that particular video because I want to go back, and I'm thinking about just jobbing the last hour of that, of him talking, just to make it a video all on its own, because he really did do a good job breaking down, exposing what is going on within our school districts and where all the money is going. Did you know that they are expecting in the next year or so that the school district just in Anchorage alone is going to have 5,000 less students in it? On top of the 5,000 to 6,000 they lost this past year, over the last decade, as they claim. If you take a look at that, they got 5,000 more students that they're going to be losing. The big town halls, the 6 of them that they had there in Anchorage about the 6 schools being closed, and going to each one of the schools and listening to the crying tales of the teachers and the parents. And I went to the very last one of those, and I really have to chuckle when it comes right down to that. I gave testimony, and boy, the teacher that testified shortly after me, she was offended at what I had to say about they just need to close all 6 of them down. We've got the worst schools scores in the nation. We are the worst in the nation at nearly triple the cost. What's the point of having all of these schools open? Close all 6 of them down, consolidate the students, use that money that you're going to be saving right there and put it towards the students and actually provide a quality education. There's the raises you guys are all screaming for. Problem solved. She didn't like that. And then I also said maybe they need to start passing more policies like they see happening in the Matt school district right now, and rechanging some of those equality, diversity, inclusion, and equity policies that have been forced and rammed down our throats. The different little things that they have changed and made unique now in Alaska for the Matsu Valley, because the rest of the Alaska population seems to be slow on the draw and doesn't want to take any action. They don't want to offend anybody. But don't cut our funding. Don't cut our funding. So back to the Kowalke and Eastman case. I know that is why you are all here watching. And it is just absolutely sickening watching how they are trying to paint the narrative that you are guilty by association. You belong to an organization that automatically makes you guilty for the actions of anybody, doesn't matter who it is within that organization. And that's what they're doing here. They're trying to claim, because he is a card-carrying member of the Oath Keepers, that he is guilty for the actions of 33 or so people at the Capitol on January 6th's actions. that he is guilty for that. He belongs to an organization that is 38,000 people strong. And they are trying to say the actions of those 30 plus people on that day is all the fault. Every single person that is a card-carrying member of the Oath Keeper, all 38,000 of them, are guilty by association of being domestic terrorists because of those 33 plus people that are under convictions right now, or 38 people, somewhere in there. And it just kind of, the number, I mean, I know if I say 30 plus people, I'm safe. Because when they were talking about all the private messaging going on with the Oath Keepers and everything else, that number jumps over 60. But is that anywhere close to 38,000? Anywhere close? Their Facebook page has over 500,000 followers on it before it was taken down. Just to give you a concept, but there's only 38,000 members. And they tried to bring the Facebook page in as here's an equivalence. Look at what's going on. Look at how much influence they had, so on and so forth. So whether or not everybody that they want to claim that was there, and then they want to take the actions of thousands of people, and I believe it was just a little over 1,000 people that had actually entered inside of the Capitol, but forget about the near million people that were outside. So 1,000 inside, 1 million outside. The actions of those 1,000 inside makes every person, all 1 million on the outside nearly, guilty by association just for being there for those people's actions. It just makes me really just shake my head. Let me see which people I'm seeing messages popping up here on the screen. So give me a second. Let me read what's going on here. Budget proposal at 1 o'clock. Okay. Well, hopefully I'll see about trying to get that one live streamed back out here on the channel. Not sure if I'll be able to do that or not. Depends on this court case that's happening right now. But we'll see. It looks like they'll have them going to lunch maybe at that time. Homeschools get funds. Our schools now allowed to roll over funds. We have to give itemized lists for what our funds go to. Agreed. They should be given an itemized list of where every penny is being spent within our school districts, because rolling it in, it's like on the Duke show this morning, they were talking about they had a $68 million shortfall that they needed to come up with. This is what they told us during their 6 town halls for the 6 school closures that they had there in ASD. Yet miraculously, overnight, they found $20 million. Now they're only $48 million shy. Excuse me, of covering their budget this year. So miraculously, somewhere they came up with $20 million overnight. So the big Crimea River, oh my God, scenario that they were playing out just prior to election to help sway people's votes by NEA had a lot to do with the outcome of the way our elections played out this time around. Whether you believe it or not, if you don't believe it, you need to wake up. Our elections are bought and paid for by the special interests, the unions, the NEA, the Alaska government themselves. These people are all part of the unions. They are 80,000 strong in Alaska. And if you just look at just the, and when I come up with 80,000, I'm throwing federal in there, not just local. And it boils down to these 80,000 government employees, the 60,000 union for AFL strong, the 20,000 NEA strong union members. All of these folks out there are buying our elections. $500,000 of the Vote No campaign came from NEA. I mean, 1630 Group, located out of the lower 48, same people that I wouldn't be surprised if some of the money that's funding the Kowalke case right now for their prosecutors that is currently happening didn't come, part of that money came from them. I mean, Kowalke's been involved in just about everything out there that I can believe that you can think of. I mean, make the assumption and that everything I'm about ready to say is correct. He is involved with the Vote No for the CON-CON. He's involved with the Vote Yes for ranked choice voting. He's involved with every bad policy from the recall Governor Dunleavy campaign that has gone on out there, directly in the middle of all of that kind of stuff, and is the instigator in coming up with the funding and the money to do all of this. Worked for Walker. I mean, these are all things that I'm making assumptions here, but I believe all the assumptions that I'm making currently at this moment in time happen to be 100% accurate and true. We'll just have to do the research. I know Must Read Alaska and Alaska Watchman has done a pretty good breakdown, especially the money that's paying for this current event there for this trial right here. The money that is coming in, just follow the paper trail. And the money that is financing this is very far left-wing establishments that have millions and millions of dollars to file lawsuits like this against individuals that have to pay for it themselves. Eastman's case has now already cost David Eastman personally $100,000 to fight. If this goes all the way to the Supreme Court, this could range up to $300,000 to $500,000 for his court case. And as long as he wins, he might be able to get all that money back after filing another lawsuit to get that money back for falsely having pursued for these charges that was brought by a very disgruntled ex-constituent of Eastman whose feelings had been hurt. That's pretty much what this case is all about. This is a vendetta. As one of the bars that I drive by, and I say that because they're on the main highway, they got a billboard on the outside, and they said, Kowalke has a bromance going on with Eastman. Maybe he needs to rethink where his life's objectives are. And that's kind of the way that things stand nowadays. We really, really, really do got to work on trying to straighten things out and getting things cleaned up. Takes activism, positive activism, each and every one of us every day doing what we can to get the word out, to make sure the message is being spread. If I'm live, it's usually for a darn good reason. I don't go live just cause. I go live because I believe it's something that is of great importance to all of Alaskans to know. Every once in a blue moon, I do it just cause. I won't deny that. But majority, 99% of the time, if I'm live, it's because I'm streaming something all Alaskans need to be paying attention to. Whether it's protecting our PFD or doubling our motor fuel taxes down there and so on and so forth. If it is of great importance to all of Alaskans to be aware of, I'm there directly involved. I see them popping back up on the screen there in my browser. I am going to quickly get that one turned back on here and flip it over so that we can hear what they have to say.
All right, we're back on record with the parties present. I can see Mr. Dedukian and Ms. Harrison. I also heard Mr. Miller as I was coming in. Mr. Miller, can you hear us?
Yes, Judge, and I did find a Supreme Court case during our break. If you would like to hear the site on that.
If it's something you want the court to consider, then yes, I'll certainly take it.
It's Bruton versus U.S. 391, U.S. 123, and this quote is from page 141. Let me mute my, it is muted. I'm getting a little bit of feedback. This relates directly, the quote that I think is relevant to the court's decision. As to the defendant, the confession of the co-defendant is wholly inadmissible. It is hearsay, subject to all the dangers of inaccuracy, which characterize hearsay generally. Furthermore, the co-defendant is no more than an eyewitness, the accuracy of whose testimony about the defendant's conduct is open to more doubt than would be defendant's own account of his actions. More than this, however, the statements of a co-defendant have traditionally been viewed with special suspicion. And part of it's, of course, confrontation. The right of confrontation is eliminated by the admission of a document of that nature. Obviously, most of the case law that you find that relates to this, as I'm sure Your Honor has already found in the truncated time that we had to review it, it kind of rises out of the criminal context. But the same rules of evidence would apply even to this particular case, even in the civil context, and we'd submit that this particular decision should bear on the court's decision as to whether or not to admit the exhibits in question.
Okay, I'll certainly take that argument. I'll have a look at the case. But Mr. Miller, we've sort of reached a point where just looking at the clock, it's 12:30 you're telling me that you have a witness that's only essentially available at 1, and that we're going to need to make sure that they're available at that time. After I make this ruling, also, I understand you want to make your motion following the conclusion of the plaintiff's case. Just timing wise, it looks to me like I'm going to have to take a look at this case, come back, make a ruling, then you make an argument, then I make a ruling if we want to do this in order. I don't think we have time for that. Plus I'm sure people are going to want to get some food. So what I'm going to propose is that we essentially take a break until 5 to 1, see if we can get your witness. If that works out, we go through the witness, Mr. Rhodes, and then we return to the legal issues that are in front of us. But if I've got additional citations to take a look at and then make a ruling, and then we have additional argument, I just don't think we're getting through that in time for your witness.
Okay, and Judge, what I'd ask, again, the burden is not, I'm sure Your Honor is going to agree with me on this particular aspect of us starting our case before a decision is made on plaintiff's case. We can't use the information that comes out of this first witness to help plaintiff meet his burden. And I guess, and this is one of the reasons why I suggested a couple of breaks ago that Your Honor allow me to do my argument. We can assume that Your Honor makes a decision to admit the exhibits for the truth of the matter asserted. Again, we object to that, but for my purposes of argument, we can assume that. That way we can move along, court can make its decision, maybe before, maybe after Mr. Rhodes testifies, but I don't necessarily think that these exhibits, and maybe I'm misperceiving the importance the court applies to them, are necessarily going to foreclose our position that the court should close the case now under Rule 50. So anyway, I'll submit that to the court. Again, we are not waiving on these exhibits. We believe they should not be admitted for the truth of the matter asserted, but I also believe that I can make a persuasive argument in the event, just assuming for sake of argument, that they come in.
Okay. It might be helpful. Could you just let me know that 391 U.S. 123 case that you cited from the U.S. Supreme Court, was that a criminal case? It sounded like it was.
It is a criminal case. It is. Yes, it is. 391 U.S. 123. And the page that the quote comes from is 141.
Okay. I think the safest thing then is if you can make your motion, I will endeavor to get you a ruling prior to when Mr. Rhodes becomes available. So if you want to address that now, assuming that the statements come in that were requested as against penal interest, then you can make your motion.
All right. So assuming the court rules against us and they get admitted, it doesn't really change the thrust of the argument. This is plaintiff's burden. I don't think that Kowalke will dispute that. And it's not just a matter of showing whether or not the Oath Keepers is an organization that advocates by truth or violence to overthrow government. It's a much narrower standard than that, as Your Honor's already found in granting our motion, or at least part of our motion on summary judgment. The key provision from Brandenburg that we direct the court's attention to, and this is Brandenburg versus Ohio, 3985 U.S. 444, page 448. The constitutional guarantee that free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. The mere abstract teaching of the moral propriety or even moral necessity for a resort to force and violence is not the same as preparing a group for violent action and steeling it to such action. A statute which fails to draw this distinction impermissibly intrudes upon the freedoms guaranteed by the First and 14th Amendments. It sweeps within its condemnation speech, which our Constitution has immunized from government control. So, the active words or the operative words are incitement to imminent action. And it's not just lawless action in this case, because we have the additional restrictions that the constitutional provision, Article 12, Section 4, requires that it be action to overthrow government. So that's basically the context on which the court has to evaluate the evidence that's been provided by plaintiff. So it's plaintiff's burden, and the only way that plaintiff can get to where he's getting is to conflate Stuart Rhodes with Oath Keepers. That's it. He has to do that. The other supposed or alleged bad actors that were part of this small group of 50 to 60 people on the Capitol from Oath Keepers on January 6th, they weren't the vectors for the advocacy. It was only Stuart Rhodes, at least allegedly. by, again, the evidence produced by plaintiff. And I think I should also note, just by way of argument, our position is that introducing fact witnesses by experts isn't appropriate. In fact, we believe that none of the facts adduced by the experts should be admitted or considered by this court. The only fact witness the plaintiff had in this case was Representative Eastman himself. And of course, Representative Eastman in his testimony really didn't help them get to where they needed to be to satisfy their burden. So again, getting back to the point, you got to conflate the organization with Stewart Rhodes. Well, let's look at the organization first apart from Stewart Rhodes. We know that there are bylaws, and we know that those bylaws are reflected at Exhibit U. That's an admitted exhibit at this point. And the bylaws of the organization make it very clear that this is a group of people, and this is Section 8.05, which conceded by plaintiff as part of the organization. Now they claim, hey, the organization is not the bylaws, but again, no accepted or expert that really is experienced in that area. But notwithstanding, the bylaws are the vector by which the members of the organization understand their membership. The interesting aspect of how this advocacy allegedly occurred was through an invitation-only chat group. We have that on record from their witnesses, again, assuming the court considers that information for the fact of the matter asserted. The reality is that wasn't a broad-based communication tool. That was one that was limited to a few people, 50 to 60 at most. It did not go to the group as a whole. The other communications that occurred that the experts that plaintiff had testify told the court about were also limited. You have before you, Your Honor, the communications to the organization as a whole. Those communications, none of them point to any type of, they could not point to any language in any of those communications, any of those emails, even the webpage postings that reflected any type of incitement to imminent lawless action, let alone imminent action to overthrow the government. None of those communications occurred. So again, in order for them to get to where they're going, they have to conflate Stewart Rhodes with the organization. And not only that, they also have to conflate with that the communications that Stewart Rhodes gave to a very limited number of individuals that were present on Capitol Hill on January 6th. Now, I'd submit, Your Honor, that even those communications that were provided don't even provide evidence of incitement to lawless action. Again, what these experts have done is created this amalgamation. They try to aggregate everything in general and point to all these bad statements that were made, at least in their view, bad statements, bringing together this kind of amalgamation of items to say that, hey, in general, what they're really doing is advocating for the overthrow of government. Actually, they haven't done that at all. What they've shown is that you've got, partisan people that believe government should go one way and not the other. In fact, at one point, expert Kreiner made the comment that, the people and Oath Keepers wanted to change the government. Well, that's what voting is. That's what the political process is. And I'm not suggesting that any of the violence on January 6th was part of that process. But the fact of the matter is that, yes, the people in Oath Keepers, including the small group that were on Capitol Hill at the time, they had opposition to the incoming Biden administration. But that's not the standard here. The standard is, did Stewart Rhodes or did the organization, Oath Keepers, incite not just to violence, but incite to imminent overthrow of government? Never happened, of course. We know that. And we also know that even as to the actions that took place, that you can't construe them to overthrow government. Expert Kreiner admitted that they were tantamount to overthrow of government. They couldn't even get their own expert to say that it was overthrow of government. That's not what the advocacy was about. And again, Your Honor, going back to the communications to the group as a whole, the 38,000 or, depending on which expert you rely on, assuming that you admit that evidence in your consideration, the 10 or 20,000 members, those communications said, look, we're on Capitol Hill because there was fraud in the vote. This was said consistently in the communications that we have before the court, or the plaintiff has before the court. They were concerned about vote integrity. They wanted to delay the certification for purposes of getting to the bottom of vote integrity. That's why they were there. That was a stated reason. Now, whether or not you read into this some sort of untoward purpose that was communicated in this small insular group by invitation only that were communicating, that's another matter. But even those communications, I would submit to
Mr.
Your
Miller,
Honor,
at least on that point, Mr. Miller, I'm sorry to interrupt you, but at least on that point, you mentioned reading into, it would be helpful as part of this to to make sure that we're on the same page as far as the standard here. On a Rule 50 motion, are and I required to view the evidence in the light most favorable to the non-moving party? So when we're talking about inferences, don't I need to read into it essentially what would be, or view it in the light most favorable to what's been advanced by the plaintiff?
Well, it has to say it, though, Judge. I mean, that's the standard of Brandenburg. You can't make inferences, okay? So even if there's a motivation out here, we're talking about advocacy, Judge. Advocacy is the spoken or written word. And so in these communications, you have to look at them. Yeah, I mean, I think giving the evidence, deference due under a Rule 50 motion, you have to assume that, yeah, these were actually communications that came out from the Oath Keepers, that came out from Stuart Rhodes, but you can't read into them. I mean, I think giving deference to plaintiff is saying, okay, I'll concur. They came in through your experts. These are accurate communications, but you have to find in them the advocacy. Advocacy is not motivation. Advocacy is not what they're thinking. Advocacy is statement or it's oral word. And so you have to find those in the record. And there are no such written or oral statements made in the record bringing anyone to imminent incitement of overthrow of government, let alone imminent incitement of violence. I mean, you can't even see it. You can't find anything in the record. Again, we're using that term broadly, a record admitted by experts, not fact witnesses, but you can't even find anything there besides articles written by Kreiner or Lewis themselves that say anything about Stuart Rhodes having anything at all to do with having people go into the Capitol itself. Now, he was there, and of course, what the communications reflect, there are all sorts of extreme statements made. But again, the standard is imminent incitement of lawless action, and of course, in the case of Article 12, Section 4, it has to be to overthrow government. We don't get to the first step, and we're nowhere close to the second step. One of the things that I would note too, again, what the focal point has been, and I touched on this earlier, from the perspective of plaintiff, the entirety of the group should be guilted by the actions really of one person, because again, we're talking about advocacy. It's not the other Oath Keepers that were purportedly involved and that were involved in the violence on January 6th. Again, we're talking about the group, according to Lewis, of 50 to 60 people. I think Kreiner said it was 50 people. And then of those, we have 33 that were, according to them, Oath Keepers. That we go forward with our case, and actually not 33. But the reality of it is a very small percentage. Now, one of the things that they tried to say is this was tantamount to the overthrow of government. Okay, so the Oath Keepers at best had 50 to 60 people present on Capitol Hill on January 6th. How many people, according to their experts, were charged, indicted? There were 900. So less than 4% of the people that were even charged, less than 4% were the Oath Keepers. So were these 4% trying to overthrow government? I mean, they never even had guns on the Capitol. Of course, again, taking at face value the communication that were submitted by plaintiff here, why were the guns anywhere close to the Capitol? They were there in case President Trump invoked the Insurrection Act. Yeah, it doesn't matter how far-fetched the theory is. That's what they said. That's certainly what was communicated, again, in their little insular group. If the Insurrection Act is invoked, then we'll have the firearms there. It wasn't to go overthrow the government. If it were, well, for crying out loud, when they went into the Capitol with a few people that from the Oath Keepers that went in, where were the guns? I mean, clearly not part of that plan. But again, going to the language, the advocacy, which the court has to focus on, there is no advocacy anywhere other than the fact that, and this is not advocacy, it's just a statement that, look, the QRF is there for the purposes of if we're called up. And then the statements made to the organization at large, as the actual put writ large, those statements were all, we are trying to ensure that we have vote integrity. And absolutely, I mean, assuming the court, I think under the standard Rule 50, you accept these statements as written. You say you accept that they are from Stuart Rhodes. I think that those things the court has to consider as part of its decision-making under Rule 50, but none of them anywhere. There is not one. In fact, let's just take a look at one of the exhibits that was focused on by the plaintiff's counsel in the questioning with Mr. Eastman, and that's Exhibit 7. The purpose, I think, primarily of that from plaintiff's perspective was to demonstrate that Representative Eastman had renewed his membership, then inquired, hey, how does lifetime membership expire? But the language of that email, Your Honor, and if you look at it, we'll take a look at page 2 of 3. So it starts at 1, but there is basically a summary of what the Oath Keepers have been up to. And this is, again, one of these general emails that goes out to the Oath Keepers writ large. It says, with your continued support, know that your membership dues and donations are going to further our mission to defend the Constitution as we swore an oath to do, and also help Americans in need. In addition to our continuous outreach to current serving military police, Oath Keepers members have been instrumental in defending life, liberty, and property of Americans across the nation. And then it goes on. You'll note, Judge, that both these experts talked about the terrible things that happened in Ferguson and at the Bundy Ranch and, at the refuge in Oregon and some other things. Well, this is what the general membership is told. And we don't even have to get to our case on this, but this is what the general membership was informed. Quote, we stood guard on rooftops in Ferguson, Missouri to stop murderous arsonists from burning both occupied apartments and small businesses to the ground. We helped protect a ranching family from the overreaching BLM at Bundy Ranch in 2014, as well as helping to ensure the due process rights of traditional small claim miners at the Sugar Pine Mine in Oregon and again in Lincoln, Montana. Oath Keepers stood up in Washington, D.C., and so on. So what is being told to the membership is these are the things that we're doing. These are the good things that we're doing to defend your constitutional rights. And, of course, these are the same things that the Oath Keepers, when they joined, saw as part of the bylaws and rules of the organization, which, of course, there's no evidence before the court that those changed in any way. And those bylaws, again, I read part of them earlier on out of Exhibit U, make it very clear that you cannot, as an Oath Keeper, do anything to overthrow the government. I mean, it's specifically stated. And not only that, and again, let me just go or direct the court to the provisions. We looked at 805 earlier. Let me go to Code of Conduct. There's a Code of Conduct and 8.04 regarding Oath Keepers and their compliance with the law. Restrictions on membership. Members include those that are currently serving or retired military, reserve, National Guard, can't be convicted of a felony, dishonorably discharged. It's stated in their rules and bylaws that, again, the membership of the organization had access to, that the membership of the organization believed to be the governing documents, including apparently the entity, the state of Nevada, where the entity was actually incorporated. There is an admission from the experts that these are, in fact, those bylaws. So getting to what the organization viewed, these were the limiting factors on the organization. Now, I bring your attention, Judge, to an admission made by expert Kreiner. When I asked him about different types of membership, if you recall, expert Kreiner said 85% true. He agreed that there were categories of people within Oath Keepers. You had the 50 or 60 that participated in these events, like the event in Ferguson, like the event at the Bundy Ranch, like the event at Sugar Pine Mine. And then you had, and like January 6th for that matter, and then you have the general membership. The general membership that understands what the bylaws provide, that read these emails that go out every so often, not very frequently, but every so often, stating the same sort of things that you see in Exhibit 7. And that's not a lawless organization. It's one where the oath matters. And the people that join this organization, it's called Oath Keepers for a reason. They take an oath. The oath is important to them. Your Honor, you took an oath when you were sworn in as a judge. And yet, the experts that are opining on this being some sort of organization that apparently all members should be painted with this broad brush of guilt by association because of a few bad acts of those that weren't part of any advocacy, by the way, to end the overthrow of government, he doesn't even understand why an oath is taken. That was near to the last answer he gave to a question on his cross. That Mr. he doesn't Miller, know why people
Mr. Miller, I need to interrupt you just briefly here. I'm I want to be cognizant of the time, and you've told me there's a certain point where your witness is only available. It's up to you whether you want to continue with the argument that you're making, which is certainly helpful, and I want to give you a chance to make your motion, but recognizing too that Mr. Dedukian has an opportunity to respond, and I don't know if the division's going to also want to make argument or its own motion at this point either. And so, we're 10-1. You told me that at 12:55 you needed to be making sure that Mr. Rhodes was available if he was going to be. So I'm bringing that up to you now and make a decision on what you want to do.
Even with the evidence construed for the plaintiff judge, they haven't met their burden, and so the claim should be dismissed as to against Representative Eastman. Thank you.
And before you finish up, and I'm hearing you do it, but I just want you to know it's only fair that I give a fair amount of time to the plaintiff to make a response, and they're not going to be able to do that before 1 o'clock. So do you want to?
Understood.
Okay, so do you want to take essentially a break at this point, just sort of a rest in place to see if you can get Mr. Rhodes available?
Well, I mean, I prefer to hear argument by Mr. Dedukian, and we have to cut short Mr. Rhodes' testimony a few minutes, and so be it. I mean, assuming that if the court makes a decision against us, but I think this is an important issue about the burden, whether or not it's been met.
And I agree, and I'm telling you, I don't think I can make that decision in the next 9 minutes, and I certainly don't think I can make it, and I can require the plaintiff to give a very short response. I need to give.
I think Judge.
So I'm telling you,
Your Honor,
if your witness is
that, Your Honor,
available at a certain time, you need to make a decision if you want to call them now or not.
Well, I don't think I can. I think we have to wait for the court's decision on this, and so I know he's not going to be available tomorrow. We may be able to get into him a little bit today. And I guess there's a remote chance we could get him in on Monday or Tuesday. But I think Your Honor needs to make a decision on this motion. So.
Okay. All right, Mr. Dedukian, are you prepared to respond?
Yes, Your Honor, I am. Thank you. And I want to go back to the two elements that you had set out and the two elements that I had discussed in my opening statement, which is what we need to show to win the case is one, that Representative Eastman is a member of the Oath Keepers organization, that he aids or belongs to the organization, and that second, that the organization engaged in actual conduct or advocated concrete action to overthrow the U.S. government. And again, I think the evidence that we presented throughout this trial is very clear on the first element, which is that Representative Eastman admitted yesterday that he is a founding lifetime member or paid for a lifetime membership to the Oath Keepers, that he is still a member as of today. He has not taken any steps to resign his membership or disavow any association with the Oath Keepers, or even disavow the actions of the Oath Keepers that he subsequently learned had entered and committed violent acts inside the U.S. Capitol. So I don't think the court even needs to draw inferences as to the first element. There's an admission from Representative Eastman that he is an Oath Keeper, and that satisfies the first element that the court set out. As far as the second element goes, Mr. Miller started with a reference to Brandenburg. I think if we're going to start with the First Amendment standard here, whether the conduct and actions of the Oath Keepers was protected by the First Amendment, we're not even close to any kind of line between protected and unprotected speech. To quote Mr. Miller, he said that, and also the court recognized this in your order from last week, that the distinction is between abstract teaching on the one hand and words that are likely to lead to action to overthrow the government on the other hand. Here, there's no question that that there was going to be likely conduct or likely action, because we know that there was actual action by the Oath Keepers on January 6th to overthrow the U.S. government. And before I go any further on that, I just want to address the argument made by Mr. Miller today and kind of throughout trial about whether or not delaying certification of the vote is the same thing as overthrowing the government, or other suggestions were made that they were just getting to the bottom of vote integrity. As Mr. Lewis, I think, he hit the nail on the head when he said, if you're trying to get to the bottom of vote integrity, you don't go chasing after Nancy Pelosi. So it's clear what and these were admissions made by the Oath Keepers who pled guilty to seditious conspiracy charges, that they were there for one purpose on January 6th, or their actions in entering the Capitol building was intended for one purpose, and that was to stop the transfer of presidential power from Trump to Biden. And they also admitted that when they were in the Capitol that they used force. They also admitted that they assaulted and intimidated government personnel. So all of those things are they're clear conduct, they're not words. And there's no question that they engaged in seditious conduct that goes well past any line of First Amendment protected speech. And I don't see how Representative Eastman can draw a distinction between preventing a legitimately elected president from coming into power and overthrowing the government. The natural effect of what would have happened if these Oath Keepers succeeded on January 6th is that President Biden would have been kept from power and President Trump would have continued in some sort of dictatorship as the leader of the United States. And there's nothing in Article 12, Section 4 that requires an insurrection or attempt to overthrow the government to succeed. There's nothing that requires the people trying to do it to be competent, to do it in a way that's going to be successful for sure. All that we need to show, and I think the Dennis case from the Supreme Court is instructive on this point, even threats or conduct aimed at future attempts to overthrow the government are considered unprotected by the First Amendment. And so again, just because, first of all, Donald Trump was not the government on January 6th. He was a part of the government. The government has multiple branches, one of which is Congress, and that's who was under attack on January 6th. And again, if these insurrectionists had succeeded, they would have stopped the transfer of presidential power. I don't think there's any way the court can say that that's not an attempt to overthrow the government. As far as conflating Stewart Rhodes with the Oath Keepers, or why the actions of Rhodes himself are so important, I think, again, both experts really explained why that's the case. I don't think it's possible to separate Rhodes from the Oath Keepers any more than it's possible to separate Adolf Hitler from the Nazi Party. I think the interconnectedness is one and the same. And some of the reasons for that, first of all, is that Rhodes is written into the bylaws that Mr. Miller likes to talk about as the founder of the organization, board member for life, can only be removed for very limited circumstances. He has veto power over board actions. Both experts talked about how he had his hands on basically all of the national operations of the organization. He used the infrastructure of the organization to get his message out, including posting messages on the website, emails to membership. He set up a hierarchical organization with lieutenants like regional and like state and county level leaders of the Oath Keepers who played prominent roles in the January 6th insurrection. And I think if you look at the testimony was, and Representative Eastman talked about pictures that he's seen of the events that happened on January 6th, it's clear that this was an operation under the flag of the Oath Keepers. They were prominently wearing their Oath Keepers logos. Nobody would have mistaken the fact that this was an Oath Keepers operation. As far as the bylaws and whether they're significant or not, I think the court already early on in this case recognized that bylaws might be one data point. They're not the same thing as the organization, and the organization is defined also by its actions, and those are the actions that we've been talking about. There's also been evidence presented to the court that whatever bylaws that the organization had were essentially a front, a legal cover. They've never been consistently enforced. Mr. Miller likes to point out the fact that the bylaws prohibit felons and certain members who've committed crimes or tried to overthrow the government from staying as members of the Oath Keepers. Well, we now know that there's been 3 Oath Keepers who pleaded guilty to seditious conspiracy and 2 that were convicted by a jury. Representative Eastman reached out to the organization to find out if they've been removed from the organization, and the information that we have is that they have not. There's no evidence whatsoever that those bylaws, those provisions of the bylaws were actually followed. And just to briefly wrap up, I want to just respond to a few different points that Mr. Miller made. I think he drastically mischaracterized the communication network of the Oath Keepers. He said that it was only by invitation only chat groups. That's absolutely untrue. I've already talked about different ways that the message was communicated. The best evidence of that is Exhibit 14, which is the national call to action that Representative Eastman admitted that he received. If you look at Exhibit 14, the 2 open letters that the court has admitted into evidence were hyperlinked on that email. So I don't think there's any doubt or any question that the message of Rhodes about bloody revolution, fighting no matter what, if the president doesn't invoke the Insurrection Act, was being broadly disseminated to everyone who was a member of the organization. I don't think any member could honestly tell the court that they had no idea that Rhodes was saying these things. The Insurrection Act was brought up. I think it only suffices to say that if you look at Rhodes's communications themselves, he himself recognized that there was a possibility that the Insurrection Act would not be invoked. And I think it's important to look at those communications and see that it was always a plan A and plan B kind of situation where, of course, the Oath Keepers preferred for the Insurrection Act to be invoked, but they also recognized that they were going to fight either way. Like I said in my opening, they were going to fight either with or without Trump's support. And so I don't think it's a fair conclusion for the court to draw that they were only there with arms and in QRFs just in case the Insurrection Act was invoked. As far as guilt, I think the word that Mr. Miller used was guilted by association. There's no question of guilt in this case. This isn't a criminal prosecution. Nobody's trying to send Representative Eastman to jail. It's just a matter of applying the qualifications that the founders of the Alaska Constitution came up with. So there's no guilt here. And as far as association, even sitting in court today and acknowledging the actions of certain Oath Keepers, even if he didn't want to condemn the Oath Keepers organization as a whole, Representative Eastman even refused to condemn the individual Oath Keepers who committed violent actions on January 6th. And then lastly, and this is by no means in order of importance, just in the order in which Mr. Miller presented them, he said that our expert, Matt Kreiner, had admitted that there were different categories of members or membership in the organization. Some people showed up to mobilizations, some people provided support. There were different categories of membership, but that's completely irrelevant because he also explained that that's a typical structure of any extremist or terrorist organization where they're the foot soldiers who mobilize and commit the violent acts. And then the rest of the membership that either does the coordinating and planning or provides support or just chooses to associate with the organization. So for all those reasons, I think, again, with the 2 elements that the court has set out, I don't even think we're close to the line where the court would just grant a directed verdict. So the court should deny the motion and let the trial continue.
Understood. Ms. Harrison, turning to you, does the division have a motion or a position on the motion that's been filed?
No, Your Honor. As always in this case, the division remains without a position on the substance of these claims, and I have no motion to make now. I will let the court know I'm thinking about a Rule 50 motion at the close of both parties' cases, but not at this time.
Okay. Thank you. All right, we are at 1:05. Mr. Miller, I understand that your hope is that I'm going to make a decision on this immediately and that we have time for Mr. Rhodes' testimony. I'm going to tell you, there's a lot to consider here, and I've got a lot of documents to take a look at. I don't think I could give it a fair consideration if I didn't take some time to prepare for it and then go through the arguments of the parties on both sides. So I'm going to ask you now, do you want to try and call Mr. Rhodes at the moment? Or do you want to have, essentially we take our lunch break, it's 1 o'clock, and we come back after I've had a chance to consider this and then move forward if that's where we're going.
Judge, how long do you need?
I'm probably going to need it at least until 1:30 to go through what's been admitted, take a look, compare them to the arguments by both parties, and then apply them.
Yeah. Judge, I think that what's going to happen is that I think I've got to wait on Your Honor's decision. Mr. Rhodes should still be available at the bottom of the hour, but likely, given the desire for cross on him, we're going to have to find a different time anyway. We know he's not available on Friday. I mean, if the court requires us to go forward, this case is going to continue into Monday. I can just already tell you that based upon planning with our witnesses. So I don't know what the schedule is on Monday and whether we can get him back in then or not. But I think what we should try to do is get started again at 1:30. If Your Honor decides against us, I guess, the issue here, Judge, is that we'll just have to try to find the time. And I'm not in control of that. The U.S. Marshals are, so.
I understand it. I want to give you the opportunity. If he's available now, it's
but
bird in the hand.
Judge, I think, right. Can we just take maybe a 5-minute break and then go back on, Your Honor, and let me just make some calls?
Sure, let's do that. So we'll come back on at 1:13.
And Your Honor, before we do
Okay.
that, I just want to say that we would request at least equal time with him. I don't want to have a situation where our cross-exam is artificially limited in time. So I just want Mr. Miller to be aware of that.
We'll address that.
And I think
let's get some info. So
Okay.
we'll come back at 1:13.
Remember to turn off my phone this time before I actually begin talking. All right, they're going to be back at 1:13, so we're talking, 7 minutes from now. So we've got to hear the closing arguments, excuse me, opening arguments of both the defense and the prosecution. They're here right now. This is whether or not to continue on to the defense's side of the case. Miller has put out his defense saying that the plaintiff has yet to ever even bring forward anything that should say that this case should be brought forward. All the charges and allegations that they have brought against Eastman should be dismissed outright, that the only thing that they have proven is that other people did bad things that Eastman is not responsible for and never should be, and those actions of those few bad apples out there have nothing to do with him. That is all that I have heard so far out of this case, but it's up to the judge now. He is going to be reviewing some documents. They have a witness that I believe, don't quote me on this, but I believe that is incarcerated right now, that was there on January 6th and is incarcerated because of that and has only a very small window to be able to testify. And that's why they're trying to do this hurry up along right now for the next 6 minutes, as they try to determine what to do to move forward because of all the exhibits at the very last second the prosecution had put down onto the table when they rested their portion of the case, getting ready for the defense to get started with theirs. And Miller is right now advocating for this case to be outright dismissed as a waste of time, and that the prosecutors have yet to ever bring forward anything that means that this case should move forward. And if you've been watching since day one, which I have, my opinion, my own personal opinion right now is this case should be dismissed. The expert witnesses were nothing more than hearsay opinions. It was what they thought or think things should be, not what it actually was. And that is, we shouldn't be determining what is going to happen here just because of that. And Hopefully you guys have all been hearing me pretty good here. I've just got my other feedback up and running here. So we're now 4 hours into today, and the witness is only available between 1 and 2, so that's why the judge is doing an expedited review over some more of those documents, those last second documents that was handed out about an hour ago, and that the prosecutors wanted to have put into as exhibits as why this is how they're going to convict Eastman of these bogus charges. Our freedoms, our liberties, our way we think, who we organize with, who we associate with is all on the line right now. This case has more to do than just with David Eastman. It has everything to do with each and every one of us. When they get done here, there is nothing to stop them from targeting the rest of us if this case makes it all the way through to what I would classify as what you'd call the conviction. And the whole conviction in this one is David Eastman will be removed from his legislative office because the courts are going to declare that the overwhelming votes that he received in this past election, his constituents' voices and votes mean absolutely nothing. That they don't have no say who represents them. The judges and the whoever wants to bring a lawsuit against whoever they think that their feelings have been wronged wants to, will be the determination of who gets to represent them and who doesn't. And all of that is on the line. When they get done here, who's to say they're not going to go and start next and say go after Senator Shower, Senator Hughes? You know, they don't like anybody in the Valley. What's to stop them? Myers, right after that. We'll just go with the Senate minority right now that has no legwork, no leverage whatsoever in this up-and-coming next 2 years of sessions because of the way things have been aligned. It's just, it's atrocious that we keep electing what we call Republicans into office, but Democrats control everything. And the ones in the finance committees and the ones in the House committees control everything. And they dictate what the rest of the body in the House and the Senate is going to vote on and what's going to be in it. And they're the ones that work directly with the special interests. They're the same names, same faces in control of those committees year after year. This is why nothing ever changes, because they control the purse strings. They control everything that's flowing in and out of that location. And it's not going to end until we change who's there or change the laws, which the con would have been able to do. But those same people in power, the ones that are in power right now, had big financing from out of state. All of them use that money to convince Alaskans that you're opening Pandora's box. Just ignore that the Pandora's box has already been open for a very, very long time before this vote for the con ever occurred. I see a black screen showing up there for the trial. And so that means that they're getting close to bringing people back online again to their Zoom, and they'll be resuming after the judge has had a chance here to review. And cross our fingers, maybe we'll get lucky and this thing will be completely dismissed at this point, that the judge is not aligned with the agenda and actually wants to follow the rule of law. I believe the prosecution has not brought forward their case. They have not made or brought anything that is factual that would say David Eastman is guilty of what they're accusing him of, and this case should be completely thrown out under the merits of that it was bogus to begin with. Oh, I see the prosecutor's face there just popped up on the screen. He's moving over. Oh, there's Scott Kowalke. There's Miller. All right, let me get that turned back on here. I'm going to swap it over. I'm going to shut up. Like, share this video, subscribe to us, YouTube, Twitter, Facebook. Go to Rumble, become a subscriber. We reach 100 people. We'll be streaming live there too.
Who's on the line? Hear me?
Yes, I can hear you.
Yes.
I can hear you, but if you could join my.
All right, Mr. Miller, are you back on the phone so that you can hear us well?
I am, Judge. Thank you.
I see Mr. Dedukian's here, Ms. Harrison's here. Mr. Miller, were you able to get some information?
It looks like that that there still may be an hour availability that we can effectuate tomorrow. But the court and parties are going to have to be flexible on it.
And is it sometime in the morning, just recognizing the hours that the court system's open in the morning?
Again, I still don't have a firm answer on that yet, Judge.
Is he available right now?
Given he's not. In fact, he was supposed to be, and he's not. So, I mean, that's the short answer.
Okay. So what we'll do, if he's not available right now, then I'm going to take the time that I need to make a decision. And we'll come back at 2:00, and then we'll have to address when he's available going forward. Is there anything else any of the parties want to raise before we take our recess to eat and I can decide the motion?
No, Judge.
There you are.
Okay, so we'll be back at 2:00.
Okay, you guys all heard it here first, or there first, that they will be back at 2:00. The judge is going to take time to review all the closing arguments that they have just given there, and hopefully we'll get a verdict of dismissal, will be what he comes back with. If not, this case will be moving forward from there. There is currently one witness that can only be testifying telephonically, is only available for a very limited window. I'm not positive 100%, but I believe this person is currently incarcerated under the January 6 incarcerations that have occurred, and is given firsthand accounting that the prosecutors right now have yet to ever provide. In fact, their expert witnesses both admitted that they have never, and if my recollection is correct, they have never once ever talked to an actual oath keeper or any of the ilk that belongs, anybody that belongs to the Oath Keepers. And so they have no personal knowledge firsthand about them other than what they have read. And so it's all online, personal. I watched this video, I read this. It had nothing to do with actually interaction with any of them, actually getting first-hand accounting of what went through their minds that day and them in the Capitol. And so they're supposed to be experts, but they're experts of what? The narrative is about all I got out of it. That's what they are the experts of, spinning the narrative that they want you all to believe, want us all to believe. All right, democracy is on the line, as the Democrats would put it, and it needs to die in darkness. And I agree with that terminology 100%. Democracy needs to die in darkness. We are a republic. We are based on republic values. And we need to start treating our laws that we have within our nation under how our nation was built as a republic, not the democracy that they are trying to turn us into. Our elections are determined by ballot, not by bench. We need to make sure that our voices and our votes actually count. And they are trying to take that away with this case right here. David Eastman is the representative that should be down in the House for the next 2 years. His constituencies, their ballots, their votes, their voices, they resoundingly said who they wanted to go back to Juneau. They made it clear, and there should be no judge in the world that should ever be able to take that away, especially from someone that did absolutely nothing wrong. Absolutely nothing wrong. Nothing. They have not proven a single thing. They're trying to blame the actions of the 60 people involved, the 33 that are under convictions right now for the Capitol, and the other ones that they're working towards, and in that direction. There's only 60 plus that was actually in the main core of the group that was working for this out of 38,000 members. Only 60 plus actually had any access to the inside information that they're trying to accuse David Eastman of being a co-conspirator of. Somebody who hasn't for years had any conversation or connection to any of that. So they promised that they're going to come back at 3:30 there, or excuse me, 2 o'clock. 2 o'clock is when they're going to come back, and that's 40 minutes from now, a little less than that. And they will be back here. I have other things that I was already supposed to get to at this point. If you're not watching it already, take a minute now, step away from this broadcast. I am going to leave this up and running. I can run this stream all the way up to the very end of whatever they're doing, thanks to being able to do it straight from my studio here, and it makes it available to be able to just keep this running right on all the way through. But the governor has given his proposed budget, and he's announcing that right now. I received my YouTube announcement that it had gone live. I have not seen any announcements yet from Facebook, but at least YouTube has told me that the governor is live and is giving out what his proposed budget is. And as I like to tell all of you guys out there, please go subscribe to us on YouTube, Facebook if you're already here. Go to Politadick Unfiltered also, subscribe there. And then go to Twitter, YouTube, both at Politadick. And the last one is Rumble, and I should say that should be the first one is Rumble. As quickly as we can reach 100 subscribers on Rumble, as that much quicker we're going to be able to live stream to them directly. They will be our first one out there that we can honestly say will be unfiltered and uncut, and we'll be able to make sure that you receive your notification when we go live, just like YouTube will make sure you receive your notification. Facebook's no longer doing that. I don't receive notifications from anybody but who they selectively choose to let me see. Everybody else, there is no longer one, and I usually have to hunt and peck to go find those out there, and that's usually the case. But if it's something they want to make sure the 90% of the MSM out there wants to make sure you see, Facebook is make sure you get those notifications, but anything else, not reaching us. So again, like and share this video. They will be back at 2 o'clock, and that is the time that I am expecting them to be here. I will be back at that exact same time, and I'm just going to change my little splash here so that it matches what it says there on the that I just got done telling you. And like I said, I got a couple of things I need to go and take care of. I was expecting to have a lot longer lunch break, like an hour, not just a very short window there. And all right, that is done. And hopefully everything is lined up. And you guys, I will see you back here just before 2 o'clock. I'll definitely start talking again before they actually begin the next portion of this trial. We'll see you there here in just a little bit. Go take a break. Watch what the governor has to say. Hello, my fellow Alaskans. I'm back once again. The trial is just about ready to begin. Oh, crap. Ah! Quick, run! Left the phone across the room, volume all the way up. Heard my clicking everything on, and it realized I better get that shut down before it starts making noise and squawking there in the background. All right, we are live once again. The trial is about ready to resume. The judge is going to come back, and Judge McKinnon, and he is going to present whether or not he is going to dismiss this case on the merits that the prosecution has not brought forward any evidence that gives reason for this trial to continue. Based on the merits of exactly what has been presented so far by the prosecution, this case should be dismissed. They tried to make it look as if the actions of others are all the responsibility of David Eastman or anybody else that may have been a part of the Oath Keepers. All 38,000 of them are going to be responsible for the actions of less than 0.0015% of the organization who committed the actual offense. And so this is where this stands at right at the moment. The judge and them should be appearing here in the courtroom here anytime now. And as soon as they do, I guarantee I will swap over the screen and make sure they are on there so we don't miss a single second of all of this. I have taken the time out of my busy schedule for the last few days, or as long as this trial is going to last, to make sure that I live stream every second of it to all of you. And that is what I'm doing. They called and said that the courthouse in Palmer was closed today. That's why this is all being done virtually. It has been a very rocky start to getting things going here today. David Eastman was the first one on the witness stand, as he ended it that way last night. The prosecution got to do their cross-examination of him, and Miller got to do his, and it was interesting, and I think Miller just did his as in closing it out, as we'll reserve the right to bring them back later. And then he gave his reasonings why this case should be dismissed. The prosecutors brought forward all of their opinions, theories, assumptions, and guilt by association just for being a card-carrying member as their reasons why this should be brought forward and continue on. And that's what we're currently waiting for the judge right now to come back and give his verdict of which direction this case is going to go next. I'm not sure if they have another witness available for today. The person that was supposed to testify today in the beginning of the defense's case was scheduled between 1 and 2 o'clock today and is only able to appear or be present for this case. Very short windows. I'm making assumptions here, but I believe this person has been incarcerated for the involvement directly within the January 6th that happened, and this is why there's only a small window that they're available. But from my understanding, they've made them available tomorrow if this case does move forward. If not, we're here in that wait and see. And we're kind of in that wait and see specifically because the prosecution brought forward a whole bunch of exhibits and evidence that they want to have put into this case, and they want to make sure that this information is there for everybody to look at and see, and they want this as their surprise stuff that was not given during the disclosure that they're supposed to do at the beginning of the trial. Before it even happens, all of this evidence should have already been presented so that they had plenty of time to review it all. So David Eastman's attorney Miller is currently working his butt off going through all of those documents that they submitted as evidence that they want to bring into the defense against the defense that may or may not be happening here real shortly. And I believe they were supposed to start at 2 o'clock, and I'm patiently waiting here, but I'm not seeing any action on their end on the screen saying that that they're clicking over and getting that going. So we'll patiently sit here and wait. If it goes too long, I may end up having to just go back to their They are waiting to come back. Please stand by screen and give you we'll wait and see sign there. But at the moment, we're just currently waiting for the judge to come back into the room and decide whether or not this trial is going to move forward or if it's going to be dismissed. And it is really debatable. Hopefully you guys have all finished your Christmas shopping and got that all done. You are ready for that merry day. It is literally less than 2 weeks away. I'm so excited. I get to see Santa Claus. He gets to come to my house. He has not missed a day in 18 years. I don't expect it to happen again. And this year he's going to be here. I've been a good boy. I deserve something. Yes. So I'm ready for the holidays. I don't know about you. I'm excited. Plow truck came in today and they did a phenomenal job. They've plowed out my yard. A lot less expensive than I was expecting, considering how much snow they had to move around in my yard. The previous plow truck that got me out made it so that I could actually live stream the one day that I was able to make it into the courthouse, and that day, and they did nothing more than a swatch through my yard. We're talking a 1/4 acre driveway, so I got a pretty good area there that needs to be cleaned out every year. And they just left us in 60-point turn to do a turnaround to get facing the opposite direction. That's how much space they left me in my backup areas. This plow truck driver, I can now go out there and just do figure eights if I wanted to all day long again. It's nice to be able to have an open up yard, so that's a very good positive. Waking up this morning at 6 a.m. and watch the Michael Duke show. If you didn't get a chance, please watch the Michael Duke show from today. It is hour 2 that I want you to pay attention to. In hour 2, they did a good breakdown on the Alaska school districts and the budgets and financing and how all that is calculated and how much money certain students based upon their disabilities, how much money they are applied towards them. We're talking, upwards of $72,000 a student, and a good chunk of Anchorage was the primary focus of everything that was going on there. I know if you were to look at places like, I want to say Barrow, Kavatovic, I think is what they renamed themselves to. I'm trying to remember who dragged my memory. I wasn't quite in that direction, but I looked at their budget pre to the pandemic, and they were already getting $28,000 when I broke down their budget there. $28,000 per student is what that Kavatovic was receiving in their school district there. And it's just absolutely amazing how much money is distributed and how the funds from our state budgets is actually divided between the schools, the haves and the have-nots, and why do they get so much money. A lot of that has to do with the special needs that are there in the classrooms themselves. There's a lot of people that need a full-time care provider with them while they are in the classroom, and they are allocated for each one of those types of students. Not trying to generalize here, but every one of those students gets approximately $72,000 in funding provided to the school for that student. Kavatovic is one of those, or Kowalke is one of those places out there that has a high percentage of that. That is one of the reasons why their budget is so high compared to everywhere else within the state when you compare school budgets. So the trial, I'm still waiting. Maybe it's supposed to restart at 2:30 and not 2 o'clock. I heard the wrong thing, and it's a good possibility that's the case because they're still not on screen yet. The defense was supposed to begin their case at 1 o'clock today due to a lot of Zoom technical difficulties, bandwidth, and everything else. The case got off to a rocky start today. Took them a little over an hour, about an hour and a half, to finally clear all of that up to where they could actually see and hear each person without sounding like a robot in the background. And it just really goes to show you where our technology is at today, that unless you got good bandwidth, high-speed internet connections, you can't perform anything functionally on, say, Zoom. It just doesn't work. It crashes. You listen to robot voices. The screen freezes and nothing moves at all. We all deal with that on a regular basis. Imagine what our kids have been going through the last couple of years with their virtual learning and having to do it all through Zoom on your own household internet, which is usually not set up for high speed traffic. And unlike here in my studio here that I got set up in my house, I have a high-speed connection. I am on the biggest bandwidth that you can possibly ever get, and it's been supporters like you that made that possible to have happen. Without your support, I probably wouldn't be able to afford any of it. And everything you guys do help send my direction, goes right back into expanding everything that I do around here. Upgraded tripods, video camera equipment, laptops that are capable of doing this, the software that runs it all, the websites. It's all your support that makes that happen. Covers the gas money to get to and from the different events. Just like making it to the courthouse yesterday. It's an hour drive from where I live to get there. It's 20 minutes shorter than what it takes me to get to Anchorage. And so you really get a concept out there that it takes a lot of time, it takes a lot of money to be able to do what I'm currently doing right now, and your support makes that possible, so thank you. Every little bit helps. Our website will be back up and running hopefully by tomorrow. I'm crossing my fingers, literally crossing my fingers right now that it will be back up and running again tomorrow. We had to transfer web hosts. It was supposed to be a seamless transition to the new web host, and the old web host is dragging their heels on releasing the site itself and the domain over control over to the new web host. I own it. It's mine. Do it. Darn it. I'm getting really frustrated with that. I would like to have something other than "Do you like philosophy?" splash page sitting there for my website. I really want to see the entire site back up and running. I've done a lot of work to streamline that thing and improve it here over the last few weeks. And I really love highlighting it now compared to the way it was because I'm proud of it. And your support makes that possible. Just like the Restream services that you're currently watching this video on right now. This, thanks to the being able to use them, this is now seeable on Twitter, YouTube, Facebook, at Politadick and Politadick Unfiltered. This will hopefully here one day be live streaming directly to Rumble. And your support and your subscription there can help that happen. All you got to do is become a person that subscribes to Politadick on Rumble. Subscribe to me. As soon as I reach 100 subscribers, I can live stream directly to them, and that is one less place that I can be censored from. YouTube already has censored a couple of my videos over the years, and here the most recently 3 in the past month and a half, especially during the election cycle, claiming election misinformation on every single one of those 3. Only one of them I lost on, and that was when Rachel Allen and Scott Clayton was giving their take on the elections during the general part this year and how ranked choice was playing in their election. And YouTube came back and says there's election misinformation from the 2016-2020 election in there, and we're banning the video. And I pointed out, said, point to me where in this video that I have gone against your guidelines, and they claim it was the entire video. At least that's what I believe they claim, because they wouldn't point exactly where, any section, what minute within that video that we violated their community policies. This is the censorship that's going on. YouTube is the only one that I'm finding out there right now that is sending a consistent notification when people go live. Governor Dunleavy's proposed budget that he just was talking about, and may still be on stage, but I think he's over with. I had to do a lot of work while he was talking, so I didn't get a chance. But I did share it on our page here at Politadick, and it was the YouTube feed. I could not find one for the Alaska News Source when it was coming on. I went to KTOO and checked them. I didn't find anything there, but YouTube had sent me a notification that the governor was going live. And so I was able to share that at least to all of you so you can hear what the governor's proposed budget for the 2023-2024 budget season is supposed to look like. From what I've heard through the rumor mill, in other words, of media out there, that he was going to be proposing a budget that was going to promote increasing the revenue that is coming in, code word, we're going to spend government money, our Alaskans, taxpayers' money, our money, on the special interest to help increase their profitability so that the government can take more on the other end. Meanwhile, the rest of us that are not on the government dole, we don't belong to the special interest, are given the shaft and told to pay for it by coughing up more of our PFDs. So I'm assuming, going by the time that they said 2:30 and not 2 o'clock, which would be my fault, so that means I get to sit here and talk a lot longer than I was ever planning on doing that. If there's anything you would like me to cover, please throw it into the comments right now. I'm going by the time I say I got about 15 minutes to kill. I could recash of what would happen for the case, for where we stand at with David Eastman and Kowalke and the prosecutors' witnesses, their special witnesses that they had. All of those folks that came through. Oh, why not? I'm not seeing anything showing up in the messages out there. I know I got to be patient when I say something like this on my end, because it takes a little bit for my stream to reach you, and then you got to type something and send it back, and kind of that hurry up and wait. For those that asked for the time clock to be put in the corner, I thank you for the suggestion. It is up there on the corner. We added the time clock and the date so that we could keep track of when there was important testimony given, or when something was said, or a response that was there during this entire trial. We have a timestamp to make it easier to locate on the video for all of you. I wish I would have thought of it myself when this all started. It wasn't until the second day that I made, or the third day, or the second, no, it was the second day of witnesses taking the stand, that I put the stamp on there. The first day of witnesses I did not, but I appreciate the suggestions. Anything that you guys may want to see done differently, don't hesitate, let me know. Message me, call me. It's not like I don't exist. My phone number is right there on the top of this feed. I would say email me right now, but until my web hosting gets resolved, my email address has also been disabled. Those kind of little things to move away from a provider that has provided you a website that would literally go get yourself a cup of coffee. If you smoke, go have a cigarette, come back. It might be loaded up by now. I'm moving it over to a provider that you better not blink, because hopefully the website should be sitting directly in front of you after that. So that's the type of service that I'm hopefully moving into at the moment. We are also working to get ourselves on NorthTube. If you've never heard of NorthTube, NorthTube is another video platform out there. It is an Alaskan-based video company, and it is becoming an alternative stream for Alaskans. I am working on the last 4 streams, for some reason, has not been connecting for live streams there. And so I ended up disabling it for this broadcast, just because looking at that saying it's not connecting, and I'm not sure if it was causing me any connection issues anywhere else, but I wanted to make sure we had a nice clean stream for everything that is going on. Let's see, it's 1:15. Let me see, is there anybody here left anything that you want to talk about? Nope, I still don't see any new messages here on Facebook. So other than that, things are going pretty well, as in for normal general life for me, but in the political life, oh man, it is the most horrible, disastrous, unfathomable life you could ever believe. I can't believe the direction our government has gone, our states have gone, our Union of the United States has gone. It is going down the toilet rapidly. Here in Alaska, we now have a Senate that is made up of a binding caucus that are more than willing to sell out our voices and votes. Oh, I see action on the screen there. So it looks like they may be getting the trial restarted here in just a little bit. Cross my fingers. And they will, you may be able to hear something. I don't have the volume on for that here, but they may be saying something at this moment. But I see the screen splashing over. So while they're doing that, I'm going to do the next best thing and go ahead and swap this right on over so you guys can watch right along with me. Make sure to like and share. We'll see you guys all here in just a little bit.
talk to them so that you don't have that feedback issue. Little. There it goes.
All right, we're back on record. It's a little after 2:15. We have Mr. Dedukian here, present. We have Ms. Harrison here. I can see Mr. Miller, but let's make sure we get you, sir, also connected by phone if that's what you need.
I am connected by phone, Judge. Can you hear me?
Yes, I can hear you.
Thank you.
The video is a little broken up, though. I want to make sure. Are you hearing me okay?
I hear you great. Thank you.
Okay. All right. So when we broke, I had taken the Rule 50 motion as well as then the evidentiary rulings under advisement. At this point, I'll address the evidentiary rulings first, then move on to the motion for a directed verdict made by the defendant. So first, there was a request that I take judicial notice of statements in the indictments that was made by the plaintiff. Rule 201B, which governs that, it states that a judicially noticed fact must be one not subject to reasonable dispute, in that it is either generally known within the state or capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Here, I already took judicial notice of the fact of the convictions and the language of the charges in the indictment, which is really what is being asked for me to take judicial notice of. I do find I'll take judicial notice of that. It's certainly not information that's subject to reasonable dispute and can capably and readily be determined by resort to sources whose accuracy cannot be reasonably questioned. They're in federal court files accessible by online database. Both parties have submitted versions of the documents. There's the language of the actual charge itself is sufficient or subject to judicial notice. So I'll take judicial notice of those. Regarding the statements of offense that were submitted for the various, to correspond to the various indictments, Rule 804B3 is a hearsay exception for when a declarant is unavailable for statements against penal interest. Here, I will find that the declarants are unavailable because they're not subject to process within the state. The rule states that a statement which was at the time of its making so far contrary to the declarant's pecuniary or proprietary interest, or so far tended to subject the declarant to civil or criminal liability, or to render invalid a claim by the declarant against another, that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. A statement tending to expose the declarant to criminal liability and offered to exculpate the accused is not admissible under corroborating circumstances, unless corroborating circumstances clearly indicate the trustworthiness of the statement. Here, there are statements within these statements of offense that are clearly against the declarant's own criminal liability, and I will make clear my findings, which portions of those I rely upon them, but I do find that they are statements against penal interest. I'm not admitting the entire statement of the offense. There's significant portions of that that are not at all related to essentially what are the confession of the defendants in those cases. They're just statements about process or other unrelated things, and or statements not related to the own person's knowledge or their own personal criminal liability. And so, but I will, for the purpose of this, under this hearsay exception, find that portions of it that directly relate to the person making the statement of offense that are contrary to their penal interest are admissible. The contrary case law that was cited generally does focus on criminal cases. Those criminal cases all focus essentially on that third sentence of the rule, which is essentially identical to the federal rule, that tend to focus on the statements that would expose the declarant to criminal liability that are being offered to exculpate the accused. That's not the situation here. This isn't a criminal case where the Sixth Amendment right to confrontation is implicated, or where that third section, which is generally what was being discussed in those cases, is implicated. And so portions of those statements of offense will be admitted for the truth of the matter asserted. I will make that clear to the extent that I rely on any of them and ultimate findings at the end of the case or in later portions, what those specifically are. As far as the motion for a directed verdict, under the standard and Alaska case law, when there is a motion made under this rule, a judge must view the evidence in the light most favorable to the non-moving party and may grant the motion only if fair-minded jurors in the exercise of a reasonable judgment could reach but one conclusion on the issue in controversy. That's language from Bowmaster versus Crandall, an Alaska Supreme Court opinion. Here, as I've previously written in rulings and as discussed by the parties, there's essentially two elements that I was looking for, or that the plaintiff must prove. First is that Representative Easton is a member of the Oath Keepers. Here, that's clearly been met. He talked about it both yesterday and today about being a current member, and so that item is not significantly in dispute among the parties. The second element is where really the dispute is. As I've written, the plaintiff must show that the Oath Keepers are an organization that advocates concrete, imminent action to overthrow the government of the United States by force, or that they have actually engaged in such conduct, because that would then be a form of advocacy and show that is truly what they advocate for. Here, keeping in mind the evidential rulings that I've made, as well as then the standard, the convictions and the statements by those convicted of actual action, they're convictions for crimes that involve force against the United States. The statements of those convicted and those statements against penal interest do show actual action being used, including force on January 6th directed at government, both law enforcement officers, as well as in furtherance of the goal to, there's a clear inference that can be made under the standard of this motion that it was directed at stopping congressional action to certify a presidential election. And that can be fairly viewed as an attempt to stop the peaceful transfer of power and bring about the overthrow of our democratic system and a government. These actions, including those by the founder and lifetime board member, Mr. Rhodes, as well as other leadership members within the organization, can fairly be found under the standard, again, for this type of motion to be attributed to the organization as a whole. That is both given the special position of those members within the organization, and that's supported also by the testimony of the two experts presented by the plaintiff, that organizations such as this one, and as specifically stated by Mr. Kreiner, often have a large member base that provides sort of the financial backing, but that there is and are otherwise relatively uninvolved in actual action. But could be a core group, such as the one at issue in this case, who engage in specific conduct, and in this case, as I've said earlier, under the standard for this motion, engaged in what could be viewed as force directed against the United States government to stop the peaceful transfer of power. So, viewing the evidence in the light most favorable here to the non-moving party, there is sufficient evidence for a fair-minded juror to find that that element was met. So I'm denying the motion for a directed verdict at this time. With that, Mr. Miller, I understood your motion to be essentially, you had styled it also as essentially your opening statement moving into the defense case. I also recognize I kind of rushed you towards the end of it, and so I want to make sure that you told me you reserved the opening. If there's additional comments you want to make before you do move on to your case, if there's time and it works in with the witnesses, we could do that. Or if you'd like to move in, if your witnesses are available, we can do that as well.
No, we should just move into the testimony at this point.
Okay. Is your next witness available, or your first witness? Sorry, available?
Should be in the waiting room, hopefully.
John
Guandolo.
I did hear from Madam Clerk. It sounded like we had someone there. Mr. Guandolo, can you hear us?
Yes, sir.
All right, good afternoon. Where are you joining us from?
Dallas, Texas, Your Honor.
All right, so as you can see, we've got a number of folks here in the Zoom. I'm Judge McKenna. I'm at a courtroom in Anchorage. We have various other people spread around Alaska. Are you in a position where we can have a conversation and you're not going to be interrupted?
Yes, sir.
All right, can you please raise your right hand?
Yes, sir.
You swear or affirm that the statements you are about to provide are the truth, the whole truth, and nothing but the truth?
I do.
All right, you can go ahead and put your hand down. Can you please tell us both your first and last name and spell both for the record, please?
Yes, sir. John Guandolo, JOHN GUANDOLO.
All right, thank you, sir. So the parties here are represented by Mr. Miller represents Representative Eastman, and Mr. Dedukian represents the plaintiff, Randall Kowalke. Mr. Miller is now going to have some questions for you. So, Mr. Miller, you may proceed.
Sir.
Mr. Guandolo, what were you retained to do on this case?
I was retained to evaluate the organization Oath Keepers as to whether they are an organization that seeks to overthrow the U.S. government and the government of the state of Alaska by force or violence, as well as to respond to the witnesses for the plaintiff.
Before we get into your opinion, I'd like you to first tell the court a little bit about your background and experience. Why don't we start with your education?
Yes, sir. So I'm a graduate of the United States Naval Academy, graduated in 1989. Served as a commissioned officer in the United States Marine Corps in the infantry and combat and in 2nd Marines, as well as a special operations unit, 2nd Force Reconnaissance Company. Resigned my commission in 1996 and joined the Federal Bureau of Investigation as a special agent, where I served for over 12 years, just under 13 years, both in the criminal division and the counterterrorism division, among other work, and was recruited out of the FBI in 2008 by the Department of Defense to do strategic analysis on a number of threats to the United States. And in 2012, I formed my company, Understanding the Threat. St. George's Allies is the parent company, to continue the work that I was doing in the FBI and the Department of Defense.
So when you were in the FBI, did you engage in any type of activities, or were you involved in any type of programs that allowed you to evaluate domestic threats?
Yes, sir. So as a criminal agent, I served in several capacities, but served on a narcotics unit. So as a part of that unit, we identified threats from both domestic and international narco trafficking organizations and worked with a number of federal agencies and domestic law enforcement agencies, and came to learn and actually investigate organizations that worked both with cartels and terrorist organizations and others, investigated the financing channels, et cetera. And we did investigations, like I said, overseas and domestically. I served for a little under 2 years as the FBI's liaison to the U.S. Capitol Police, investigating threats to the president, vice president, members of Congress, the cabinet, Supreme Court justices, and others. And in that capacity, also evaluated both individuals and organizations that were threatening government officials. And so that comes with a kind of a wide breadth of experience, both investigatively and the decision-making on whether something is or is not a threat. Shortly after 9/11, was transferred over to the counterterrorism division and worked on several units doing that. And as a course of my investigative work, was developed an understanding of a large jihadi network here in the United States and how they worked not only with other organizations and foreign powers, but also with other domestic threats, such as the communist movement here in the United States, both at the local, state, national, and international level, and other threats that relate to that. And I actually created the first training in the U.S. government in August of 2006 on those matters. The first large-scale training, that was a 2-week program. Prior to that, I'd run, half-day and day-long, day-and-a-half-long training for agents and analysts, task force officers, and others around the country on those matters inside the FBI. When I was recruited out of the FBI in 2008, the end of 2008, December, the work I did inside the Department of Defense was had multiple angles, but primarily they had myself, and they paired me up with one other individual who had come out of the Pentagon, and he was on the Joint Staff, branched intelligence officer in the Army Reserves, who had previously been working for the Joint Staff under General Pace. And our work was primarily briefing senior government officials, both in the executive branch, the legislative branch, and other senior intelligence officials on the threats as they were manifesting both here domestically and overseas, and providing recommendations and solutions for those and continuing to train individuals, both military, National Guard, law enforcement, and others.
Did you receive any awards for your work while you're at the FBI?
I did, sir. So for the work I did on the criminal side, I was given a couple, two specifically, U.S. Attorney's Awards. And after I created that program in 2006, the following year, two U.S. Senators, John Kyle and Joe Lieberman, gave me the Defender of the Homeland Award as a result of that program.
And so now you're working with understanding the threat. Do you do training across the country that's related to your work with that organization?
Yes, sir, I do. My organization does training and briefings and consultations still with since we've been doing it 2012 with leaders at the national level, state leaders, whether they be law enforcement or state homeland security. I've worked with governors and states attorney generals. We work with state legislatures, individual legislators, but in a number of states have briefed the leadership of legislatures. I've appeared before Homeland Security committees in places like Oklahoma, Kansas. And we continue to train law enforcement, citizens, local leaders, state leaders, and others on the threats as they're manifesting in the local community.
So in addition to your education and experience that you just testified, what have you done in preparation for offering an opinion to this court on the issue of the Oath Keepers and whether or not they're an organization which advocates the overthrow of the government of the United States or of the state by force or violence?
Yes, sir. Well, I've read a number of documents. So I've gone through the reports, the depositions, and I've heard a large portion of the testimony by the plaintiffs' witnesses, and have tried to watch as much of this proceeding as I've been physically able to. I have gone through many, maybe not as many as 100, but dozens and dozens of articles, videos having to do with the Oath Keepers and the events in which they've participated and their activities. I've certainly read their bylaws. I've listened to or read the transcripts of numerous interviews that Oath Keepers have given, including their leadership. I've looked at articles as it relates specifically to January 6th, since that has been a significant part of these proceedings. I've actually, through the course of my normal work, I've spoken with, over the years, hundreds of members of Oath Keepers through just being in contact with them at events that I've either spoken at or Patriot events that I've attended for one reason or another. I've interviewed the leader this week of Oath Keepers, Stuart Rhodes. I have looked at, as I said, a number of videos that relate to the topics we're talking about. I've obviously reviewed the Alaska Constitution as it relates to the charges here in Article 12.
And were you present in Washington, D.C. on January 6th?
Yes, sir, I was. I was in a limited space with a group there right out in front of the Capitol.
Okay. So what I'd like you to do is let's first talk a little bit about the experts that have testified in this case. Mr. Kreiner and Mr. Lewis, did you have an opportunity to listen to their testimony that was given in the case before the court?
Yes, sir. I listened to a significant amount of both of their testimonies. And as I mentioned, I did review their depositions in total and did read their reports that they submitted in this case.
Have you had an opportunity to evaluate the expert witnesses, plaintiff's expert witnesses identifying threats using the terms violent extremism?
Yes, I would say that's for me, and I believe from a threat perspective, the fact that they use the phrase violent extremism, it was to me right out of the gate an indicator that their analysis was going to be problematic. For a number of reasons, and I'd like to, if I could, just quickly take it in order. First of all, since 9/11, the domestic violent extremism, countering violent extremism are terms that came into the U.S. government's lexicon from overseas, from Britain. And those are terms that were brought into the British government and the British security services from European Muslim Brotherhood organizations, Muslim Brotherhood being a jihadi organization that is arguably, and we can go in as deep as you want, but is certainly the root for the modern terrorist movement in the Sunni Islamic world. And the Muslim Council of Britain, the Muslim Association of Britain, which are Muslim Brotherhood organizations, introduced that into the British government's lexicon. And it was an information operation designed to get the British government off their game of actually targeting appropriately real threats to the British government. In the several years after 9/11, in the mid-2000s, U.S. government officials from FBI and other agencies went to Britain and met with the Brits and had discussions with them and brought that back to the United States, where the U.S. government officially adopted the CVE, Countering Violent Extremism. And it has been an abysmal program. And actually, our adversaries, the U.S. Muslim Brotherhood, not only used it to keep the U.S. government from identifying Muslim Brotherhood organizations here in the United States as hostile, but then they turned it on the government, and the whole program is imploded, but the lexicon remains. So first of all, the phrase violent extremism has no legal impact, whereas words like enemy, which is the word used in the oath of office, protect against all enemies, foreign and domestic, and words like terrorism that are legally defined, there is no legal definition for violent extremism, which is exactly our adversary's intent. And as a matter of fact, I heard yesterday the phrase violent extremism defined by the plaintiff's witness as somebody who's willing to do violence in furtherance of achieving their goal. And what's problematic about that from a legal standpoint is that describes members of the U.S. military, that describes police officers, that describes U.S. citizens who are exercising their natural right to defend themselves, as well as their constitutional right to do so and their lawful right to do so. So the phrase right out of the gate, violent extremism, is problematic. And in my experience, especially in the last 15 to 17 years, when that phrase is used, it is either used by people who do not understand that, or they're intentionally using it to muddy the waters about true threats to the United States.
So in looking at the Oath Keepers itself and looking at their central tenets, have you formed an opinion as to what those central tenets of the Oath Keepers are?
Yes, sir. So if we just start with basic bylaws, and then if I reference again, many members of Oath Keepers that I've run across in my time, and then I reference direct discussions I've had with intelligence directors from state law enforcement agencies at the national level, as well as individuals that I've briefed and worked with who are in the intelligence community. And I look at all the information that I have gone through, by the way, including the plaintiff's witnesses, their own testimony and depositions and what they've testified to here in this trial, as well as speaking directly to Mr. Rhodes, I read Mr. Rhodes' testimony in full in his criminal trial. And if you put all that together, my assessment is you have an organization that is made up of people who do not, as the plaintiff witnesses have said, they're not anti-government and anti-authority. They are anti-tyranny and anti-leaders inside the government who are violating their oath of office. And they are expressing themselves in a way that they believe is constitutional and lawful in order to make those points as clear as possible. So their objective, again, by their bylaws and by the interactions I've had with them, the comments of their leader, is that they seek to ensure that the Constitution is adhered to by people inside the U.S. government who swear an oath and fidelity to that Constitution.
What is your perspective of plaintiff's expert witnesses referencing Ferguson, Missouri as a flashpoint of violence for the Oath Keepers? Do you find that problematic?
I do. And I want to say, from a perspective of how their analysis was conducted, just from a basic investigative and analytical perspective, what was, especially in their testimony, but we did see some of that in their depositions and in their reports. Number one, as an objective investigator, what I believe we are supposed to do is you look at all the facts on the table and you make an assessment based on all the facts. Both of the plaintiff's witnesses admitted that there were basic facts that they did not know. And I'll give a few examples from the testimony. When it comes to relying heavily, as Mr. Lewis mentioned, on the Anti-Defamation League and their articles for what went into the report, he was unaware of specific background information on ADL that reveals that is an organization whose credibility is significantly questioned by the fact that, for instance, they believe racism is defined only from the perspective of people of color and can't be directed at white people. And that was on the ADL website. But no understanding of that, no mention of that. That to me is unprofessional analysis, that you are citing a source and not at least taking into account that there's a bias there. So it doesn't mean you can't, it doesn't even mean you can't use their sources but to be ignorant of these basic things. The fact that when it comes to Ferguson, that they are ascribing, in their words, 1 to 2 dozen members of the Oath Keepers in Ferguson, Missouri, and that the violence that we saw there, and the phrase was used in the deposition, the flashpoint for violence by Oath Keepers in Ferguson. Yet there was no mention by either of these analysts that, in fact, we know that Liberation Road, a Chinese communist organization, their Organization for Black Struggle, led by Jamala Rogers, were the ones that organized those events, that there were hundreds of people involved in Ferguson. We know that this Chinese communist organization organized those events. And again, if we want to have a discussion about what the bigger impact was, that would be a professional discussion. But to have no knowledge and no understanding that was a significant component to what happened in Ferguson, and we now know this 8 years later, I just find that to be wholly unprofessional.
Do you know what the Oath Keepers were doing at Ferguson?
Yes, sir. They were, their primary mission in Ferguson was to guard a bakery.
And you're aware of the fact they were criticized by the police chief at St. Louis?
Yeah, St. Louis County. I'm aware of that.
And what's your take on that?
I can't speak for why he did it, but my take on it is he didn't understand the moving parts on the ground. I mean, he was focused on the Oath Keepers for whatever reason, and obviously was not aware that was a major Chinese communist operation going on in Ferguson, Missouri.
Are you aware of other humanitarian type relief that the Oath Keepers have done throughout the time since they became an organization in 2009, 2010?
Objection, Your Honor, that goes beyond the scope of the expert report.
Mr. Miller?
No, it's about the Oath Keepers and the organization. That's squarely within the expert report and squarely within his experience.
If he has personal knowledge of it, yes, he can testify to it.
Thank you, Your Honor. Yes, sir. It's one of the things when we talk about the plaintiff witnesses that again caused me some concern that their analysis was, I think, grossly incomplete. Is that the focus was on only specific negative acts and opining on those specific negative acts without any mention, and again, based on their own testimony, no apparent knowledge of the positives and the mission statement across the country at the numerous operations the Oath Keepers have undertaken since their founding. Specifically humanitarian operations that I'm aware of in Texas and Louisiana, doing disaster relief, where, for instance, in Houston, they were lauded for their work, both in media articles and online video posts. And I have even seen a photograph of the Houston mayor with a big smile on his face and his arm around the leader of Oath Keepers, Stuart Rhodes. And so these are, I think, again, just from a professional, investigative, and analytical standpoint, if you don't look at the goods and the bads and make an assessment based on that, but based on the testimony and the depositions and the reports, all the information that's on the table is the plaintiff witnesses were not even aware and didn't even appear to have searched for this kind of information, which again, to me, goes to an incomplete and unprofessional analysis.
And Your Honor,
do you believe plaintiff's experts?
Hold on, Mr. Miller. It sounds like Mr. Dukian has an objection.
Your Honor, under Rule 26A2, the expert has to disclose the basis for each opinion and all information considered. There was nothing in the report about humanitarian efforts. There was none of these sources that he just spoke to mentioned in his expert report. So this testimony is going beyond what was disclosed to us and should be precluded.
Mr. Miller?
Your Honor, again, I mean, much of this is rebuttal. That's the first point that I'd make. And second of all, in his report, he did talk about the hundreds of Oath Keepers that he's spoken to. The basis, and I guess we can lay a little more foundation for this, but unlike plaintiff's experts who never interviewed anybody associated with Oath Keepers, this expert has actually gone to the source. And that absolutely was disclosed to plaintiff's counsel.
For the purpose, it sounds like this is being offered to impeach the opinions offered by Mr. Kreiner and Mr. Lewis. For that purpose, I'll allow the line of questioning.
Do you have anything else to add to that, Mr. Guandolo, regarding the type of humanitarian relief or other good acts that Oath Keepers have told you they've done?
Just, you know, whether we're talking about the reasons, and I suspect we'll get into this more, but the reasons Oath Keepers were in Washington, D.C. on January 6, 2021 was primarily a security mission at two locations.
Right, and we'll get to that here in just a second. Let me just hold you on that for just a minute. So let's not speak directly to January 6th yet, because we're going to hit that here in a second. But were there other security missions outside of January 6th that you're aware of, based upon your discussion with Oath Keepers, that they were involved in?
Yes. I mean, they've done numerous things around the country. They've gone to college campuses to protect speakers who are trying to just exercise their right to free speech. They've gone, we just talked about Ferguson, Missouri, to protect a business. And they've done that kind of work around the country. And I'm aware of that not only from reviewing literally dozens and dozens of newspaper articles, online interviews with them, videos, as well as talking to not only people that I've just run into at these events that are Oath Keepers, but obviously also talking to Stuart Rhodes.
Are you an Oath Keeper?
I am not.
Okay, let's talk next about January 6th. Do you believe that plaintiffs' experts fairly described the events on January 6th for purposes of this proceeding before the court?
I do not. And so I would just reiterate without rehashing what I said about the phrase violent extremism. But I'll go towards the law that the plaintiff's witnesses were speaking about and the statement of facts. So there are a number of things with regards to January 6th. I was present, as I mentioned just a moment ago, in Washington, D.C. at the Capitol in a permitted spot. I was lawfully there on the Capitol grounds. Never went into the Capitol, but was a witness to all the events. And so first, I'll just say this: the atmosphere that the plaintiff's witnesses described about the Capitol on that day, I think, was grossly inaccurate. The atmosphere was a very peaceful atmosphere. It was, I would use the term jovial. I would say it was much more like a football tailgate party than it was some massive riot. And there were, I grew up in Washington, D.C. In the D.C. area. I had been at events on the Mall when the Capitol Police make estimations of the number of people in the crowd. And there was a massive crowd. And whether we put that at 500,000 or 1 million, I'm not an expert at guessing crowds, but I know that based on my experience of being at events on the Mall and knowing what the number was of those events as related by the Park Police and being at that event on January 6th, I would say that those numbers are certainly well within the ballpark. And yet people were incredibly kind to each other. It was a very mixed audience. And what I mean by that is, there were Latinos there were Asians, there were Blacks, there were whites, you name it. And it was people who were just there to show their love of country. And what I saw, people singing frequently, people saying the pledge frequently, very easy to talk to people. People actually were being amazingly attentive to not littering and stuff like that. I mean, it was pretty amazing to be there and just be a witness for that event. So I think the way the plaintiff witnesses described the whole event out of the gate was inaccurate. And I didn't hear any of them, either one, testify that they were actually present there, and I didn't see that in their depositions. I would also say this: they solely focused, with very little exception, on the Oath Keepers. And the fact that the Oath Keepers were a minuscule number, and by the way, the Oath Keepers, as it relates to broader national security threats to the United States, are not even on the radar. And what I mean by that is they do not pose in any way a threat to the national security of the United States, as was brought forth by these witnesses. But there was no mention. Matter of fact, they diminished the presence of Antifa and BLM operatives, both of which are communist organizations, BLM being founded by the largest Chinese communist organization in the United States, Freedom Road Socialist Organization, and later split into Liberation Road, and Antifa, which originated out of a Soviet communist group founded in Germany and then adopted by Communist Party USA 90 years ago here in the United States. So no mention of the presence of those organizations there. And I think that to me is disturbing, especially since I personally witnessed members of Antifa walking into the Capitol and into the front of the crowd and moving up the stairs into the Capitol. The other thing that I did hear testified to.
Hold on just a second, and then I'll let you continue. I mean, how did you know these were Antifa or BLM associated individuals?
So part of my job inside the FBI was, so I'll back up a little bit. In my time as an FBI agent, both as a criminal agent investigating, as a counterterrorism agent, as a SWAT agent, handling a wide variety of criminal violations. We had in Washington, D.C., I was assigned to the Washington, D.C. field office. We had a number of large-scale events in Washington, D.C., some peaceful, some violent, to include groups like Occupy Wall Street and others. And so part of what I've learned over the years is it's important to know how to identify how people dress, carry themselves, and operate, the modus operandi. And so, for instance, the black face masks, the all black dress, the backpacks walking by us are indicative of what we've seen across the country for years in these anti-American, anti-government, and in most cases, communist supported groups, even though the individual operators may or may not be actual communists. So that's the point I wanted to make on that, is when you see them going by, and that they're not operating on the friendly side. I will also say two other things. There was information brought forth about how the individuals got into the U.S. Capitol, and yet I witnessed on dozens of occasions individuals walking up the steps with American flags, Gadsden flags, all kinds of patriotic flags, stopping in the middle of the stairwell on the exterior of the Capitol, where there were Capitol Police, standing in front of the Capitol Police. You could see them conversing, and the Capitol Police pointing them up the steps, and those people walking up and going in the Capitol. You could see Capitol Police at the top of the steps, pointing people to the door and people walking in the door. And so none of that behavior was mentioned. And again, it just goes to the breadth of what was actually going on that day, and what has and hasn't been testified to here thus far.
While we're still on this subject, did you see any other indicators, you personally, while you're in D.C. on January 6th, of any type of other organized efforts to create disruptions?
Well, there were clearly individuals who were, for instance, an easy example that, again, was not mentioned by plaintiff's witnesses was John Earl Sullivan, who's a Black Lives Matter and infrequently Antifa, but BLM leader, who was actually filmed himself up on Capitol Hill inside the Capitol and during the event. And I've not only seen the videos, but the photographs of him, and that was going on as well. And again, these are just other indicators that there are other threats up there at the time that go way beyond the Oath Keepers that were there. And again, I'm just talking from a professional, analytical, and investigative standpoint. When you have well over 800 people to date that were arrested, and you have a small number of those people who identify as or are claiming membership in Oath Keepers, I think that's a point to be noted. And certainly I note it as an investigator and as an analyst.
Anything else about the events of January 6th, as described by plaintiffs' experts, that you believe the court should be aware as being inconsistent with your opinion, as well as what you observed?
Well, I'm gonna go back to the work I mentioned in my CV with regards to the work I did in the Department of Defense. So a significant part of the work that was asked of me, and one of the reasons I was brought out of the FBI into the Department of Defense was asymmetric warfare, information operations. And so there is a significant amount of activity around that event, January 6th, that raises serious questions of much more significant activity. And I'll give you just one significant example. When I returned to my hotel room in the evening on January 6, 2020, which was maybe a 10-minute walk from where we were on the Capitol grounds, I got to my hotel room and in less than 10 minutes, probably closer to 5 minutes having the TV on, there was a news report, and walking down the street was this group with about a 6 to 7 foot by 18-inch to 24-inch professionally made banner that said, "Stop the GOP coup." And in the bottom corner, it said "Right to Resist," which is a communist group. And so as an investigator and as an analyst, that raises the question, was that because that goes to a premeditated response, a propaganda response to an event that it is highly unlikely, although I suspect possible, that they cranked that huge professional banner out and got these people together in a very short amount of time, or that was a pre-made banner because this was at least in part, an information operation. That's an example.
Based upon your discussions with hundreds of oath keepers, as well as the work that you did and your review of the documents, the court documents, the articles that helped you prepare for your opinion, do you believe that the Oath Keepers is a significant threat to the United States?
I do not. I think through the evidence that as an organization, Oath Keepers and its general membership seeks to do what it says it does. I mean, you've got people who are current military law enforcement, retired law enforcement, combat veterans, people that have primarily sworn an oath to the Constitution. And in their words that I've heard, there is, they say, hey, there's no expiration date on my oath of office. And so they want to see leaders in America at all levels of government, especially the federal government, adhering to their oath of office, defending the founding principles articulated in the Declaration and reflected in our government through the Constitution. And the fidelity is to the Constitution. One of the things that I feel like is lost here, Counselor, is that all of the Oath Keepers that I've run into, and might be a half hour long conversation or a 5-minute conversation throughout my time, the years of meeting these people at these events. And they have, while they are people of a vastly diverse background, their opinion about the country is the same. They just want to see liberty protected, the rights of the individuals protected, our unalienable rights protected under the Constitution, and people that are tyrannical and who hold positions of authority should be challenged, and their fidelity to the Constitution, if they're not adhering to it, they should be challenged in lawful ways in order to maintain the dignity and the fidelity to the Constitution. I mean, the reality is that's what separates us from everyone else. We adhere to the Constitution. We don't obey a man. We don't obey somebody who's just your governor or your president because they say so. Our fidelity when we swear an oath is to that Constitution. And it separates us from people who just follow orders blindly so they don't get in trouble. And to me, that's the greatest distinction here. And I feel like it's being lost in this case.
So when you say it separates us from everyone else, who is us and who is everyone else?
Us as Americans, our law and our government, and every other form of government around the world. It's the singular thing that separates us. America was the first nation in the history of mankind that stepped away from the monarchy and created an entirely new form of government that never existed, that specifically took into account the rights that we have that are unalienable, that we are born with. And they created a federal government whose primary duty is to defend those unalienable rights. I mean, it's pretty amazing when you think about it. And in my experience, my research and my investigation, the membership of Oath Keepers writ large, which is in keeping with their bylaws, that's what they believe in.
Did you hear expert Kreiner, the witness Kreiner's statement near the end of his testimony when I asked him, why do people take an oath?
Yes.
And his response, does that concern you?
Oh, that greatly concerns me.
Okay. Why don't you explain to the court why?
It concerns me, Your Honor, because here is an issue, the very issue at stake is that we have a sitting representative that's been elected 4 times. And the question as to whether he is a member of an organization that seeks to violently or by force of violence overthrow the Constitution of the United States. And to not understand that the importance of swearing an oath to the Constitution instead of a loyalty oath to an individual or anything else is greatly significant because it is the foundation and basis for our entire system. I mean, it's the beauty of what we're doing here today. You know, we have one side, you know, trying to demonstrate through facts and evidence one thing, another side trying to do the same thing and leaving it in your hands. And you swore an oath. I swore an oath to testify truthfully. I swore an oath as a Naval Academy midshipman, as a Marine officer, and as an FBI agent, as do literally millions of people around the country and in our history have done that. And that's the beauty. We can certainly disagree, and we can even disagree, and people can disagree in ways that we don't like the way they disagree and the words they use and the actions they take. But us liking it or not liking it isn't the point. The point is the oath is absolutely critical because the oath, and when police officers and military people and elected officials and judges take these oaths, it literally is the foundation for our entire system because our fidelity is to the Constitution, first and foremost. The fact that a plaintiff witness wouldn't even know why we take an oath of office. And I'm not trying to make any other kind of statement other than it tells me it is either a grossly biased perspective that the witness is coming from, or they just don't know. And in either case, I think it's really unprofessional.
So with respect to the loyalty to the Constitution and speaking to, again, the hundreds of oath keepers you've spoken to over the years, have any of those oath keepers ever talked to you about their loyalty to Stewart Rhodes?
Not one. No, they're.
And what's your perspective of the general membership that you've talked to vis-a-vis Stewart Rhodes?
In all of my discussions, there are a couple things that I would say are true. The one is the primary focus of all the members that I've interacted with has been the importance of being to honor the oath of office to the Constitution and to ensure that our leaders do the same. That's it. They don't think of it in terms of Stewart Rhodes or any other leader of Oath Keepers. They see it as and even in the if you read the charging documents in the people who were charged with crimes, for instance, on January 6th, even the government identifies the Oath Keepers as an organization of loosely affiliated individuals. And my experience is that's exactly right. While they do have leaders and they have responsibilities, that is absolutely true. The general membership that I've met around the country has demonstrated that those two things I just mentioned, their own loyalty to the oath and feeling their duty as citizens to continue that and to hold our leaders accountable, to their oath of office. That's it, as a singular point.
I'm going to get to the interview with Stuart Rhodes here in just a little bit, but let me first move to, I guess, drill down a little bit more into what happened on January 6th. Based upon your experience, what you've reviewed in preparation for your opinion in this case, did you find any evidence that federal law enforcement found that there was any type of coordinated attack on the Capitol, or maybe a plot to overturn the presidential election results?
No, as a matter of fact, again, I'll just mention two quick things in answer to your question. In the charging documents, the phrase that was used multiple times was that those people that were charged, and even those that were convicted, sought to delay the process of certifying the election. But obviously they were not successful. And even Stuart Rhodes himself said in his testimony in his own trial that he understood that they weren't going to stop the certification. He knew that wasn't their point. So that's the first thing about that as it comes to January 6th. And there was also a Reuters reported, and I think this was an article dated August 20th, 2021, that was made a pretty big splash because they had 4 senior U.S. law enforcement officials who spoke under a condition of anonymity and they were directly involved in the investigations. And they said the phrase they used.
Your Honor, I'm going to object at this point because this article was not disclosed to us. He's going to be recounting hearsay that wasn't included in the expert report as a basis for his opinion. So it should be precluded under Rule 26 and as hearsay.
Mr. Miller?
Judge, I mean, there was numerous materials that were referred to by plaintiffs' experts that weren't disclosed, including this entire repository that was testified to, consisting of tens of thousands of documents. But my position on this, Judge, is this is a recent article. We certainly, I think that counsel's correct. If he wants to look at that, we can get that to him during a break, and then maybe I can just do a little more direct on that, just so that the plaintiff side is not disadvantaged in any way.
At the moment, let's move on from the article. If you do want to go into it, it at least needs to be shared with Mr. Dedukian, and then we can retake up the issue. But at the moment,
okay.
The objections.
Yeah, so, Ms. Guandolo, if we'll probably have a break here soon. Well, in fact, Your Honor, is it possible that we could, not sure how long we've been going, maybe a little bit over an hour. Is it possible that we could have a break now until the end of the, and I can get that article over to Mr. Dedukian? I probably have another hour with this particular witness.
And is he available tomorrow morning for continued cross-examination?
Yes, Your Honor.
Ms. Guandolo?
I could make myself available. Yes, sir.
I just want to get scheduling down. Anytime we get a chance to do it, it's helpful. So let's take our break now. I could use it, and frankly, we're going to go up until 4:30. It sounds like that might essentially close out your direct. So let's come back in 10 minutes. So we'll be back at 3:25, and then if you can share that information over with Mr. Dedukian, then we can finish out the day with testimony. All right, we stand in recess.
Right.
Hello, everybody out there that's watching right now. They will be back in about 10 minutes, as I'm sure you all just heard by the color of my glasses that you can see on the end of my face right now. Whoops, oh, did it again. Get that double echo. Forget to turn the phone down before I start this. Okay, we have heard the first witness for the defense, who has been on the stand now giving testimony, about who he is, what he does. From all the credentials that were laid out in the very beginning of this, he is more qualified as an expert witness than the last two expert witnesses that we heard brought forward by the prosecution. Very clear, different style of defense versus the prosecutor, and the direction that they're taking the evidence in this case. The prosecutor seems to be on the edge of his seat for all of this testimony. Quite a few times I've seen him fidget when it might just be just because he's uncomfortable, been sitting there all day long, or the bottom line is fact that he's just not liking what he's hearing, worried about what's going to be said next, and that's the whole key. Their whole prosecution's attack on this particular one all stands on the basis that you are guilty by association, and that is the big ugly monster in the room. To me, that's that sums up this entire case in its entirety, is you are guilty by association. So whoever you associate with, that you are guilty just because of that. They will be returning right now. They are passing on a article that was written by Reuters and making sure that the prosecutor has a copy of that before they continue on. They have about one more hour to go before they get back in again. And just so though, if you're just tuning in right now, it's going to restart again the trial at 3:25. So it's just about 5 minutes away. Take a moment, like, share. Make sure you're following us. Click that bell to be notified. Do all of those good things. If you're on YouTube, go subscribe to us on YouTube. The quicker we can get to 1,000 followers there, the faster I can monetize things. Get me one more step closer to be sitting in Juneau, waiting for them to come out of those committee meetings or off of their floor sessions, camera in hand, live already, asking them the hard questions our mainstream media refuses to do. Your support makes that all happen. Also, find us on Rumble. Go to rumble.com. Type in Politadick, Politadick, into that search bar. You will bring us right up. Become a subscriber to us there. Follow us there. And make sure you hit that notification bell. Rumble does a really good job of making sure you're notified when we go live. And once we reach 100 subscribers there, we will be able to live stream to them directly. And just like YouTube, who's doing a really good job of making sure the notifications go out, they will let you know that we have gone live by sending you a notification if you click that bell to get messaged. But if you're on Facebook, good luck. If you're not a part of you are the in crowd for who they think they want to have in that in crowd, you'll never see a notification ever show up on your phone or on your notifications anywhere that we have gone live. It won't be seen. They'll make sure of it. Those that do find me on a regular basis, is the first thing that shows up when they actually open up their Facebook browser during the day and take a look. They see me at the top of their feed that I am live. That is because you are an active person that continuously participates in my live feeds or come to my page on a regular basis. If you're someone that's only been here a few times or are just refinding me again after years of not seeing anything coming to you, this is the reason why they are doing their utmost to shadow ban us all. And it's very evident. Mike Shower was talking about it just the other day about how we'd start a live stream, we would have thousands of people reached and seen that video within an hour of that video playing, or while we're streaming, have 100 or so people watching at one time. Now we're lucky if we get 10, 20 people to watch a video at a time. That's how bad they have destroyed our reach. They are literally 3 minutes away right now from getting back up and started. Pop up my other little screen so that I can see where they are at in the courtroom, so they should be coming back here really soon. Current testimony being given by the defense and the John there, and I really want to say his last name, Gowandolo. I hope that's right. I'm sorry if I slaughtered it. But he's doing his, from what I consider, he has done the best job so far as a witness for either the prosecutor or the defense. It doesn't matter. Just as a credible witness, I would consider him that. The last two witnesses, the expert, excuse me, the expert witnesses that they had there for the prosecutors were opinion makers, theorists, and conspiracists that all worked for universities in one form or another, and or think tanks, and I have all given testimony for their narratives, not for actually being educated on the actual real live facts. I mean, their first person given testimony couldn't even tell you how many members were in the Oath Keepers, and when he was asked that question, and he had to be supplied with the answer by the defense. And it's amazing that these are supposed to be the experts on everything Oath Keepers, and that they can't answer the simplest questions. Or John Kreiner, Matt Kreiner, the second expert witness, when asked the question about patriotism and what it meant and what was his definition of a patriot and the disastrous job that he gave of that definition. I mean, it was disgusting, appalling that that is what they thought of it. I threw out a couple of suggestions for the guy. Go watch the movie The Patriot. Or how about William Wallace? You know, we'll just throw two different versions of different scenarios out there. Kind of ironic. I believe they're both the same lead actor in both of those. But they give you a really good idea of what it means to be a patriot, and something that person just does not understand, and which was one of the last questions asked there by the defense here. Miller asked him, comparing what the answer that was given by the previous two expert witnesses and his idea of the difference between what it was. And that's kind of where the Reuters article came into play right now. They should be starting up here any second now, going by the clock on the screen. I believe they said 25 after 10-minute break. So it should be popping up. As soon as I see them pop up on the screen here, I will definitely make sure that I get it swapped on over there. But if you got any questions, anything you'd like to have answered, just let me know. This case is just going exactly kind of how I expected it to at this point. I was really crossing my fingers the judge would see the light and dismiss this so that it could end and David Eastman can move on in his life. Unfortunately, the two stipulations the judge said that he put in place were met, and so the case continued, and that's where we're at right now. I see the screen there on their end starting to change. Let me make sure my other one here is already set up and ready to roll with that on screen. As soon as I see that meter bar bouncing on the screen saying they're actually talking, I'll shut up here. If you haven't shared and liked this video, do it right now. It's your chance. Like and share this video. The more places it gets shared, the more people that like it, the more people that continue to keep sharing it, the more Alaskans that are going to get to hear what is going on unfiltered and uncut, and not just that 30-second mainstream media spin that they like to give to all of us out there. And that they do. They love to give the spin of their narrative. You saw it yesterday. They focused on the short 15 minutes, supposedly half hour, almost 45 minutes later, first beginning of the questioning of David Eastman, and we're highlighting about how he admitted all of this stuff. Whoa, whoa, whoa. Not one iota word about all their expert testimony witnesses that were theories and their opinions and assumptions, and zero facts to actually back up what they were trying to say there. Oh, they're talking. I'm going to swap the screen over now and quiet up on my end.
All right, good afternoon. We're back on record. I see we have Mr. Dudukian back on the Zoom. I can see Mr. Guandolo present. Mr. Miller, can you hear us? Mr. Miller, are you able to hear us now?
Oh, I got you now. Perfect.
All right, you ready to proceed?
We are. And Judge, I sent the articles, I copied the court as well to opposing counsel.
All right, understood.
All right, so let's go back to that question first, Mr. Guandolo, relating to whether or not a coordinated attack on the Capitol has been found. You mentioned the Reuters article. Before we get to that, any other basis for your understanding that there was not a coordinated or attack on the Capitol or plot to overturn the presidential election on January 6th?
Yes, sir. So there are a number of things. I'll just mention maybe a few. Number one of the FBI's witnesses in this matter is the former vice president of Oath Keepers, Greg McWhorter, and he was an FBI asset that has been made public. He was going to testify in the trial, in these trials, these matters that we're discussing. And he would have been duty bound if there was a known organized effort to overthrow the U.S. government. He would have been, being a former FBI agent that handled numerous assets domestically and internationally, that asset would be duty bound to report that. And in my interview of Mr. Rhodes,
Objection, Your Honor. Objection. There was no interview with Mr. Rhodes noted anywhere in an expert report or disclosed to us before today.
All right, Mr. Miller?
Yeah, it just happened yesterday, Judge. I mean, it's been a very long and arduous process to try to get hold of him. And this is an accelerated trial, as we've mentioned numerous times before. So that's what happens in cases that are truncated as this one. We've made efforts and we were finally successful, and it just recently happened. So the disclosure's been made. If I suppose opposing counsel needs time, I'm not sure what good that would do because of the limited access to Mr. Rhodes, but certainly his experts had opportunity to interview people associated with Oath Keepers, and they declined to even interview one person. So I don't think that this is anyway. Judge, I'll let you make your ruling. I just, again, the time circumstances of this case have not allowed preparation in the ordinary course that you would expect. And so, the disclosure has been made. It was very recent, and I don't think there's any prejudice.
Well, when did the interview happen?
Well, maybe we should ask Mr. Guandolo that. My understanding is yesterday, maybe it was the day before. Mr. Guandolo, would you tell the court when you interviewed Mr. Rhodes?
Yes, sir. That would have been Tuesday.
And
okay, so 2 days ago, Judge.
Was any of this communicated to the plaintiff?
Well, I mean, just through court, Judge. I think I found out about it yesterday.
All right, and so are there any materials or notes that were made as part of that?
Judge, do you want to direct the questions to Mr. Guandolo, or do you want me to ask him? I'm not aware of any.
Mr. Guandolo, did you take any notes or create any materials from the interview?
I just took a few bullet points, Your Honor.
If I take the point that this is a accelerated schedule, but there are basic rules for if an expert's going to give an opinion based on information that they have, it should be disclosed, and it should have been made as soon as it happened. The plaintiff should know about it if there's planned testimony that's coming about. And so if you want to get into it, you need to share all the materials with the plaintiff. And I think he's entitled to at least some notice as to what the change in the opinion is, or if there's going to be any opinion. And then I don't know what, if any, inferences Mr. Guandolo is going to draw from it. But, maybe this is the kind of thing you could rely on under 703. But yeah, again, no one knows what he's relying on. It's not part of his report yet.
So Judge, if I may, there are a couple of responses to that. One, to say that it wasn't disclosed is not exactly accurate. He did disclose that he's interviewed hundreds of Oath Keepers. There was no inquiry no request by counsel for any identification. That's been part of the record for a long time. To suggest that there needed to be individual identities of each one, I mean, that kind of gets to this whole repository that plaintiffs experts relied on of tens of thousands of pages. I mean, well, I certainly didn't see every one of those pages.
The plaintiff didn't attempt to get into every one of those pages. But if you want to ask him specific questions about an interview that he had with someone on Tuesday that informs his opinion, that's like asking him about an article. That's like asking him about a textbook that he may have reviewed. Those are things that need to be disclosed to the other side. There's a specific person there. It's not just a generalized group. And so that information needs to be shared.
And Judge, and we absolutely will comply with the court's directive to provide those notes, and we can take a break and do that now, or I can do that at the end of the day. I would note, and this is my proper, obviously Mr. Guandolo will have to address the court, but it's my understanding that that interview does not change his opinion. It simply confirms his opinion.
That's correct, Your Honor.
Okay. So Mr. Deacon, I'll hear from you and then we can move on.
I mean, I don't need to say much. I don't think it makes a difference if it buttresses the opinion or changes it. If it's part of the opinion, part of the basis for his opinion, it should have been given to us.
Right.
And if Mr. Rhodes is going to testify tomorrow, he can speak for himself. We don't need to get his statements in through this witness.
So two rulings there. First, any materials that were relied upon, those do need to be shared. So that needs to be shared with the plaintiff. As far as the statements themselves, they're just like the other materials that came in under 703. Those are offered because those are the type of things that he's relying upon. But for the truth of the matter asserted, I'm not going to, unless there's some other hearsay exception. I heard essentially a hearsay objection from the plaintiff, and so that's how I'm taking it. So, and if it turns out that there needs to be more information relayed on this, Mr. Guandolo is going to be back tomorrow morning, so we can address it further then. So at the moment, you can ask the question, but the materials need to be shared, and then certainly it's open for cross-examination.
Very well, Judge, and we'll make sure that happens after we're done here today. Mr. Guandolo, can you give me the notes that you took during your interview with Mr. Rhodes on Tuesday?
Yes, sir. I will do that when we break.
Okay. All right. And so, again, continuing with that discussion, there was a discussion about Mr. McWhorter, who was who again within the Oath Keepers?
So Mr. Greg McWhorter was the vice president of Oath Keepers. And
I don't need you to go back into the fact that he's duty bound as an informant to disclose any plots to overthrow the government, but moving directly into the conversation now with Mr. Rhodes.
Right. So
Judge, I thought the ruling was that they would have to disclose the materials before asking about it. Did I misunderstand that?
He can ask about it now. You'll get the materials. If there's additional, whether you get it and he asks about it now, you're still going to have a chance to review them before cross-examination. So okay. Functionally speaking, I think we can keep moving forward, and then you'll have the materials for cross-examination. So please continue, Mr. Miller.
Yes, sir.
Go ahead, Mr. Guandolo.
Yes. So what Mr. Rhodes told me did confirm what was reported, which is that Mr. McWhorter, obviously had access to Mr. Rhodes, knew what Oath Keepers was doing and what they were up to, and of course he would have been duty bound to report something such as an organized effort to violently overthrow the government.
So, and this is something that calls upon you as not just an expert, but also as a person that participated, or not participated, but was present on January 6th. From looking at what happened at the Capitol and based upon what you reviewed in this particular case, what is your opinion about the Oath Keepers' role in the lawlessness that occurred at the Capitol on January 6th?
Yes, sir. So again, there were a large number of people that were arrested, over 800 as we know, that were arrested in in the events on January 6, 2021 at the U.S. Capitol in Washington, D.C. And relative to that, a small number of them were Oath Keepers. So whatever, 3% or something, just rough math, were Oath Keepers. And based on the testimony, based on of Mr. Rhodes during his own trial, and based on the information that he shared, which just confirmed that testimony, Mr. Rhodes was at his hotel when there's activity started at the Capitol, meaning things started happening, and he was informed and he went down there. And he made very clear comments in his testimony. He did not want his people in the Capitol. He actually used the phrase he thought it was stupid for Oath Keepers to be inside the Capitol. That wasn't their role. That wasn't why they were in town. And he made it very clear that the purpose of them being there was the security of those two areas that they were responsible for. And that was it. And yes, he was preparing for contingencies, but he did not, according to evidence that's on the table, he did not order people, nor did he expect people to do anything like what some of them did. He actually thought it was a mistake.
And with respect to the contingencies, what do you know about the weapons that were cast in Alexandria, Virginia?
Those weapons were there, again, according to Mr. Rhodes, because in the event that Mr. Trump invoked the Insurrection Act and gave the Oath Keepers authority to come perform some security functions as a militia, they would be ready. And I think again, if the Oath Keepers intended to violently overthrow the government, then they would have gone and gotten those weapons in mass under his orders, and they would have actually taken actions like I would expect insurrectionists and those who are plotting to overthrow the government violently to do. But they never did that. And again, this is just basic investigative analysis, looking at facts on the table. And that to me, that's a pretty big one. If you're actually intending to do something, you wouldn't leave a stash of weapons sitting in Alexandria, Virginia, minutes from the nation's capital.
Do you think that the fact that weapons were stashed in Alexandria, Virginia, had an impact on plaintiffs' experts' opinions regarding the tendencies of this group to want to overthrow government?
Your Honor, I'm going to object. If I'm understanding the question correctly, he's asking the witness to speculate what had an impact on our experts' opinions. Maybe I didn't understand it properly.
Mr. Miller?
Judge, I can withdraw and ask a related question.
All right, proceed.
So, Ms. Guandolo, what did you think about the emphasis of plaintiffs' experts on the importance of the Second Amendment to Oath Keepers?
Well, this opens up a couple interesting points. Number one is based on the depositions, reports, and testimonies of the expert witnesses. For the most part, and by their own admission, their perspective is academic, is research oriented, whereas mine comes from both an investigative and analytical side, an operational side. I'm a combat veteran. I was a SWAT team leader for the Washington field office of the FBI's SWAT team. I have traveled overseas in very hostile environments as an FBI agent to conduct investigations domestically. So it gives me a different perspective. And so I do believe in my professional opinion, that may or may not have tainted them. But what I am from my background, the idea that they would stash weapons lawfully in the hopes, meaning they did it lawfully in the I won't say hopes because that's not consistent with what they said, but in the eventuality that the Insurrection Act was invoked by Mr. Trump, then that's just contingency planning. That's the first part. The second part is, again, and I will go back to this, has a lot to do with the phrase violent extremism. That there is married to that, and I'm going to call it an information operation because that's what it is, violent extremism, because it doesn't legally actually define anything. And the way the plaintiff's witnesses defined it, it basically can be used against anybody that uses violence. And violence is neither good nor bad. So somebody who breaks into your home at 3 a.m. and unfortunately a homeowner is forced to choose to protect their family or to allow a bad guy to harm them and has to use violence to stop that attack, that is viewed in the eyes of the law as lawful. And that comports with natural law and it comports with our Constitution. As an example, violence was used in World War II to stop a very aggressive, and I would argue evil force in the world. So violence. So I think there's this idea that all violence is bad. So I do believe that the plaintiff's witnesses, based on their deposition, their report, and their testimony, that they have the view that all violence is bad, and therefore people that would actually stash weapons, therefore must be up to something nefarious. And I would say the same thing with the list that was commented on, where the Oath Keeper said these are things we will not obey, and then they basically bulletized statements that were nearly lifted right out of the Bill of Rights. And somehow, from the perspective of the plaintiff's witnesses, that somehow is conspiratorial. And I just, I really find that to me is a vulgar assault on liberty. And you may say, I don't like the way Mr. Rhodes goes about what he does. That has no bearing as an analyst or as an investigator on whether or not what they are doing is a part of their protected speech or exercising their unalienable rights under the Constitution.
So within the report and also part of the testimony given by plaintiff's expert, there was a characterization of the constitutional sheriff and peace officers associations as domestic violent extremists. Do you agree with that assessment?
Objection, relevance.
Impeachment, Judge.
There was no testimony about that yesterday.
Could you repeat the question for Mr. Miller? I want to make sure I fully understood the first part of it. It was a little bit garbled for me.
Right. So the question is whether the Constitutional Sheriffs and Peace Officers Association are domestic violence extremists. And I do believe, Judge, there's testimony about it, certainly within the report.
You can ask the question. So objection is overruled.
So I would.
Ms. Guandolo, do you recall the question?
I do recall the question, sir. And I would say this goes exactly to my point. If you use the definition that plaintiff witnesses used for violent extremists, then of course, anybody that's a constitutional sheriff or a member of the military or police officer that believes in upholding the unalienable rights and defending them would fall under that definition of violent extremists, which is why that is such a dangerous phrase to use, because the constitutional sheriffs are in fact not terrorists, domestic terrorists, but I'm using legal language. Domestic violent extremists is not legal language, and there's no statute on that, and there's no under the oath. Again, the word is enemies. The word used in legal language is either terrorists, material support for terrorism, and then the individual acts of unlawful violence are articulated, but domestic violent extremism, again, this is the danger of it. And giving the plaintiff witnesses the complete benefit of the doubt that they're just grossly ignorant, this is where it leads, is that you would identify sworn law enforcement officers who are sheriffs, and not as, constitutional sheriffs is a growing movement in the United States. So I find it highly problematic for those reasons.
And there was some concern expressed by the experts called by plaintiff regarding the right of an individual to interpret the Constitution for themselves. So my question is, do you believe that individual citizens who swear an oath to the Constitution have a duty to not follow orders if they believe that those orders are unconstitutional?
Absolutely. And I will go back to what I said earlier, Mr. Miller, is that the individual who, whether it's a Marine Corps private or a general officer or a senator, a congressman, or president of the United States, when you swear the oath, the fidelity is to the Constitution. And if you receive an order that you believe in your conscience, you believe violates that your oath of office, then you absolutely have a duty to refuse that order. And you might suffer in the near term punishment for it, but that's your duty as somebody who swears an oath. Absolutely.
Did you hear the experts for plaintiffs characterize the Oath Keepers as a militia group?
I did.
And do you agree with that characterization?
Well, again, I go back to, there's still the statute on the books for the unorganized militia of all males between the age of 17 and 45. So they could certainly be considered part of that. As I recall, in the testimony that was given, referring to them was meant to be a negative connotation, in that there's some freelance pseudo-military group that thinks they can do whatever they want. That was my professional take on their use of that term, which is not how the Oath Keepers views themselves.
Would you regard them to be a terrorist-like group as described by Mr. Kreiner?
Absolutely not. As I've testified before, but through the bylaws, through the individuals I know, the individuals that I have encountered over the years, the hundreds of Oath Keepers I've run into, be they police officers, retired military, current military. And again, my conversation with Mr. Rhodes just confirmed it, that these are individuals who simply want to, in themselves, continue their fidelity to the oath of office and ensure that American leaders do the same.
So did you hear Mr. Kreiner's testimony that the delay of the transfer or the certification of the vote for the presidency was, quote, tantamount to the overthrow of government, end quote? What is your opinion on that statement by Mr. Kreiner?
Right. So I would go back to something I started to touch on earlier in the charging documents for those people that were part of those people charged on for their actions on January 6th, 2021. Like I mentioned, there was some consistent language. Number one, none of the Title 18 charges that were brought against them were for violent overthrow of the government. And they were likening seditious conspiracy to violent overthrow of the government, that is a separate charge, number one. Number two, they were charged with things like obstructing official proceedings, tampering with documents, things like that. And if they did it and the evidence proves they did it, they should be charged and convicted. Some have been, but that's a far cry. And to your specific question, the phrase that I saw most often was that so-and-so intended to affect the government by stopping or delaying the congressional proceeding, which was to certify the election. That is a far cry from overthrowing the U.S. government by force of violence.
What is your sense of the expert opinion from plaintiffs that Stuart Rhodes ran the Oath Keepers in a hierarchical military sense? Do you agree with that assessment?
So, sir, as I mentioned earlier, there were clearly people that were responsible for certain duties in certain regions of the country. But my experience was it's certainly, there were not daily operations orders that went out. There were not monthly or even semi-annually. Like, here's what we're doing this, the next 6 months. It was normally, these are events we're supporting. If you can, go out and do it. So it was a volunteer organization. It was not structured as it in the way I took what was testified to by the plaintiff's witnesses. It was not a top-down absolute control organization. And as I mentioned, the individuals that I've spoken with over the years were in the organization to do those two things, to continue their own fidelity to the oath and to ensure our leaders do the same. So I do not believe that was a top-down controlled organization, and I have not seen evidence across the country of that to support that.
You heard the expert for plaintiffs characterize the political views of Oath Keepers, which I think they described as an aggregate, help persuade them as to their opinion regarding what Oath Keepers is. Do you recall what those various political views are that they described?
Yes, plaintiff's witnesses mentioned that, the Oath Keepers viewed themselves as the guardians of the Republic against tyranny and the guardians of the, quote, Second Amendment and phrases like that. And what I also found, and I'm going to go back to this because I really believe this is very important, is in a number of ways they would say, we're not saying that this one thing, like the emphasis on the right to keep and bear arms, that's fine. But when you collectively put it together with all these other things, all of which are protected activities under the Constitution, but when you put them all together and you get people together like this, well, then you have real trouble. And that is just to me, a vulgar assault on individual liberties. Again, not from a personal perspective, from a perspective both investigatively and analytically, looking at the real hostile movements. Because what the plaintiff witnesses, again, failed to even mention is there are massive movements inside the United States that are extremely hostile, very well organized, very well funded, with doctrine, operational strategies, and an incredible network, thousands of organizations that they don't even take into account when they're talking about threats to the actual republic, even though these movements specifically state their goal is to bring down the U.S. government. And I just think when you look at their assault on individual liberties and targeting individual liberties and saying, well, these things individually are not a problem, but when you put these together, they paint a picture. And yet they're ignoring these very easy to identify, much larger, like on a magnitude of 1,000 larger threats to the United States, but they don't seem to know about it or take them into account. And again, I go back, like, for example, they will talk about Ferguson and talk about the small handful of Oath Keepers, call that a flashpoint for violence, yet they have no knowledge that Chinese communist organizations were directly involved in the violence there in Ferguson and funded it.
So let's, before I turn to your report, I want to just talk about one other thing, given the fact that you were present on January 6th, and I've also had opportunity to review video related to that. You talked about the presence of Antifa and BLM, other actors. Did you see any other evidence of incitement apart from any activities of Oath Keepers?
Outside of Oath Keepers, is that what you're asking?
Correct.
Yes, sir.
Well, first, I mean, let's just eliminate the Oath Keepers first as a group. Do you see any evidence that the Oath Keepers incited what occurred on January 6th?
No, I didn't. I mean, I did not see, to my knowledge, anybody that was an Oath Keeper where I was and from my perspective. And I might, somebody might have been one, but I wasn't, didn't see them wearing a hat or the colors, and most of them will wear their T-shirts and their jackets and stuff. So no, I did not see anybody in that sense. Other than that, and outside of that, while I did not see it as while I was present at the Capitol on January 6th, and before and after, I did in my research come across
election relevance.
Mr. Miller?
Well, Judge, I mean, part of what has been presented by the plaintiffs' experts is this idea that the Oath Keepers were responsible for what happened in January 6th. And so we've had a broad presentation about all the bad things that happened on the 6th. And again, they're conflating that, if you will, with the Oath Keepers themselves. And so I think this does relate directly to that and acts as a degree of impeachment on the experts that plaintiff has presented their testimony regarding that intersect with the Oath Keepers.
Overruled on that. You can answer the question, Mr. Guandolo.
Yes, sir. Thank you, Your Honor. So the video and multiple videos that I saw with a gentleman named Ray Epps, who was clearly inciting violence. And this goes, again, I don't want to get too far afield, but this is important. This was one of those things I mentioned when I mentioned, the banner that said, "Stop the GOP coup," paid for by a local communist group, Right to Resist. You've got Ray Epps, who is clearly and openly inciting violence and people to go into the Capitol. And then we had a major publication, the New York Times, write a.
Mr. Guandolo, can you just pause for a second? Mr.
Yes,
Miller
sir.
looked like dropped on and off the Zoom. I just want to make sure he's still working.
I'm still here, audio, Judge. I have I think it's the Valley internet connection, but I'm connected to audio by phone, and so I'm fine.
Okay. As long as we can still hear you, are you fine if your video goes in and out, continuing with testimony?
I'm perfectly okay with that, Judge.
Mr. Dukian, it looks like you had a point to raise.
Yes, it sounded like the witness was going to bring up another undisclosed article about another item that wasn't covered in his report, so I would make the same objection I did before.
Mr. Guandolo, so you had reached the point where you were talking about an article in the New York Times in relation to Mr. Epps. Is that something that you reviewed as part of forming your opinion, or?
Yes, sir, it is. It's one of the many articles that was part of what I mentioned in my report that I, reviewed many, many articles. Yes, sir.
Mr. Miller, is there a copy of the article, or I know you were kind of popping in and out on the Zoom there, but do you understand what the objection is and have a response to Mr. Dukian?
I understand that, yeah. And so I would just ask Mr. Guandolo, is that one of the two articles that you've already provided to me to send on to opposing counsel, or is this another article that you're referring to?
I believe that's one of the two articles I sent you, sir. But if would you like me to check right now? I could look and make sure that's one of the two I sent you.
If you would, please.
Yes, sir.
And Judge, whether it's there or not, it's offered up for purposes of impeachment like much of the other testimony. And so we'll endeavor to get opposing counsel a copy as soon as we can if it wasn't provided with that last email.
Thank you.
Okay, that's a separate article, Your Honor. So I would have to send, and I can do that again at the next break, if that would be okay with you, sir.
Yeah, let's just make sure that at the end of the day, you get it to Mr. Miller and you can get it to Mr. Dedukian before tomorrow morning.
Okay. May I answer
Okay. And Judge, we'll do that.
question, or should
we'll do that. Hold on, Mr. Guandolo. Well, Judge, we'll do that after court along with the notes from his interview with Mr. Rhodes.
All right, understood. With that, you can continue with the answer to the question.
Okay, thank you, Your Honor. So I was just, the only thing I was, point I was going to make is here is an individual whose, that those videos were viral of Ray Epps openly calling for incitement of violence, yet he has never been charged. And then this major media outlet, New York Times, writes an article defending him. And that is consistent in my experience in these kinds of operations. Much like, as I mentioned, I'm likening it to immediately after the events of January 6th, on the evening of January 6th, people marching down the street and they're putting out a narrative that this was a GOP coup. And of course, it's a communist group that's putting out that. So those are different statements of fact that go towards informing my understanding based on my experience with information operations and information warfare. And so here you have an individual who we can see plainly is inciting violence, is never charged. And then there is a media outlet, a large national media outlet that then basically protects him and is calling for protection of his reputation. It raises, in my professional realm, that raises serious questions about the nature of his role on January 6th, who he actually is, and why there have not been real investigations into that. That's all.
And with respect to the opinions offered up by plaintiffs' experts and their testimony regarding not have seen any type videos of that nature, does that concern you based upon the review that they testified to in connection with their expert opinions?
Right. That again, like the other things I've mentioned, it leads me to believe that they were not looking for, or they just ignored this. But again, giving them the benefit of the doubt, they just were not actually looking for anything that was contrary to their the narrative that they stepped into this trial with. And that's why I said at the beginning, I mean, their perspective from just an objective, professional, analytical perspective, I think, is it incredibly, in my opinion, biased and unprofessional, because how do you not know who Ray Epps is if you're actually looking at the events surrounding January 6, 2021 in Washington, D.C. at the U.S. Capitol? He's one of the most notable figures. And to have no knowledge and to say I've never seen the video is, to me, it's astounding.
Let's turn next to your report itself. In your opinion, and this, Your Honor, if you want to follow along as Exhibit M, if you could describe for the court now your opinion regarding the core mission of Oath Keepers.
Yeah. So the primary mission of Oath Keepers is to promote the respect for the oath of office and the fidelity to the Constitution of American leaders, if I were to sum it up. And that's consistent with their bylaws and with all the other things that I mentioned earlier.
So is that core mission compatible with plaintiff's position that it's an organization which advocates by force or violence to overthrow the government?
Not at all. Those are diametrically opposed. The stated mission and the actual mission, as understood by the membership, and I would argue by the leadership as well, of Oath Keepers, is diametrically opposed to the way it's being described by plaintiffs' witnesses.
So you've heard the argument by plaintiffs' experts regarding conflating Stuart Rhodes with the organization, or basically casting blame on the organization because the actions, even of those that are not in leadership of the organization. Why, in your opinion, are they wrong with that approach?
Well, the Oath Keepers bylaws themselves say it. The organization and the bylaws and is known in the organization. They don't want people who are felons or going to be, if we go back to the testimony of Stuart Rhodes regarding in his own criminal trial, talking about the day of January 6th, saying he doesn't want, he didn't think anybody from Oath Keepers was in the Capitol because that would be stupid. Those are his words. It is directly contrary to what the plaintiff's witnesses are ascribing to the entirety of Oath Keepers. And I'm not, like, as I said previously, if individuals who are also members of Oath Keepers did things as they did on January 6, 2021, or at any other time that violated the law and got arrested for it, then they should be punished according to the law and either plead guilty or, get a trial. That's our system. But to conflate that to being the same as the entire organization wants to overthrow the U.S. government by violence that's absurd. And I think it's an unprofessional assessment.
So with respect to the verdict against Mr. Rhodes, and I mean, again, I think it's a matter of record that he has not yet, that the conviction has not been entered, that he has not been sentenced. What do you understand the impact of a felony conviction on a member to be within Oath Keepers?
They couldn't be a member of Oath Keepers if they're a felon.
Did you have a discussion with Stuart Rhodes about that on Tuesday?
I did.
And what's your understanding of his position?
I'm just going to object to hearsay to the extent it would ever be considered for the truth.
Mr. Miller?
Well, I mean, I think it informs his opinion and confirms his opinion. I don't think it changes his opinion. So I don't think the truth of the matter is necessarily important. I do think it has an impact on the listener. So maybe I could voir dire a little bit more with this witness regarding who he communicated that to.
When you say who he communicated that to, are you speaking about Mr. Rhodes?
Mr. Eastman.
What?
I'm confused then by the response.
I'll withdraw. I mean, Representative Eastman can testify when he's brought in on the case, so we'll avoid that at this point, and we'll just bring it through another witness. But our position is, I think that the testimony should be treated in the same manner that the testimony of the experts for plaintiff was treated with regard to hearsay.
And it will be. The objection was hearsay. I would say he could testify to the point that, what it was and then how it informed his opinion and informing his expert opinion. But as far as the substance of the statement, the statement by Mr. Rhodes can't be offered for the truth of the matter asserted unless there's some other hearsay exception for it.
Right. And respect that, Judge. I mean, the availability question is up in the air right now, but I guess that will develop as the case goes on. And I will represent to the court that we're trying to get him back, and hopefully that will happen tomorrow, but I can't give the court any assurances of that.
Understood.
So, Judge, if I may continue.
You may.
So, Ms. Guandolo, did your conversation with Mr. Rhodes confirm or alter, how did it impact your opinion that you're offering the court regarding the bylaws and rules of the organization?
It confirmed what I had, the conclusions that my research and analysis investigation I'd come to about this matter.
And his statement that confirmed that was what?
Well, there were a number of them, but I think the two that were most critical was the fact of the duties of oath keepers when they go to different areas or to deploy to different areas, including their duties and responsibilities on January 6, 2021. And the fact that Mr. Rhodes himself said, if I, end up being convicted and it stands, then I would have to step down. And I believe, based on not only that and the trial, but based on the fact that some of the senior leadership, specifically Mr. McWhorter, and he did say this because of his disloyalty, he would feel like he would kind of be done with oath keepers and step down.
And Your Honor, again, I'm going to object on hearsay grounds to the extent that statement is being offered for the truth.
And for the same reason that it's granted, unless Mr. Miller, is there another, is there another hearsay exception?
No, not at this time.
So granted to that extent.
Okay, so with respect to the solicitation membership by oath keepers, what is your understanding based upon your review of this organization? What is your opinion regarding who they solicit for membership?
They solicit individuals who have sworn oaths of office at some point, or so active duty, law enforcement, military, National Guard, local elected officials, state elected officials, national, federal elected officials, retired police, military, the like.
So are they trying to find people that are anti-authority or anti-government?
No. And again, I have not found that to be the case with oath keepers. They are not anti-government or anti-authority. They are anti-tyranny and anti-anything that infringes on the natural rights and constitutional rights of American citizens.
Do they pander or seek members that desire to overthrow the government?
No, the exact opposite. They want people who are going to protect and defend the Constitution.
So they're, again, getting back to the experts that plaintiff called regarding the viewpoints that those experts believe are consistent within oath keepers. You've interviewed, as you've already testified, hundreds of members of oath keepers. What have you come to know about any particular ideology or political philosophy that's held by the oath keeper members that you have had interaction with?
So based on my interaction with members of oath keepers throughout the years, as well as knowing their bylaws and seeing what they have put out about meaning the articles and interviews that I've watched, their perspective is as an American, it's, rugged individual.